I'm David Rudenstein. I'm the Dean of the School of Law, and it's always a great pleasure for me at moments like this to get up here and take 60 seconds of your time and welcome you to the school. Cardozo is 30 years old, and from my vantage point, we've covered more ground in 30 years than any other law school in North America that I'm aware of. And I look forward to the same kind of dynamic future that we've had in the past. And conferences like this are very important to us, both from an outside perspective, but more importantly from an inside perspective. It just gives us a real feeling of intellectual growth and development to have folks like you here to talk about important issues. And so welcome and thank you for coming. I want to thank Miriam Gillies for organizing today's conference. Miriam is one of the great strengths of the faculty. She is constantly active in pushing us intellectually into the sort of the cutting edge and finding the new frontier. And if you've ever organized a conference, you would have some idea as to how much work there is in bringing together an event like today. And so I want to just thank her very much for doing this. My last task is to introduce and invite Stephen Feynman up to the podium. Stephen is one of the main participants in today's conference and organizers, and he's at the law firm of Leaf, Cabraser, Hyman, and Bernstein. So please welcome Stephen Feynman.
Good morning, everybody. Thank you, Dean, very much. Thank you to Cardozo Law School. As Dean said, my name is Steve Feynman. I'm the managing partner at Leaf, Cabraser, Hyman, and Bernstein. Some of you know, does a little bit of class action work. I'm also involved with Public Justice and with American Constitution Society, the co-sponsors of today's event, along with Cardozo Law School. I want to thank Cardozo Law School and specifically Professor Gillies for organizing the conference. Thank you, Miriam. I wanted to also single out Praveen Fernandez, who's right here, who you're going to hear from a little bit, and Virginia Marinette, who's right behind the post there. Thank you. Who also helped was instrumental in planning today's conference. I want to thank Arthur Bryant from Public Justice, who could not be here today, unfortunately, and Lisa Brown, also, who's the executive director of ACS, who could not be here, but sends her regards. And I want to thank both of those executive directors for their support of today's program. Finally, I wanted to thank Lisa Mazzetti from Cohen Milstein, who was also part of the planning of today's event. Thank you, Lisa. Very quickly, I want to tell you a little bit about what to expect from today. After I finish with my very brief remarks, I'm going to introduce to you Ken Feinberg, who's going to deliver our morning keynote address. Following that, in a short break, I believe, we will have a panel that will discuss the historical significance of class actions. We'll have lunch. Following that, lunch will be served right out where you were having coffee this morning. Following lunch, a program about challenges facing contemporary class actions, and we'll conclude the afternoon with a program about moving forward class actions in the future and around the globe. You will see, I think, today some of our speakers coming and going. Some of our speakers have timed their appearances perfectly with their programs. So we'll try real hard to not be too distracted by people coming and going. We had 120 people register for the program, which is pretty impressive. But a lot of those people aren't here yet. So if you need to move in and out of the room, if you could use the back door, that way it's not so distracting to the panelists and the speakers coming out over here. After today's program, there will be a cocktail reception out in the lobby. And we hope to get a chance to talk to colleagues and friends at that time. Now it's my pleasure to introduce our keynote speaker, Ken Feinberg. Ken says, please make the introduction short. It's hard to do that with Ken because of his extraordinary resume, but I'll do my best. Ken, as you know, is one of the leading lawyers in the United States, has mediated or arbitrated literally thousands of complex disputes ranging from mass torts to antitrust to securities. and obviously catastrophic disaster cases as well. Ken is a well-respected teacher, lecturer, professor. He's taught at such schools as Georgetown, Penn, NYU, UVA, and Columbia. Many of you know Ken best over the last several years as being the special master from the 9/11 Victim Compensations Fund. I was talking to Ken this morning. He's also a fantastic author. This is a book that meant a lot to me as a tort lawyer reading it. It's called What is Life Worth? And this is Ken's diary about his experience as the special master. I recommend it to any of you who have not had a chance to look at it. Most recently, Ken was also involved in administering the claims process arising out of the Virginia Tech shooting disaster. Anyhow, I want to welcome Ken to our program and look forward to his comments about class actions and the resolution of those sorts of cases.
Thank you very much. Steve mentions my book, and I'm grateful to Steve for mentioning my book. Now, you may have trouble finding that book now at Barnes & Noble. My supply of that book is virtually inexhaustible. So if anybody has trouble finding the book, just email me. I also got to point out, the 9/11 Fund, that was an extraordinary experience for me. But Bob Peck is here. And if you really want to know how that fund came into creation and what trial lawyers did to assure that there would be a 9/11 fund, corner Mr. Peck during the course of today, because he was instrumental in making the fund a reality, and a lot of people don't know the role that Bob played in that regard. I want to thank the Dean for hosting this today. This law school, I'm not surprised that Cardozo is the venue for today because, as you know, Cardozo is really at the cutting edge in trying to meld legal scholarship and law schools with the contemporary issues, so I thank the Dean for that. Steve, I thank for his national role in class actions and in the practice of law. I also want to point out, right at the outset, if you look at the group of distinguished practitioners, professors, experts that are going to be here today, how often do you see Sam Zakharov sitting next to Professor Nagarita? And they're actually communicating. This is a conspiracy. This is something we should get a photograph of the two of them talking with one another about class actions and aggregation, and there's a national resource for you sitting over there to my left. There are also other people here who really labor in the vineyard when it comes to aggregation. Judge Maltese from Staten Island is here today. He's dealing day to day with some of these problems, with the aggregation of claims in his courtroom. So the right people are here for this important day. Also, do not miss the significance of a discussion of class action law and politics and aggregation just a few months before a national election. No matter who occupies the White House and the Congress and the courts, there are inevitably going to be changes. And it's a very timely conference on class actions to get together here a few months before a national election, when you will see undoubtedly some important movement in the way of how, short-term and long-term, how class action should be treated in our society. Now, I just want to make a few comments, and what I'm really going to do today is what, Sam or Richard or anybody would do, sort of as an opening speaker, is simply to pose really some issues, some musings, some questions for panelists and attendees to think about over the course of today. And it's based really on my experience in dealing day in and day out, both in the courtroom, private parties, and in the classroom, with issues surrounding classes and beyond classes, aggregation of claims. No one should underestimate the importance of the class action. The class action is not a new device. It's been around for almost half a century. And the fact of the matter is, if you think of the class action primarily as a device not to gain advantage, but to level the playing field, that's really what the class action was designed to do. Through aggregative techniques, level the playing field for consumers, for civil rights advocates, for the little guy, in confronting an efficient way, and an effective way to deal with mass aggregation, mass claims in a way where the courts would be able to live up to their obligation to promote efficient justice. I mean, forget for a minute what will come up today, all of the controversy. At essence, the class action really is a device. Might be abused, might be extended beyond its appropriate limits. We'll talk about that. But the class action really was a device to promote swift justice, avoid delay, deal with volume by conveniently aggregating claims in one forum for prompt resolution where the individual claims would either not be worth the candle, not worth enough for an aggrieved litigant to litigate, or the courts were ill-equipped to handle the volume without some mechanism to aggregate the claims. Historically, that's what we're talking about. But at the same time, there's a panel this afternoon, and Steve mentioned it in his opening. There's a great deal of fluidity and discussion going on now in Europe about promoting the class concept. The idea that maybe England, France, the civil law countries should develop something analogous to the class in an era of globalization, where whatever's going on here is reported the same day abroad, and now we see lawyers interacting with one another and align with one another, particularly in the European community and the European Union. What is to be done? Question for this afternoon is exactly how and to what extent the class concept can be, should be, will be extended to European countries and European law. That's an issue. Ask yourself this question. Am I right when I say, am I correct when I say, to the extent that the class action is under fire today, to the extent that it is being defended against broad attack from various quarters, to the extent that the class action is now being criticized and undercut legally and politically, to what extent is that due overwhelmingly to the fact that it has become a poster child for alleged abuse in mass tort cases? You know, mass tort cases, asbestos, Agent Orange, Dalcon Shield, tobacco, DES, Zyprexa, etc., Vioxx. To the extent that the class action is under fire, is it under fire primarily or exclusively because it's been asked to adapt to an area of law where either A, it doesn't belong, it just doesn't belong in the mass tort environment, and or B, oh, it belongs, there's just so much at stake financially when you talk about aggregating mass tort claims, that there is inevitably going to be barriers built against the threat posed by the class action to financial viability of industry. So there's a lot there. I'm just raising the question of whether or not, to the extent that the class is criticized as a concept, it's really because of mass torts and not because of civil rights, consumer, securities law, or others. Next, ask yourself this question, doctrinally, I guess. How much of the class action criticism and class action problems could be avoided if the litigants were able to assert federal question jurisdiction over the class rather than diversity? How many of the problems, even in the mass tort context, doctrinally, associated with the class action could be avoided if, as Judge Weinstein tried to do in Agent Orange, the basis of jurisdiction is federal question rather than diversity? Would that help alleviate many of the problems that we confront? Now, I want to raise in the next few minutes just 5 or 6 principles that I hope all of you will focus on in whole or in part today during this day of class action review. Principle number 1. What do we mean when we talk about class actions? And is a discussion of class actions as an aggregative tool to consolidate claims really too narrow a discussion? Take a look at Sam Zakharov's work for the American Law Institute, Aggregation of Claims. When we meet here today to talk primarily about Rule 23 or state class action rules, wouldn't it make more sense to broaden the discussion a bit and focus not only on Rule 23 as a procedural device to aggregate claims, but other aggregative tools as well? The MDL, regional consolidation of claims. If you look at the law and case law governing MDL consideration, local consolidations by district or state courts, I venture to say you will find that most of the same doctrinal conceptual issues that arise in a class discussion also rear their head if you're talking about other analogous forms of aggregation. So maybe we should not be focusing only on, predominance and numerosity and typicality and commonality, the very same issues that are posed by litigants when it comes to aggregating asbestos claims in Judge Weinstein's court in Brooklyn, or aggregating Zyprexa claims in Judge Maltese court in Staten Island. The same issues often arise. And maybe what we should be focusing on today is a broader discussion of Rule 23 into the area of when, under what circumstances, how do courts permit aggregation of claims, not just aggregation under Rule 23. That's point number 1. Or principle number 1 that I at least want to put on the table for all of you to think about later today. Principle number 2. Show me a class action that was ever litigated. I don't know of any. I'm sure there are some. How many class actions actually get litigated with a jury in the box? Maybe somebody knows on Pluto there might be one. I don't know of any. I've learned over the years, it's all about certification. It's all about getting the class certified. If the class is certified, it settles. If the class is not certified, it doesn't settle, and usually it goes away. Not always, but usually it goes away. So in our discussion today about the future of the class action, remind our panelists during the day not to focus too much on the judiciary's tendency to focus on Rule 23, contemplating trial. A trial that never takes place. It's a little bit surreal when you read the literature. Well, you know, if we certify a tobacco class in Castano, all these thousands of cases will be litigated. It'll be worse numerosity than before. We're actually throwing gasoline on the flames by promoting millions, perhaps, trials. And I mean, judges, you don't get it. You don't get it. If there's class certification of tobacco, there's a nationwide class settlement of tobacco. And to what extent is it important to keep that point in mind when discussing the appropriate role of the class action and its future? In fact, keep this in mind. Do not assume, as Victor Schwartz this afternoon will assume, do not assume that all plaintiffs want class actions as a device to aggregate claims and increase leverage against defendant companies, and all defendant companies oppose class actions. That is a very sophomoric view of the world. Instead, as you will hear later today, the class action device is often a favorite mechanism of defendants. Perhaps the most effective mechanism of defendant companies to try and shut down litigation efficiently in a cost-effective manner. And some of the most important class action cases involve challenges to class action settlements by plaintiff lawyers, not by defendant companies. It is very often the plaintiff lawyers, unsatisfied or dissatisfied with class action governance, which Sam has written about, dissatisfied with their role in the class action, the rug being pulled out from under them. It is very often the plaintiff lawyer who poses the most serious threat to the class action. Not always. But I find, as I've said earlier, that the defendant company that challenges class aggregation challenges it at the certification stage. That's where the challenge is met. I mean, one can agree or disagree with Judge Posner in his famous Seventh Circuit opinion involving blood contamination. You can agree or disagree with his doctrinal analysis of the Seventh Amendment and Rule 23. The fact of the matter is he makes some sort of interesting practical points about the extortionate threat that aggregation poses to a defendant company. So this is my next principle. During the course of the day, it is not, I suggest, an ideological battle between the downtrodden plaintiff and the Fortune 500 defendant. It doesn't work that way. And don't approach today with the notion that there is an ideological clear break between plaintiffs and defendants. The history of class actions over the last few decades points otherwise. And that is point number 2. Point number 3, keep in mind the importance in discussing the validity of the class action device of maturation, maturity of the claim. I have found again over the last couple of decades that to the extent that the class action allegation or the class action proposed certification or the class action settlement is grounded in some degree of historical basis. The value of the claim, dollar-wise, based on trials, based on experience. The quality of the claim, again, based on experience, number of cases, where brought, allegations made. The maturation of the litigation before it reaches the certification stage is a very, very important principle, I suggest, in betting on whether or not the claim or the class will be declared valid. And where you run into the most trouble, I think, with class action allegations is when those allegations are not grounded in any historical perspective or corroboration. And the more you have sort of a litigation history that helps define the value of the claim, the quality of the claim, the predominance of the claim, the typicality of the claim, I suggest to you that greatly increases the likelihood of success in terms of class certification acceptability. My next principle: try today, at least in part, and again, read the last chapter of Sam's work with the ALI on aggregation. Try today to spend some time focusing on post-aggregative or post-class administration. This is a very fluid area where there's not much yet to go on doctrinally. Ken, we have settled the case for $800 million. We have settled the case for $1.2 million. We have aggregated the claims, whether it's a class or an MDL. We now have all of the claims settled. Now what do we do? Who gets what among the class? Under what principle does the money get divided? Who's responsible for dividing the money, for evaluating the claims? How do we avoid allegations by claimants that they're being treated unfairly and that their lawyers are engaged in a conflict of interest? My lawyer said that I would get X, but he also represents 23,000 other people who also want X. It seems to me that part of the discussion today should not only focus on, forget the trials, pre-trial certification, but also should focus on post-settlement activity. Now, this is not some esoteric thing. The law of aggregation at the ALI, they devote a quarter of the draft focusing on what we do with claims after they're aggregated and settled. And how do we promote efficient, fair distribution of proceeds? The defendant company walks away. All we want are the releases. All we want are the releases. We bought total peace. How you divide up the proceeds among hundreds, thousands of claimants, we don't care. We're not an adversarial check on how you distribute that money. All we care about is peace. Make sure we get the releases. Well, without the defendant there, what's the appropriate role of the court? And here's the question that I'm getting more and more involved in these days. What's the nature of the design to distribute those proceeds? How is procedural and substantive due process protected when there's no adversary? So you've got the court neutral, you've got the plaintiff, maybe you've got a special master, maybe you don't, maybe you should. how do you go about doing justice to people who purportedly won the case by having a settlement corpus to distribute? I suggest that's an important issue. Finally, something that my final principle for today, something that I think has probably been implicit in everything I've said so far today. During the course of the day, understand that there are efforts underway today, embryonic as they may be, to extend Rule 23 principles to other forms of aggregation. For example, what is the role of the judge when he or she is not presiding over a Rule 23 class, where clearly the judge the court has clear, explicit, objective direction as to its role? But what if it's not a class? What if it's another form of aggregation, like an MDL or a regional consolidation? What is the appropriate role then of the judge relative to the litigants and the litigators? What doctrinal principles from Rule 23 should implicitly, at least, be transferred to any type of legal review of that form of aggregation? It's too bad Judge Weinstein isn't here today. Last year, in the Zyprexa litigation involving the Zyprexa drug of Eli Lilly, 7,000 claims before Judge Weinstein, MDL'd to the judge in Brooklyn. He wrote an opinion. It's not an opinion that many have read or that has received wide dissemination. But he wrote an opinion in which he said, this is an MDL, but I treat it for my purposes as sort of a quasi-class. It has all the characteristics of a class. I've got 7,000 cases. They're all aggregated before me in one forum. There is no motion for class certification, but so what? The same problems arise. They haven't settled yet. I've got to get ready for an aggregative trial using some extrapolation technique to determine who will be tried first as representative plaintiffs. It may settle, so I'll appoint a special master. But he wrote that in my review of how the plaintiff lawyers are behaving, legal fees, for example, and how the money should be distributed, assuming there's a settlement of 7,000 claims, I will rely in large part on Rule 23 doctrinal law. Whether it's a class or not doesn't change the fact, said Weinstein, that it's an aggregation of thousands of claims, and I think, I've got to be ever vigilant. If it's a class, he wrote, I have an institutional role to review the fee arrangements between the lawyers and their clients, the class members. But even though it's not a class, I still have that role. Whoa, think about that. I have a role because it's sort of like Lily's gone. They don't care if it settles. Who's looking after the interest of each individual plaintiff relative to their lawyer? There's no class counsel. There's 38 lawyers that represent 7,000 people. They've all got together informally and agreed on a settlement, but doesn't the court have an institutional role, even though it's not a class, to look after the interest of these quasi-class members? And he proceeded to do just that. And the case settled. All 7,000 cases settled. He established in an opinion that was, I believe, accepted by the plaintiff lawyers a formula for legal fees. And basically he had on his desk Sam's draft of the law of aggregation that helped guide him on how he should treat, not a class, but an aggregation of claims. So, my final principle for you to think about today: not only should we be here defending today sort of the class action and how it works and how it can be made better and more effective, but also are the principles of Rule 23 to be extended in whole or in part into non-class areas with some of or most of the same characteristics as the class. So that's sort of a 30-minute summary of some of the issues. I don't even begin to claim to answer these questions. I mean, we've got, 125 people here who have varying views on how these questions ought to be asked, ought to be answered. I'm more interested, at least sort of as a kickoff keynote, to lay out some of these issues and then save for these incredible panelists today to focus on these questions and others that they'll raise. I can tell you right now, one of the very interesting things today in these panels is going to be whether each panelist yields time to the others. No, this is going to be very, very interesting to see whether Richard Margarita is actually going to stay within his limit or filibuster. But I'll tell you, listen very, very carefully to what these guys say. Because these panelists, I think, Steve, you've done a remarkable job in bringing together in one day, under one roof, the people who really are thinking about this stuff every day. I was, last month, I taught a one-week course on the 9/11 Fund at Vanderbilt in Nashville, and I sat in on Richard Margarita's class on complex litigation. A tour de force. I mean, there were professors sitting with me taking notes that were attending the class. I take it they were, observing, but still, they were, it was just unbelievable. And Sam, of course, and others. The right people are here today to answer these questions and maybe pose some others that I've neglected. So, we still have about a half an hour before a half an hour. 10:30 is the first panel, but Steve said we should take a break around 10:15 to get the panelists set up. So we've got a half an hour, and let's go to questions, and I may deflect the questions and ask guys that are here to answer them instead of me. Yes, sir.
Practicality, federal question only, not diversity. How practical is that to accomplish, and does it accomplish? Just throw the whole load.
Well, the question is, how practical is it to assert federal jurisdiction? I'm not sure how practical it is. As many of you know, in Agent Orange, Judge Weinstein, I was the special master. Judge Weinstein tried to avoid the obvious problems that would arise with diverse laws of negligence in 50 states, and the problem that would pose for commonality and typicality, so that he decided, when it comes to Agent Orange, the herbicide dropped by the Air Force in Vietnam, federal question jurisdiction. Well, the complaint didn't say anything about federal question jurisdiction. The complaint relied on good old-fashioned state tort law. I was injured because of the negligence of the chemical companies. Weinstein said to himself, too bad he's not here, but it's in his opinion, if I have to rely on 50 state tort laws and diversity as a basis for federal jurisdiction, I can see where commonality and typicality under Rule 23 will be seriously undermined. I may not get away with it. So, let's try to say, well, this, even though Congress didn't say it's a federal jurisdictional issue, I really think that when you drop stuff in Vietnam, That's really military, national, fighting the Viet Cong. It's federal question. It's federal question. I made it up. Well, it went up to the Second Circuit. 2-1. No, it isn't. It's state tort law. 2-1. Very, very interesting opinions. Very interesting. The majority, 2. Saying it's federal question doesn't make it federal question. We don't see that it's federal question. The allegations of the complaint are people are suffering, Vietnam veterans are suffering all sorts of injuries because of exposure to a herbicide. That's state tort law. That's what they're relying on in the complaint. Dissent. If it's diversity, it's going to be problematic resolving this case. Because I, in dissent, anticipate that under diversity principles, we're going to run into issues of Rule 23 commonality. State tort laws differ from state to state to state if you're relying on diversity. We'd better rely on federal question. That would be an easier way, and it makes sense with fighting the Viet Cong. Well, it went back down now, and so Weinstein certified using diversity, and then tried to anticipate choice of law problems and negligence problems among 50 states by saying, basically made it up. Basically, every state has the same tort law for purposes of helping the Vietnam veterans. Well, you know, we all laugh, but meanwhile, he had the last laugh. It's settled. It's the high watermark, maybe, of mass tort settlements using Rule 23. It might be the high watermark in mass tort. Goes back to my principle about what's the problem with Rule 23, unless it's mass tort. Isn't mass tort what drives all of it? Isn't mass tort what drives this conference today? He got away with it. It's settled. Once it was certified, no one's going to try the case. It's certified. They can appeal the certification. The chemical companies, they thought better. This is a case. Wait a minute. Why are we appealing? Why do we want to appeal? We've got a class certification to shut down now and forevermore, little did they know, now and forevermore, all Agent Orange litigation. Well, then who objected? Who appealed? The plaintiff lawyers objected. The plaintiff lawyers didn't like the class settlement unless you were the class governing plaintiff lawyer. So that's where the objections came from. Sustained. Second Circuit, sustained. With sort of an admonition, don't ever do this again. But sustained, and there it is. So, how practical? I don't know how practical. Perhaps not very practical. But sure worth trying, in certain cases, to avoid some of the doctrinal problems of Rule 23. Yes, sir. What's my thinking on the Vioxx settlement? I don't know anything about the Vioxx settlement. No one's called me. I read in the paper about the Vioxx settlement. I think it's fair to say, as a layman reading the newspaper, a bit premature to articulate any sort of long-term, firm view of the Vioxx settlement. It seems to be sort of sensible. Notice one point in my principles governing in Vioxx. Notice the effort by the defendant company in particular, before settling, to deal with maturation and get some corroboration internally as to what these cases were worth, what it cost to litigate the first, 20, what the verdicts were. One aspect of the settlement that I think, one characteristic of the settlement that augurs well for its ultimate approval is the fact that it's grounded in some limited litigation history. I think without that history, I don't think, A, the company would have settled. I don't think. They hoped that favorable verdicts or unfavorable verdicts protracted and dragged out over years would enhance their leverage in terms of settling the cases. But I'm more interested in the Vioxx settlement in what happens now, one of my other principles about post-settlement administration. How many litigants will accept the settlement? Are they just a number, or will each litigant be given a true opportunity to evaluate the settlement in light of his or her own interests? How will the billions be allocated? Under what type of matrix? Who's reviewing it? I mean, that's an aggregative settlement, so it's going to be interesting to see how post-settlement administration works in practice. Yes, sir. Oh, a former student of mine. Yes, at NYU.
Class action completely discredited given some people otherwise benefits of mechanism and championship was quite covered.
No, I don't. I think it's a personal tragedy. A personal tragedy. I don't think myself that there's any long-term or short-term institutional diminishment or diminution of the value of the class or of aggregation. I think there's nothing as old as yesterday's news. And I think that one should not view the recent misfortune governing certain individuals with some sort of broad-based attack on class actions. No, and I don't think it will have that impact. To the contrary, I think that what will have an impact on the future of class actions and aggregation is this year's election. I think that will have much more of an impact than on the personal misfortune of a few lawyers. The other thing I must say is that, well, let's save it for a little bit later. Yes, sir.
I make the point that class action can give value to defendants, that is, those against whom claims are made, as well as parties making claims. I think that Rule 23 provides the possibility of a defendant class action, and I was wondering whether there have been any significant defendant class action where potential defendants as plaintiffs try to identify a class so it's very easy.
It's a good question. A defendant-initiated class. There may be some. I don't know. I mean, Sean's here and some others. They may have some experience where there's been a defendant-initiated class, but I don't know of any. But you're right. Rule 23 clearly provides that option. The closest I ever saw to a defendant-initiated, these guys will know exactly, the Keene case in asbestos years ago. Keene, in order to try and cabinize its asbestos liability, worked out a settlement with plaintiff lawyers where I think it was it brought the claim, the certification request. It was thrown out by the Second Circuit on the grounds, as I recall, that it was just that what was sought from the courts was an advisory opinion, that if Keene was initiating the activity with the plaintiff lawyers, there was no trial contemplated, and that therefore really what it should be is just a private settlement and not get the courts involved at all. But again, I don't know of cases where a defendant's taken the initiative. Yes, sir.
Yes, I really appreciate your principle number 4 about
What was that?
class administration.
Yeah.
I think particularly in the context of consumer class actions, I got the most from this will be familiar with the fact that the claims rate for bribery is 10% is having success in class actions. And that, of course, suggests a failure of the mechanism to provide real justice to the class. It seems to me that there's something structurally missing in Rule 23 to address that. The language about notice is inadequate, obviously, to address the problem. How to address that.
That's a great question. I'm not sure that Rule 23 is inadequate in its requirement of class notice. But one topic for our panelists today, and maybe Bob Peck has been focusing on this issue. One topic today ought to be, in the 21st century, with the technology and electronic revolution, are there better ways, qualitatively, to keep class members or aggregative plaintiffs more informed about the nature of a class, the allegations, the settlement terms, and what their options are? Ask the folks that are here today from Mike Hausfeld, from Cohen-Milstein. We have just settled, I was the mediator, we've just settled the Virgin Atlantic British Airways private class action. It's settled. As to principle number 4, your point. Ask the folks at Cohen-Milstein to give you a copy of the notice provisions in this settlement, in which, basically, let's minimize the importance of publication in the newspapers. That's 20th century stuff. No one reads newspapers. Let's minimize, have some of it, but let's minimize newspapers. Let's go to the internet. Let's go to Travelocity. Let's go to websites. Let's go to blogs and set up for court approval an electronic, basically, an electronic notice provisions designed to educate claimants about their rights when they flew from London to the United States or the United States to London on Virgin Air or British Airways. It's absolutely very, very creative. In addition, let's make it so that any claimant could just file a claim online using the web and get paid. Now, this may seem like, yeah, well, what else is new? But really, the idea that, to my experience, maybe some of you know of other similar situations, but the idea that we'll now use primarily electronic means to keep class members informed of their rights is very, very interesting stuff. In addition, ask this question today. To what extent, in aggregative claims, whether it's a class or not a class, should the plaintiff lawyers be required to keep their clients apprised of developments during the course of the settlement negotiations and or the trial? Now here you get into some deep water, because I don't think many lawyers involved in such a case, pre-class, really want the clients to know too much. So who really, other than the court, is sort of representing those people during the course of negotiations of a settlement, so that they're kept apprised of what's going on, since their rights are going to be impacted? It all goes back to the broader issue of the extent to which in the 21st century there's some additional requirement to keep aggregative plaintiffs aware of what's going on. And how are you going to do that? Yes, ma'am.
There are still a lot of people who don't have access to the internet and electronically, and I think that's practically, that's actually already getting short end of the stick. There's another way of sure happens not like that happens. So I would hope that something after everybody.
I'm not suggesting that the internet become the only vehicle. I'm just suggesting that if the goal is relative to maximize dissemination of information, it is not only the print media, but also electronic media or electronic means. Also, let's not forget, in a lot of these mass tort cases, you can send a letter still. I mean, there's still, let's not forget that in many cases you have the name and address of the patient who was prescribed the drug, and you can reach that person. That's still the best. Personal notice is always the best. I'm just suggesting that as part of this principle about post-settlement administration, take a look at that VA-BA settlement, because those guys really came up with some very creative ways to reach out to class members who flew those planes. Yes, sir.
Your second principle about...
What's that?
That was the one about how there's not a predictable ideological divide that we would expect. I understand what you're talking about with respect to mass towards personal cases, but in small consumer cases, any cell phone company over big switches or unfair charges or things. My experience with those sorts of cases, pretty much providers were 100% present because always the plaintiffs want these small consumer cases. That's that. Never depended on the lobbying on CAFA and the money all flows from the big level pricing. So what you're talking about really applies to one thing.
It may. You know better than I. I'd ask, later on, ask Sean whether or not in the securities area, for example, is it always the ideological divide? Does the defendant company or the accounting firm or the hedge fund, are they always anti-class certification, settlement, aggregation, let's shut down the future? Or is that somewhere in between mass tort, where you have a lot of defendant companies interested in settlement, and perhaps consumer or other similar cases where there's, as you say, I don't know, 100% ideological opposition to class aggregation? That very well may be the case. But if you have three buckets, consumer, civil rights, institutional litigation, class, securities litigation, Sean, mass torts, Sam and Richard and others, and can by the nature of the case, can you pretty much predict where the ideological divide will be? That's an interesting question. And I don't know enough about consumer cases, for example, or for that matter, Sean's cases, for example, to say with 100% certainty, the way I can with mass torts, that how that ideological divide shakes down. Yes, ma'am. My understanding of the bedrock principles of Rule 23, if you have been designated class counsel, pre-certification, you're the lawyer that's the advocate for the class. You have an institutional obligation to represent the best interest of the class, not the interest of any parochial interest of any individual class member. That's why, read Sam's article on governance, that's why, I think it's in the materials, that's why judges very often want to make very, very clear when class counsel, when the plaintiff's lawyers start jockeying to be class counsel, the irony in a way. Well, plaintiff lawyer, how many class members do you represent? I represent all of them. I should be class counsel. Well, wait a minute. Be careful what you wish for. If you represent those individual class members, how can you effectively act as class counsel since you represent this bevy of class members? So the plaintiff lawyers are walking a tightrope very often. Now, there are some plaintiff lawyers who walk in and say, I want to be class counsel, who don't represent any class members, but have affiliations or work with those class counsels. So, you know, people like Stan Chesley in Cincinnati he's been very, very effective over the years in representing classes when his actual institutional firm involvement with individual class members is pretty small. And yet he's managed, I think, quite effectively to represent the class. So that's an interesting issue. And again, the experts are here today to focus on how they walk that line. Judge, I'm the guy. I'm the person because I know the players. Well, if you know the players, how can you be class counsel? You have an obligation to those 111 people that you represent, not the greater class. That's the discussion that ensues in the courtroom. Yes, sir.
Can you say a word about practical provisions, either for arbitration or for arbitration without class arbitration? That whole business strikes it as the other attack rather than legislation.
You're absolutely right. I mean, that's a big issue today, a huge issue today. Under what circumstances may arbitration provisions contractually entered into by the defendant company and would-be class litigants, to what extent may arbitration be the device for class resolution? I think that's one of your questions, at least. And that's being debated right now. Now, it's a problem that will easily, I think, be cabinized because you're seeing more and more arbitration contractual provisions today that expressly preclude the ability to arbitrate classes. The problem's arisen because previous arbitration provisions were ambiguous or confusing on the broad scope of arbitration. A company would say, if there's any dispute, we don't want to go to court, arbitration. Okay, let's certify a class from the 3 arbitrators. Oh, no, we didn't mean that. Well, the language doesn't say you didn't exclude it. So I think it's going to have to play out. I don't think the courts are going to be very sympathetic to the use of arbitration in class aggregative litigation. But and the AAA, for example, I guess doesn't permit it. So, but I don't view that as a big issue because I think that sooner rather than later there'll be contractual limitations on the ability to aggregate claims in arbitration. Okay, let's do one more. Yes, sir.
Defendants often want class certification. Describe some of the conflicts on the plaintiff's side. What are the disputes about money? Who's more qualified to represent the client?
What are some of the plaintiff disputes that arise in a Rule 23 situation where the defendant company wants class settlement? What are the disputes that arise among plaintiffs? They vary, like human nature varies, right? 1, an ideological aversion to a class. Let me tell you, don't poo-poo that. There are very, very good plaintiff lawyers in this country. Robert knows them, who will say, I think, I'll use Paul Reingold as an example. I think he's a good example. If he were here, maybe he'd disagree. I don't care if you want to make me class major domo. I have no interest in a class. Mike Cerisi at Robbins Kaplan. I think that the class action is anathema to the civil justice system. Maybe it's all right in consumer, my drain doesn't work, or my Mixmaster. Maybe. But in my experience, there are plaintiff lawyers. What's the nature of the disagreement or the opposition? 1, there is an ideological aversion to aggregative justice. That's one objection. 2, I'm not in charge. Basically, what you have done is you've taken my contractual representation that I've got with 8 class members in Idaho and pulled the rug right out from under me. because now you're class counsel and you're settling for the class, and I've lost 8 cases. So, I mean, it's Nazi Germany. That's not fair. Well, you can opt out. Yeah, right. That doesn't work. We tried that many times. It doesn't work. Well, if you don't like the deal, opt out. The 8 people in Idaho don't want to opt out. Frankly, the 8 people in Idaho may not even know about what's going on. But that's another whole issue. But problem number 2, I'm not in charge. Problem number 3, you said it, not me. Fees. Wait a minute. I just lost 8 people in Idaho where I had a contractual 40%. Now, basically, that contract's gone, and Stan Chesley in Washington, where the case has been certified and settled, is class counsel getting $2.6 million. So it's fees. 4, a very principled objection, and these guys will talk about it. I have nothing ideological against a class or an aggregation. I don't really care if I'm not governing. And I'm not worried about my fees. I've got plenty of work, and I'm not worried about that. Let me tell you my 4th objection, Mr. Feinberg. The deal stinks. I can go into court and challenge the deal. The trouble is, the deal doesn't stink for the aggregative common denominator. But I've got 8 people in Idaho, and it's really lousy for them. And I guess I can opt out. But the opt-out really isn't a significant weapon. So I'm really left between a rock and a hard place. And for those reasons, maybe a mixture, I'm challenging the class. So, we're done. Let me just say this. This day coming up, I mean, this looks like a major good day with these 3 panels. You've got the best people I know of going to be sitting up here. They'll answer, I'm sure, a lot of these principles and a lot of these issues, and they'll raise other questions, and maybe they'll say Ken doesn't get it, which is fine, because nobody else understands this stuff either. So, I mean, we're all sort of swimming in deep water here. But it's really going to be a great day for Cardozo and a great day for all of you. And my only warning for you, based on the quality of the people that are here, I mean, they even got Deborah here from Stanford. Must be going to the theater tonight. Anyway, I want to make one suggestion, a very practical one. With the panelists that we've got, there'll be an inevitable desire for them to just debate among themselves. Make sure that you in the audience demand an opportunity to ask questions and pose issues and engage them. Because otherwise, these guys come together and they will just talk among themselves, and it'll be fabulous, but they need attendee input. Thank you all for this opportunity.
We're going to go ahead and take a 10-minute break. If we can be back here promptly at 10:30, the panel will...
Yeah, I think that'll be a good.
I got stuck in the elevator in my apartment. I almost didn't make it, so I ran up here.
That's fine. Yeah,
Ever get stuck in an elevator? Yeah,
okay,
stuck.
Okay, that's good.
I was thinking I need a class action lawyer.
Good morning. I'm Praveen Fernandez, the Associate Director of Programs at the American Constitution Society for Law and Policy, otherwise known as ACS. Lisa Brown, the Executive Director of ACS, very much wanted to be here and unfortunately fell ill and she couldn't make it. So she sends her regrets and her best wishes for a wonderful conference. For those of you not familiar with ACS, we are a national network of lawyers, law students, and policymakers dedicated to ensuring that principles of human dignity, equality, and access to justice enjoy their central, rightful place in American law and policy. Aside from this work, of course, we're about the business of building a progressive infrastructure, and that sort of work is only possible when one collaborates with schools and organizations that are engaged in meaningful work, and those are schools like Cardozo and organizations like Public Justice, so we're very, very happy to be here today. I'm happy to introduce panel number 1, the historic significance of class actions. As you know, you'll hear throughout the day of all the variety of different reasons that class actions are meaningful, but one of the most basic ways is that class actions allow individual plaintiffs to litigate cases where they might not have been able to litigate them individually, but they're able to seek redress in the courts as a collective whole. These are the sorts of issues that are dealt with in ACS's Access to Justice group, which is co-chaired by our moderator of the first panel, Lucas Gutentag. A true recitation of Lucas's accomplishments and credentials would take more time than I have, so I'm going to give you an abbreviated Cliff Notes version, knowing that you have the bios in your conference materials. Lucas is the director and founder of the ACLU's Immigrants' Rights Project, and on behalf, under its direction, the Immigrants' Rights Project has conducted major national impact litigation as well as advocacy and public education. In addition to his work at the ACLU, he has taught immigrants' rights classes at Stanford and Bolt, UC Berkeley. Without further ado, Lucas.
Hi, thank you very much. My job is to introduce the first panel, to welcome all of you to this fabulous conference, and then basically to get out of the way and let the discussion continue. This really is, to echo what Ken Feinberg said, I mean, this is a remarkable conference with remarkable panelists, and I can't imagine a better time to be talking about class actions, the need and the challenge. On the one hand, we've seen the newest financial mortgage crisis and the allegations of misconduct in relation to that raises a need for class actions, continuing mass torts in the medical malpractice area, the ongoing obvious need in the civil rights, human rights, employment discrimination, and other areas. And at the same time, we see these congressional restrictions on class actions. We have some class action lawyers, as was mentioned a moment ago, in disrepute, and class actions being the constant whipping boy from business and others. One of the issues I think I want to be sure that we add to the discussion is the role of class actions in the civil rights area that didn't get as much discussion in the opening comments. This first panel, our job in this first panel is to give a historical overview of the evolution of class action to set up the discussion for the rest of the day. And we really do have a remarkable panel that brings, as do all the panels, a rare combination of both incredible scholarly expertise and practical experience with class action litigation. We have the most distinguished and eminent both scholars and practitioners from around the country, and in this panel in particular, to talk about these issues. So what I'm going to do is briefly introduce each of the panelists, and then they're going to speak for a few minutes about the different areas, and then we're going to have a discussion both among and between the panelists and with all of you. And as we go through, I think we want to be constantly referring to some of the questions that Ken Feinberg raised, as well as others that will emerge through these presentations. So first, we're going to hear from Richard Nagaretta on the historical context and purposes of class actions, framing the historical context. Richard, as you I think already heard, is a professor at Vanderbilt Law School, director of the Litigation and Dispute Resolution Program. He has recently published a book that's particularly timely, Mass Torts in a World of Settlement, so going to that very important issue of the actual implementation of class action settlements. And he will be, as I said, talking about the historical context and purpose of class actions. Then we're going to hear from Professor Jeffrey Miller, who's the Stuyvesant Professor, Stuyvesant Comfort Professor of Law at NYU Law School and the Director of the Center for the Study of Central Banks. Again, an eminent scholar whose works on class actions have become classics in the field, a graduate of Columbia Law School, clerk for Justice White, and has written in this area for a long time. He's going to be talking about the purpose and the evolution of Rule 23 in particular. Then we're going to hear from Elizabeth Cabraser, a partner at Leif Cabraser, Hyman and Bernstein, one of the country's preeminent class action litigators who also teaches and has written widely in this field. She is going to be talking more specifically about the use of class actions in the human rights and civil rights context in which she has extensive experience, as well as in the other areas of class action and complex litigation. And then we're going to hear from Sean Coffey, who is at Bernstein, Litowitz, Berger, and Grossman, and served as the lead trial attorney in the WorldCom securities class action case against Arthur Andersen. I don't know if he's planning on bringing some new suits shortly that resulted in over $6 billion recovery. And so he will be talking about class actions in the context of securities and antitrust litigation. So with that overview, I hope that we will frame all these various contexts and then continue this discussion. Thank you.
Thank you, Lucas, for that very generous introduction, and thank you especially to my friend Miriam Gillis for inviting me, and also to ACS and Public Justice for their support for this event. In thinking about the history of class actions, there are two features of context that stand out for me. The first point about context is that the class action emerges in its current form in American law very much side by side with the modern administrative state and the development of public administrative agencies. So, for example, it's no accident in the scholarly literature that one of the earliest articles thinking about what can be accomplished by class action. Here, this is Harry Calvin and Maurice Rosenfield's 1941 Chicago article. It's no accident that Calvin and Rosenfield's article is written in 1941 in the midst of the New Deal. All of this, I suggest, is not an accident when one considers a second point about context, and that is both class actions and the modern administrative state, I think, are two different kinds of responses to a distinctively modern phenomenon. And that phenomenon is the economic integration of the American marketplace. So in the 20th century, during the time in which both of these institutions that I've mentioned are developing, commerce is no longer local, it is increasingly national. The form that it takes is the marketing of undifferentiated goods and services across the country. The form that it takes, certainly in recent decades, is the sort of highly organized, highly integrated national firms like Walmart. It's no accident that the Walmart class action could be proposed as a nationwide class action when you have this sort of highly structured national firm. As our afternoon panel will go on to address, we're seeing a further playing out of the notion of economic integration now in the international sphere. So, again, it should not be surprising that we're seeing greater interest among European systems in something like collective or group litigation when the scope of commerce today is not merely national but truly international. Now, the emergence of a truly national economic market over the 20th century here in the United States, it seems to me, has a couple of consequences that are also important features of context here. One is the straightforward notion that a truly national market magnifies the potential scope of wrongdoing. In particular, it is what makes it economically tempting for national firms to engage in wrongs that might be quite small on an individual basis, but that add up to considerable gain for the wrongdoer in the aggregate. The national market is what aggregates those small wrongs into something that might be tempting for a large firm to engage in. The second point is that it speaks to another consequence, and that is that in these types of situations that I've described, there will be demands for regulation of the national marketplace that are commensurately national in scope. So here, in this regard, the United States has made a very distinctive kind of choice, at least by comparison to Europe. We embrace comparatively less robust forms of ex-ante public regulation by the administrative state, but also comparatively more robust forms of ex-post regulation by way of lawsuits, in particular by way of class actions. What the class action does is to deploy aggregate procedure to address wrongs that are made possible precisely because of the aggregate scope of business in a national market. Aggregate procedure is the response of the law to an aggregate market. Now, this historical story, I think, also sheds light on some of the difficulties posed by class actions that Ken Feinberg has alluded to. I think that once one accurately situates the class action in institutional terms and sees it operating in parallel with things like public enforcement actions, then I think some of the difficulties we see in class actions also come into sharper focus. The key point here, I think, is that the class action is a one-shot, ad hoc form of representation. It does not arise from a private contract, an ordinary lawyer-client retention agreement, but likewise, it does not arise from a delegation of authority by way of public legislation. It's midway between notions of private contract and public law. So on the private contract side, there is no lawyer-client retention agreement, as I mentioned. Instead, this lawyer-client representation comes into being, in effect, by a implication that is drawn by the law, at least where the requirements of Rule 23 are met. Look at the situation now from the public side, the legislative side. The class action does not arise from a delegation of governing power from the legislature. The rule itself is a matter of public law, but the class action does not have the kind of ongoing institution. It does not comprise an ongoing institution like the EEOC or the FDA that can be held accountable over the long term for both its regulatory actions and indeed for its regulatory inactions through the process of presidential and congressional oversight. The upshot, I think, is this. What makes the class action difficult for our legal system to deal with is precisely because it occupies this kind of gray area between private contract and public legislation. And so what we see in the particular procedural requirements of Rule 23 that Jeff Miller will be talking about, both requirements for class certification and for class settlement approval, is an effort to draw on both private contractual notions and public checks on this kind of ad hoc representation. So you have private checks in the form of things like opt-out rights by which class members might, maybe, assert their individual autonomy. The more important, I dare say, checks are in the nature of public checks, principally by way of judicial oversight by a court, with the court cast not as a traditional, passive, neutral umpire of an adversarial dispute, but rather the court cast as an active fiduciary, almost quasi-inquisitorial fiduciary for the class members. So much of what we're going to hear about today, I think, represents the playing out of these mixtures of public and private notions. It shouldn't surprise us, at the end of the day, that legal cultures that see the relationship between government and private law differently from the United States may have different inclinations and make different choices with regard to things like class actions as compared to the United States. Thanks.
Well, let me, is this on? Let me join Richard in thanking Miriam and Praveen and the ACS Cardozo Law School and Public Justice. My remarks here are going to be focused on one aspect of Rule 23, the B3 damages class action. I understand that Elizabeth is going to talk about the other types of injunctive class actions and class actions involving human rights and civil rights. So let me talk a little bit about B3 and its history. Many things that Sigmund Freud said are now much in doubt, but one thing we probably receives universal agreement, which is that much we find mysterious in our law and our life can be clarified with a resort to history. By going back and discovering the pathologies that were present in history in the past and the accommodations we made to cope with those pathologies, we can at least understand more about why our present is the way it is. So I think that something like this can be done in the area of the B3 class action, to go back and understand where it came from in order to understand some of the problems that we cope with today. So let's power up the Wayback Machine. By the way, unless you're a certain age, you don't even know what the Wayback Machine is. But the Wayback Machine is a time machine that takes you back in history that was a feature of a cartoon that I used to watch as a kid. So we'll power up the Wayback Machine and go back to 1966, a very long time ago, in the living memory of some here, I expect, but nevertheless, from the standpoint of class action litigation, an exceedingly long time ago. 1966 is an important date for class action litigation because this was the year that the comprehensive revisions of Rule 23 were adopted, including the opt-out class. Now, the Rule 23 in its modern form, the 1966 version, was recommended by rulemakers who started out, as is typical with many reforms that turn out to be fundamental, with much more limited goals. Consider the United States Constitution. But their goals were not to effect a revolution in class action practice, but rather to comport with the charge that they've been given, which was to address some of the issues, some of the problems that had arisen under the prior system. And in particular, the damages class action under the prior system was an issue that they were tasked with addressing. So how was the damages class action addressed prior to 1966? It was done with a device called the spurious class action. Now, to begin with, the title spurious is not actually a very favorable nomiker. It's not very nice to be known as spurious. So that class action, the damages class action, already came at that time with a certain negative connotation, that there was something questionable, queasy, uncertain about the spurious class action. And the reason that it was viewed this way is that this type of class action was not one where rights were held in common. It was one where individuals had separate rights, but the adjudication of those rights could most efficiently be conducted in a group setting. In other words, the damages class action that we have today. The spurious class action was distinguished from the true class action and the hybrid class action. We don't have to get into what these were, but these were terminologies that roughly equate to categories under Rule 23 today. Now, what was the problem with a spurious class action? The problem was that prior to 1966, it was considered that because the rights involved were separate and independent, and no individual class member could be forced to subject himself or herself to the judgment. Therefore, it was necessary, in order to participate in a spurious class action, to intervene in the proceedings. In other words, the spurious class action was an opt-in procedure, not an opt-out procedure. If you intervened, you would be able to take advantage of any judgment, but you would also be subject to the preclusive effect of any judgment as well. Now, the framers of the 1966 amendment saw two problems with the spurious class action, two in addition to its very unfortunate name. And the first is that the opt-in procedure was not affording adequate relief. And this was true both for the defendant and for members of the class. For absent class members who didn't opt in, well, they couldn't get the advantage of a judgment. for the defendant, the lack of the opt-in procedure meant that many class action members would not be subject to the final decree. And that meant that defendants could not get global peace, final relief, in a class setting. So both defendants and absent class members could benefit by a procedure. And as is well known, the procedure that was adopted was the opt-out procedure. You are subject to the decree in a B3 class action unless you affirmatively opt out of that class action. The framers were aware that the opt-out procedure had due process problems, implications. They sought to address this through the common devices of ensuring the adequacy of representation, the typicality of the named class member, the requirement of judicial review of any settlements, judicial approval of class certification in the first place. Now, that was the first problem, that the original spurious class action had been an opt-in class action instead of an opt-out class action. The second problem that the framers in 1966 addressed was something that had been alluded to and, in fact, greatly it was a principal focus of the famous article by Calvin and Rosenfield that Richard mentioned some moments ago. And the concern there was that in these spurious class actions, judges had taken up the habit of allowing people to opt in, to intervene in the action after a judgment, either very late in the action, when, say, a motion for summary judgment had been decided, or other preliminary motions had been addressed by the court, or even after a judgment. And the concern was that if you could opt in after a judgment, this gave absent class members the effect of an option. If the judgment was negative, they wouldn't opt in. They could stay outside and bring their own lawsuit. If it was positive, they could opt in and take the advantage of a judgment. And this was considered to be very unfair to defendants for obvious reasons, and Calvin and Rosenfield highlighted this problem in their article. Now, this problem of what was called one-way intervention, that is, intervening if it was positive and staying out if it was negative, the judgment, was not addressed by the opt-out procedure. The opt-out procedure also presented the risk, the framers thought, of one-way intervention. The reason was, if you could opt out at any point during the action, you could sit around on the wings if you were an absent class member, and if the judgment or preliminary proceedings in the case were favorable, you could elect not to opt out and take advantage of those, or if the judgment or preliminary proceedings were unfavorable, you could opt out and be able to bring your own lawsuit. So the problem of the one-way intervention was not addressed by the opt-out procedure. What did the framers do? Well, the framers decided that you had to have your certification immediately or very early. Once the class was certified, then the opt-out decision had to be made, so you couldn't wait around in the wings. The solution was certify the class very soon after it was filed, and this was contained in Rule C1 of Rule 23. Now, I'm going to now put this together and suggest that the framers of Rule 23 in 1966 were very far-sighted individuals, but like many people who create something, they didn't fully understand the implications of what they created when they created the opt-out class action. The reason was that they were looking at class actions that had existed heretofore, before they adopted these amendments. And because those were opt-in class actions, they tended to be small, and the individual claims that were asserted in those class actions tended to be large. At least the people who showed up on the radar screen by opting in tended to have relatively large claims. Otherwise, they wouldn't have bothered. So the type of B3 class actions that the framers in 1966 thought of were relatively small cases involving relatively large individual claims. What they did not realize was that by creating an opt-out procedure instead of an opt-in procedure, they were creating something entirely different. What they were creating was the large-scale small claim class action. That is, the class action with thousands, hundreds of thousands, or millions of plaintiffs, each one having a very small stake in the controversy. I don't believe that this large-scale small claim class action was really salient to the drafters of the 1966 amendments because they didn't understand that that's what they were creating. With an opt-out class action, you get the large-scale small claims class actions. Now, I'm going to briefly mention 4 problems that are created because they didn't understand that they were creating large-scale small claim class actions. Number 1 agency costs of lawyering, agency costs of counsel. The large-scale small claim class action is very similar to a large corporation. It's a firm, and it's a firm with many constituents, the equivalent of shareholders being the class members. And like any large-scale firm, you have a separation of ownership and control, something that Burrell and Means at Columbia identified at close to the same period. Separation of ownership and control, the lawyers control, the class members own the claims, means that the lawyer has the advantage to take advantage of the absent class members to the lawyer's own benefit. And much of the debate about class actions in the years since 1966 has addressed this very problem. The problems of, let's say, the reverse auction settlements, the problems of coupon class action settlements, the problems of attorney's fees being manipulated by counsel, all relate to this separation of ownership and control that was made possible because of the opt-out procedure adopted by the framers in 1966. Number two, early certification. The framers thought that defendants would love early certification of class actions because that avoided this problem of one-way intervention. Plaintiffs with early certification couldn't wait around on the wings to decide whether to opt out. Well, once the large-scale small claim class action enters the picture, early certification isn't a protection for defendants, it's a disaster for defendants. The reason is, once a large-scale small claim case gets certified, the possible exposure, the damages exposure to defendants become enormous, and defendants feel a hydraulic pressure to settle the case regardless of its merits, or at least that's what they report. So instead of benefiting by early certification, defendants actually were at significant risk from early certification, and contrary to the expectations of the framers in 1966, it's defendants who object to the certification of class actions. So that's another thing that the large-scale small claim class action created, which wasn't anticipated at the time. Number three, the opt-out right. The framers in 1966 felt that this opt-out right was going to be significant. It was a principal protection for the due process rights of absent class members. Well, once you get the large-scale small claim class action, the opt-out right becomes meaningless. It becomes ridiculous. It becomes an embarrassing travesty. And the reason is that it's never in the interest of a small claim claimant to opt out. Why should they opt out? If they opt out, they'll have the right to bring their own lawsuit worth $10, but that right is worth nothing. Whereas if they do nothing, at least they get the possibility that they'll get the benefit of a judgment. So opt-out rights in large-scale small claim class action are meaningless and, in my opinion, irrelevant and mistaken. And this is illustrated by the fact that when we look at opt-out rates in these actions, they're usually like 0.001% of the class opts out. And then you have judges saying, oh, this shows that the class members were universally enthusiastic about the settlement. How ridiculous! But these embarrassing statements by judges are said with a straight face hundreds of times in the Federal Reporter. Number four, the cost of class notice. Class notice in the view of the framers in 1966 was not a very big deal. But when you get the large-scale small claim case, class notice can run in the millions of dollars. And the Supreme Court told us in the Eisen case that that's to be paid by the plaintiff's attorney. Well, if you then get a class settlement, the plaintiff's attorney has to front millions of dollars that the plaintiff's attorney may not have. This, again, strikes me as ridiculous because the purpose of notice of certification of a class action is to inform class members of the right to opt out of the class action, a right which they don't value at all, and all that we do is waste money and benefit settlement administrators and give lawyers who work with settlement administrators very good tickets to ball games. So the idea of notice to absent class members, and especially first-class notice, which the Eisen case seemed to require, is again rather ridiculous and unfortunate, but is a function of the fact of the large-scale small claim class action. Now I'm going to end in 1 minute, I promise, but I have 4 suggestions that can respond as they're very short, so it'll be 10 seconds each. Number 1, dispense with notice in large-scale small claims class actions. At least dispense with first-class mail notice. Let's have notice by publication, notice on the Internet, but not waste the classes and everybody else's money by sending first-class mail notices to people who just throw it away. Number 2, let's not worry so much about the named plaintiff, because the named plaintiff in consumer cases is simply a key to the courthouse door and an excuse for the defendants to object to class certification on bogus reasons. So we should not worry about the named plaintiff. What we should worry about is the adequacy of class counsel. Number 3, settlement classes are viewed in many circles, Third Circuit has opinions on this, as being questionable, doubtful, sort of uncomfortable procedures. The fact is that settlement classes are overwhelmingly the way class actions are adjudicated in the United States today. Probably 70% of all class actions that get settled with a settlement class. And there's nothing wrong with a settlement class, nothing whatsoever. The only thing that is wrong with a settlement class, if we see the class action through the perspective of 1966 instead of through the present perspective. The settlement class helps both the defendant and the plaintiff, the defendant by putting off class certification, the plaintiff by putting off the cost of notice, and the class members by giving them at the time they have the decision to opt out meaningful information about what to do. Last and probably least, let's consider how we appoint class action counsel, and this is something I've harped on for years, but the auction approach, that is auctioning rights to class representation, or even auctioning the whole claim, addresses a lot of the agency problems that are created by the large-scale small claim class action. Thanks.
Thank you so much for the opportunity to be here today. This has already been a far more fascinating conference than I even could have hoped for, and confusing, because I was given the very small task of talking about the history of human rights, civil rights, and mass tort class actions. I had a theme. The theme was paradox. And just to demonstrate that, one of the things we know about class actions is that at the very least procedurally they are an organizing principle for large and complex litigation. And I was organized when I walked in this morning. I had an outline, and then I started to listen to Ken Feinberg and to my esteemed panelists, and this is what has happened to my outline. So, in order, we'll talk about a few of these things. Ken mentioned, and it's true, I guess, that class actions are rarely tried, and that the purpose of class certification, or at least the outcome of class certification, is settlement. So I want to talk about a few exceptions to that rule, if it is a rule. And the first comes from the civil rights arena, and this is almost too obvious to mention, but a class action that really was never settled and has been tried and retried has changed the face of our nation, who we are, how we interrelate to each other, how we see ourselves. And that is Brown versus Board of Education, which was an obscure class action from Kansas City. It was one part of the litigation strategy and agenda of civil rights giants, members of the NAACP and others, who used the class action, what we would now consider the B1 or B2 class action, as the preeminent tool to achieve through the rule of law something that Americans, for the most part, individually and in the aggregate, were not ready for and resisted. That is the plus factor of the class action, which makes it different than other forms of aggregation. Aggregation puts together individuals. A class action, through the genius of the representative suit, creates something more and can create something better. It empowers groups to see themselves as groups. It can create community. And in areas like civil rights, it may be the unique and essential tool for forcing all of us to do what we should, but what we are not quite ready to do on our own if we're left to our druthers as autonomous individuals. In the civil rights arena, we go from Brown versus Board of Education, decided by the Supreme Court in 1952 and still proceeding forward, backward, and sideways with all deliberate speed, to Dukes versus Walmart, the Ninth Circuit affirmance of what is perhaps the largest class action. That is really an employment, if you think about it specifically, it's an employment rights case, but it really is also a civil rights case because we've moved from the arenas of education, public accommodation, to the arena of the economic sphere, employment rights. Class actions have had a recent and distinguished history in the arena of human rights as well. One of the very largest verdicts in a fully tried and affirmed on appeal class action was the class action trial under Rule 23b-3 of the Marcos human rights litigation on behalf of a class of 10,000 victims of a generation-long regime of terror under the Marcos government in the Philippines. That case was tried in the federal court in the District of Hawaii, generated a verdict of several $billion, including a punitive damages verdict, went to final judgment after being affirmed by the Ninth Circuit, and sadly has never been collected against a recalcitrant defendant. The Marcos human rights litigation was prelude to another major piece of human rights class action litigation, not tried, and perhaps this one could never have been tried, but settled in 2000. The Holocaust litigation made up of two major components, the Swiss banks case, which settled for $1.2 billion, and the Nazi-era litigation involving primarily the German government and corporations that worked for the Hitler regime, which settled for approximately $5 billion. The Swiss banks case involved worldwide notice on the internet, publication, media, that probably reached the high water mark of a comprehensive and ambitious notice scheme in over 30 languages, and every imaginable media ranging from drive time radio in Sydney, Australia. I remember being interviewed by a particularly breezy disc jockey, to direct spoken word notice to members of the Roma community who were either illiterate or did not trust the written word. The largest verdict in a jury trial that we know about was also a class action, a mass tort class action, the Engel $146 billion punitive damages verdict against the tobacco industry in the Florida State Court. That verdict has been overturned, but the members of that class got a very interesting parting gift, which is another benefit of the mass tort class action, which may not necessarily be available under other forms of aggregate litigation, and that is the res judicata effect of the liability and defect findings the class jury entered during that trial. All members of the Engel class who wish to pursue individual suits, and there are 7,500 of them so far, have the benefit of those findings and do not have to relitigate those issues in subsequent trials if what the Florida Supreme Court said regarding res judicata effect of those findings holds true. The second largest verdict that we know about in the field of mass tort litigation is the $5 billion, or formerly $5 billion, Exxon Valdez verdict, a class action trial verdict in 1994, the same year as the Marcos human rights verdict. That verdict has been reduced through a series of appeals to $2.5 billion. Just last month, the matter was argued before the United States Supreme Court, not questioning the class action process or the integrity of the trial, but simply the amount of the punitive damages verdict. And by the way, something else Ken said rang very true in the Exxon Valdez case. It was the defendant, Exxon, that moved for class certification under the mandatory class action provisions of 23b-1 so that there would be only one trial of punitive damages. So, paradox. Class actions are not often tried, but when they are tried, they can be momentous, momentously effective, momentously empowering, momentously efficient, and fair. Mass tort class actions are now proceeding under the guise, possibly the temporary guise, of the non-class mass settlement, the Vioxx settlement, and also recent settlements in Zyprexa and Guidant are mass settlements. They are not literally or formally Rule 23 class settlements. They have many of the attributes of class settlements. And what's most interesting to those of us who see the past as prologue, when judges are faced with those non-class mass settlements, they tend to treat them as class settlements in certain important respects, and not just Judge Weinstein in Zyprexa, but other judges as well. Judge Frank in the Guidant settlement decided to exercise his inherent authority to review the private fee agreements of lawyers under contracts with their clients. It wasn't a class action. He had the authority. He decided to exercise that authority to make sure that the transaction costs were not overwhelming the benefit to the settling plaintiffs, and that the lawyers' fees were fair. He would have had unquestioned right to do that if it were a class action. He decided it was the functional equivalent of a class action, as did Judge Weinstein with respect to Zyprexa, and as Judge Fallon is doing in certain respects with respect to the Vioxx settlement, in terms of taking an active role in administration of the settlement, having reports from the settlement administrator at every status conference. So when judges want a model to govern their own level of engagement in the practical aspects of mass litigation, when they want a model within which to determine what their role and power is over attorney-client relations, they have tended quite recently, and will probably still tend, to look to class actions as a model. And in those very broad brush respects, the notion of a class action as a representative suit, the notion of a class action embodying a community of people who are represented by named plaintiffs and lawyers, over whom a court has a special fiduciary role, and has a role that is, in a sense, delegated to the plaintiffs and the lawyers. We see other countries beginning to take up the notion of some forms of group or representative actions. And I don't think they'll be just aggregations. I think they will have important attributes of class actions. The plus factor that makes a class action more than the sum of its aggregate parts. That's what makes class actions scary, and that's why I think there's a lot more receptivity to other forms of aggregation right now, class actions in everything but name. Because remember, the rap against class actions is that they compromise autonomy, the autonomy of the individual litigants, which we think is very important, and that is a very real problem. But remember, when the adversary of the plaintiffs is the one doing everything it possibly can to preserve the autonomy of the plaintiffs, it's a bit like the fox guarding the henhouse. And sometimes there is an equitable trade-off between autonomy and empowerment. Yes, it creates agency problems, and courts have been almost obsessed with those problems in the recent history of class actions. The Amchem case, the Supreme Court, no less, looking into attorney-client relationships, protecting the class members' rights, all of which are very important. But this near obsessiveness with protecting the autonomy of individual class members to opt out, to get individual notice, to be able to do things on their own, which is a matter of economic and practical reality, they can't do in the litigation system today because it's too expensive and too complicated and too hard. And so we see the very recent history of class actions going up to an apex of large verdicts, large settlements, important issues, probably by the mid-90s. Exxon Valdez, Marcos, the Engel class verdict, the tobacco litigation as a whole, through the very end of the 20th century. The Holocaust litigation settled in the year 2000. To a bit of eclipse in the early 21st century as we begin to experiment with any and every form of aggregate litigation except class actions, and beginning just last year and early this year with judicial scrutiny of settlements like Vioxx, Guidant, Zyprexa, all very good and necessary things. The beginnings of a notion that we ought not throw out the baby with the bathwater of class actions, and that the most problematic area of class actions, adequacy of representation, agency, attorneys and attorneys' fees, the level of court scrutiny, are really the things that make class actions qualitatively superior to other forms for the fair as well as efficient resolution or adjudication of mass problems, either in the torts, human rights, or civil rights arenas. Thanks.
Well, hello, I'm happy to be here, and very pleased to be on a panel with such distinguished folks, in particular Elizabeth, who is really a superstar in our field. I've been assigned to talk a bit about the commercial aspects of securities, of class actions, including securities. And I think I'm going to focus particularly on securities because I think it's fair to say that the securities class action is an arena that the forces of darkness first took on about 12, 14 years ago. And I think the bottom line is be careful what you wish for. So I think you're going to see some of the things they brought to bear in the securities context also being floated in other areas of class actions. And so I thought it'd be worthwhile to talk a bit about the background of securities class actions, the law that was passed in 1995, the Private Securities Litigation Reform Act, the PSLRA or the Reform Act, and what's happened since then, because it really, really changed the world in the area of securities class actions. Now, securities class actions, and I guess to paraphrase Churchill, it's the worst way to regulate the capital markets, except for all the others. If you have, let's really go out on a limb and talk about a passive Securities and Exchange Commission that might be in the pocket of corporate America, might be willing to look the other way on a lot of wrongdoing on Wall Street. If you can actually conjure up that hypothetical, then where do you look for folks to hold corporate wrongdoers accountable? And it might just be the securities class action. And I think that's really what's happened recently, in the last few years in particular. The SEC, the fabulous folks work there. There just are not enough of them, and they've been starved of resources, particularly in the last few years. And so it's more and more been up to the private litigants to fill the void. And even in cases where there's an SEC investigation and a securities class action, if you compare what's recovered for the investors, I think the record's pretty clear that the private litigation is much more effective. Now, just by way of background, of course, the securities class actions are primarily based on the acts passed in 1933 and 1934. There's fraud cases. There are Securities Act cases, which are essentially negligence cases based on new issues of securities. And under the Reform Act, what ended up happening that is of interest is that they made it much more difficult to bring these cases. By way of background, prior to the Reform Act being passed, there was a perception that these cases were strike suits, that any time a stock dropped, a lawsuit was filed, and these cases would be settled because companies didn't want to be distracted with discovery because it could be very, very expensive. I used to be, by the way, a defense lawyer at a major firm defending these. I'm a recovering defense lawyer and still in therapy. But the perception, whether it was right or wrong, the world changed in 1995. The only law passed over President Clinton's veto was the Reform Act. It was part of the Contract for America or Contract on America, depending on your political persuasion. And
And it did a number of things. It first of all made these cases very, very difficult to bring. In virtually any civil litigation in America, if you just have notice pleading, duty, breach, causation, damages, you're in. Go serve your discovery. Not so in securities cases. You now have to have very, very detailed, almost evidentiary pleadings, facts in your pleading in order to get over this very, very tough threshold. I know someone referred to the Tennessee Tuxedo cartoon before. Some of you may remember the Johnny Carson show. And he had this character called Karnak. And Karnak would put an envelope to his head, and he'd have to tell you the answer to the question in the envelope before he could open the envelope. Well, securities litigation is a lot like that. You have to persuade a judge that you know what document informed the CEO that their quarterly results were poor and he lied about it. Who else was on the email? Some judges have asked for date time groups for these things. You have to have very, very detailed pleadings before you're allowed to go forward with your lawsuit. And so this has resulted in 40% or so of these cases being thrown out, of the cases that are even brought. So there's this very, very tight screening device that was put in place in 1995, and I would submit has been very, very effective in screening out the frivolous cases. If you get over a motion to dismiss now, by definition your case is not frivolous. And how do you get this information if you don't have discovery? Because there's a discovery state. When a motion to dismiss is filed, you are not permitted to get a document or a word of testimony until you guess what's in the envelope. And so what do? Well, we depend on my favorite person, the disgruntled former employee. And that's the kind of person you have to deal with, and investigators and the media. And if you get over your motion to dismiss, then you can proceed. Another very important innovation of the Reform Act, and one that I really think was terrific, was the lead plaintiff provision. And this is something I think you may see in other areas of class action. Congress decided that and I think this goes to some of the suggestions we've heard. And by the way, Jeff, on your 4 suggestions, I'm no, 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 and no. But we can talk about that.
So I guess you like them.
It said, the problem here is that the real stakeholder in these cases are the lawyers. And so I have just put a marker down. I really believe that client involvement in litigating these cases and settling these cases is paramount. And in the securities context, I think the evidence is clear. When you have a large institutional investor in charge, monitoring the lawyers, you get good results. Better results than you would get if it was just the lawyers deciding. Anyway, so Congress said the situation is somebody has a share or 2 or 3. They become the lead plaintiff because they filed first. And at the end of the day, the company offers $10 million. The lawyers get 1/3 of that, so it's $3 million. How much is that to the investor? Do you even know the investor? Have you met the client? Those are the kinds of cynical questions I asked myself when I was a defense lawyer. So what they did is they said, no more first to file. We're going to put in place a 60-day period from the time the first lawsuit is filed, because there's always one filed. And at the end of the 60 days, people will declare, investors will declare, do I want to run this case or not? And the idea was to give large institutional investors, folks who had a lot of money at stake in these cases, to evaluate, is there a case or not? There's something a little bit ridiculous about an announcement at 8 o'clock in the morning and a lawsuit filed by 11 o'clock that morning. How good was that investigation? But, if you wanted to be lead plaintiff, lead counsel, you had to file. Now you have 60 days. We represent a lot of institutional investors. I know Elizabeth's firm does as well. They almost never file a complaint. They spend the 60 days to evaluate, then they file a motion for lead plaintiff, and the court is required to pick the plaintiff or group of plaintiffs that had lost the most money. Now, there are challenges to that, and they have to satisfy Rule 23, but in general, the client with the largest loss runs the case. So in WorldCom, for example, we represented the New York State Common Retirement Fund. They lost $300 million. They were interested in that case. They were a real stakeholder, and they were very, very involved, and they're the principal reason that case we drove that case to over $6 billion recovery. And which, by the way, we tried. I mean, I've tried a securities class action case. We settled before the verdict, but it was one of the rare securities cases that went to trial. So what happened here was the Chamber of Commerce and the other folks who don't like class actions saw securities as they could kill the securities class action through the PSLRA. What happened? It didn't turn out the way they thought it would. Why? Because a lot of institutional investors, primarily public pension funds, said, geez, we're fiduciaries. There's something wrong that happened out here. We're going to do something about it. So they got involved. They got involved for several reasons. One, to get money back for their beneficiaries. Two, to send a message of deterrence to other wrongdoers. Three, to get corporate governance, to have companies change how they do things so there's more transparency for investors and things of that nature. And four, frankly, to drive down attorney's fees. Because when you're a large institutional investor and lots of folks want to represent you because you're their ticket to get lead counsel position, there's competition. Now, you wouldn't, pick a heart surgeon based on the lowest, cost, and I don't think you should pick your securities counsel that way either, but it clearly has been a downward driver on attorney's fees. Next time you're reading the Wall Street Journal that a securities counsel get a third, check the date on the front page of that issue because they're backdating to 1994. I call it backdating the debate. That's just not the way it is anymore. So what ended up happening is you had these large institutional investors became lead plaintiffs. And if they know anything, they know how to be fiduciaries. And they say, Sean, what's this case worth in your estimation? We said, okay, I think WorldCom should settle for $3 or $4 billion. Go get it. Okay, well, no, go get it. Go try it. Yes, sir. And they made the decision. And they kept driving. And obviously the dynamics of that case changed, and we ended up settling that case in particular for billions more. So that could be a model for other class actions. But the criticism today from the Chamber of Commerce is that these cases are too successful. They're getting too much money back. Now, they don't call it damages. They call it a cost to corporate America. But let me just talk briefly about the deterrent aspect. In WorldCom, we did something that had never been done before. We insisted that the outside directors pay personally. Typically, they would pay insurance. But in WorldCom, the client and we said, if you couldn't hold the outside directors accountable in WorldCom, you could never do it. Now, there was no allegation that they knew about the fraud, but they were just absent. They were rubber stamping things for the CEO, and so we ended up insisting that they pay personally. And they paid 20% of their net worth, leaving aside their home and their retirement. What happened? Two things right away. The New York Times editorial page praised us, and the Wall Street Journal editorial condemned us. So we count that as two badges of honor. But interestingly enough, I started getting in the weeks after that copies of white papers from the white shoe firms on this island to all of their clients who were serving as directors on boards. And there were remarkable documents. They said, in light of the WorldCom settlement, we have the following recommendations, and they have bullet points. Pay attention at board meetings. Read the board materials before the board meeting. Understand what is being presented. My favorite, watch out for red flags. So of course, there was a lot of rigmarole, and I went to speak to a lot of directors, and I would start by saying, it's nice to meet you all before your depositions, and we'd have the little joke. And it may have chilled economic activity for a while. People were saying, wait, I don't want to do anything where I might get sued. But I said it to them, I'll say it to you. It should be extremely rare when directors are sued, or not sued, but when they are made to pay personally. Normally it's insurance. But it should be more than hypothetical. And that's what we did in WorldCom. And what I've heard is that we've accomplished our mission, which was to empower the otherwise timid director to speak up and say, wait a minute, not so fast. And same with the banks by making them pay so much because of their due diligence failures. We not only got a seminal decision on due diligence out of Judge Cote, but we also have, from what I understand, tightening of due diligence at the banks. So it ultimately, I think, affected how Wall Street does business. And for a while there, I was taking credit that fraud was down in part because of what we did. But, of course, fraud is back with a vengeance, and there'll be plenty of securities class actions to deal with concerning the subprime. The last thing I'll just say, there are a lot of threats still: class certification, loss causation, Chamber of Commerce, all those sorts of things, which I hope we'll talk about in the context of the panel discussion. Anyway, I'm out of time. Thank you.
Thank you all very much. I hate to cut anyone off, but we do want to have a discussion. Before I start thinking about your questions, I just wanted to pose a couple of initial questions before returning to some of these questions about B3 in particular with consumer and torts and so on. To come back to Elizabeth to the B2 class, which hasn't gotten as much attention here yet this morning. It seems that B2 class are being eclipsed by the B3 mass torts and consumer class actions and so on. And also, in my experience with the kinds of cases we do, which are B2 class actions, district courts seem increasingly reluctant to certify even those classic injunctive class actions against the government. Is that a trend? If so, why? Are you concerned? And then I'd like to hear from the other panelists as well.
Okay. It is a trend, and it's actually started in the 1930s when the federal courts merged law and equity. And you know what happens in a merger. Sean will tell you that. They're never a merger of equals, and somebody gets eclipsed. And unfortunately, equity got eclipsed. And so now, although federal courts consider inequity, and Rule 23b2 and b1 really are the quintessence of the equitable class action, judges tend to distrust and rein in their equity jurisdiction when they don't see any problem with authority over money damages. So what happens in the class certification battle is if you try to get a class certified under Rule 23b2 and there's money anywhere near the relief you're requesting, if it can be expressed in dollars, the courts say, oh, this is a suit really for money damages, you're just fooling about B2 or B1, let's go look at B3 in predominance, and then if you're bound and determined not to certify a class, you can use the extra requirements of 23b3 to avoid decertification. And we see this in the employment rights field, where courts will tend to look at almost any remedy, if they can, as a B3 remedy for money damages rather than an injunctive or equitable remedy, and they revert. In the mass tort field, there's a very important claim for medical monitoring, which is an ancient, negligence theory that if someone causes you to be at increased risk of harm through your fault. By the way, Ken Starr wrote the seminal decision upholding this claim back in the 80s when he was on the Court of Appeals. Then the person whose fault it was that placed you at the increased risk has to pay for your cost to manage that risk, to discover it, etc. It's called medical monitoring. It's a B2 remedy because it's a program that's under court supervision and control. You're not giving people money in their pockets. And while medical monitoring has had an intermittent ascendancy in mass torts, more often than not now, when courts look at a medical monitoring claim that has nothing to do with delivering dollars to the aggregated individuals, they will say, well, the defendant has to pay money, therefore it's a claim for money damages, therefore it's 23b3, therefore we can't certify it because it doesn't meet predominance. This is one more arena in which 23b3, the exception, has eaten the class action rule.
Richard, Jeff, do you want to comment on the trends in B2 injunctive relief class actions?
Yes, there's actually a couple of things that I'd mention. Is that one trend to be on the lookout for is the notion of actually having a B2 action for the kind of traditional equitable things like an injunction or a declaratory judgment, and having separately, although in the same proceeding, B2 treatment of the damage portion. And so, for example, you see in the Seventh Circuit an opinion by Judge Easterbrook, who's certainly not some huge proponent of class actions, actually overturning a refusal of a district judge to use this sort of hybrid approach and sending it back saying, no, this is what you should do. The case is Allen versus International Truck. On the medical monitoring question and how that fits under B2, this is a hard question under tort doctrine, and it's not particularly well understood. It's something that Sam and I and others have struggled with in the ALI project. But I think the crucial insight here is that because of the lapse of time from the exposure of the person to some harmful product or substance and the time at which they might, in the future, perhaps manifest disease, the idea behind medical monitoring is for the law to enjoin the company or person who caused the wrongful exposure to act affirmatively in that interval of time. And so if you look at medical monitoring as an opportunity for the law to impose an affirmative obligation, it exposes, I think, the underlying injunctive logic of that. If you're looking for support for that, there's an excellent article in the Virginia Law Review by John Goldberg and Ben Zapersky in which they tease out this sort of core injunctive notion of medical monitoring.
Jeff, any on the B2 injunctive relief cases in particular?
I have some comments about B3, but I'll hold them until you have your chance.
Okay. So any questions on that issue, on the B2 issue, before we turn back to, because I know there's been a lot of discussion. Vioxx was not a class action settlement. A number of people have mentioned that. What's the significance of that, and are there lessons to be learned about where we're going or how Rule 23 might be reconsidered in light of that? What happened with Vioxx for those of us who aren't immersed in that? Who wants to?
Well, I'm on the plaintiff steering committee in the Vioxx litigation, and there are others here today that know a lot about the negotiating aspects, even more than I do, of the settlement, some of which may not be for public consumption. But basically what happened in Vioxx is Vioxx was organized in the federal and state courts kind of at the low water mark of class certification of mass torts, to the point where the plaintiff steering committee in Vioxx did not want to make a motion for class certification of any aspect of the personal injury claims. Defendants insisted on it. The motion was denied as far as a nationwide class, leaving open smaller statewide classes. But the idea was that this was going to be an exercise in maturing the tort by having a series of bellwether trials in the federal and state courts. There were 15 trials. That would give monetary values to the cases and enable the parties to negotiate a settlement. And the notion was you would save the delay and complication of the appellate rights, which come from a class action settlement, by simply having a very large private contractual settlement that people would literally opt into. And the way the defendant gets world peace under that provision is by simply saying everybody's free to come in or not as they please, but we're not going to fund unless 85 or 95% of everyone that we know of comes in. That can work when you have an identified, not just ascertainable, but identified class. If the parties know who took the Vioxx and who is claiming injury. If the statute of limitations on individual suits have passed, you could look at the suits. So under certain conditions, you can recreate most of what you would get from a class action settlement in a non-class mass settlement. And that's what the parties saw the advantage of Vioxx. Get the money paid over, get the money to the class members. Don't let what happened in AmChem happen, where a few people or even many people could oppose the settlement from within the class, send it up the appellate ladder for 5 or even 10 years, and delay the day of payment to everyone. So there are attractions to plaintiffs as well as defendants in certain cases in avoiding the class mechanism.
Could I make a point about B2?
Jeff, yeah, if you want to.
I just, as long as you asked, I just want to mention some interactions between B3 and B2. I think that's important for B2. So it turns out that it's increasingly difficult to get a B3 class action certified for all kinds of reasons. What's the game at that point? The game for plaintiffs' attorneys is, okay, if I can't get it certified as a B3 class action, maybe I'll try to get it certified as a B2 class action, as an injunctive class action. How am I going to do that? Well, the way to do that, one way to do that, is to try to rephrase your damages relief as injunctive relief or as equitable relief. So let's say instead of asking for damages, I'll ask for disgorgement. And disgorgement I can class as an equitable remedy and try to get a B2 class out of it. Now, I think there's two problems with that are quite dangerous that haven't developed but ought to be thought about. One of them is that when a plaintiff's attorney recharacterizes a damage class action as an equitable class action, there's a risk that they'll be giving up real and substantial rights for the class, that is, rights to damages relief, in order to get the class certified. And that's a problem that has been growing in the class action area. The other is that when damages class actions start to be recharacterized as equitable class actions, there's a risk that the courts will begin to question the certifiability of equitable class actions in ways they haven't done before, because they'll view them as alternatives to damages class action. So just for example, the Amchem case, which was a damages class action, the Supreme Court was very keen on ensuring that the lawyers for the class not have a conflict of interest. Well, there's many equitable class actions, including many civil rights class actions, where lawyers have very significant conflicts of interest among different aspects of the class. So if the Amchem rule, which was in damages, gets transported over, gets imported into the area of equitable or B2 class actions, there's a significant risk that the problems that have occurred in the area of conflict of interest for damages class action are going to apply there too, and that could be quite detrimental to civil rights class actions.
Just a thought on Vioxx, and it does tie back to kind of the intellectual legacy, such as it is of the Amchem Products decision. Elizabeth's comments describing the Vioxx deal, I think, are right on point. Right? The method of closure that is used in the Vioxx deal is not a bankruptcy, is not a class settlement. It is a series of contractual agreements with the leading plaintiffs' law firms that have large inventories of Vioxx claims. It plays upon the concentrated representation of Vioxx claimants and uses these contracts between Merck and the firms as a method to drive the settlement. The contracts do not actually settle any individual Vioxx claim. That's the interesting dimension of the Vioxx settlement. Why are we in this rather odd world where you have to go through this kind of indirect circumlocution of entering into a contractual agreement with the major plaintiffs' firms involved? Why not a class settlement? Well, that's very much where we are post-Amchem. As Jeff mentioned, it is very difficult to have a nationwide class settlement under Federal Rule 23 post-Amchem. So let's just think about it. Let's just think about the rather odd world we're in. We're dealing in the mass product situation with potential multi-billion-dollar liability, potential multi-million-dollar, billion-dollar transactions, these sorts of settlements. And here's what we've effectively said in the law, right? You can put the company into bankruptcy, which might be very unattractive when the liability is not necessarily firm-threatening, or you can explore these sort of outer reaches of legal ethics and the aggregate settlement rule by going about a settlement through this kind of indirect means of contracts with the major attorneys involved. Oh, but here's the one thing you cannot do. You cannot actually present this settlement in a public hearing in front of an Article III judge with the accompanying relatively well-understood set of procedures that have developed under Rule 23. That's the one institutional arrangement that you cannot use. That, I dare say, is a very peculiar menu of choices. And that is why I think Elizabeth is right when she says what we're seeing is methods to get something like a class settlement through other indirect means. Perhaps that should make us look back now 10 years or more after the fact and really scratch our heads and ask ourselves whether Amchem was really an advance in our thinking about class actions or perhaps a step backward.
Sean, you said that you disagreed vehemently, I think, with all four of Jeff's suggestions. In a minute or less, or 2 minutes, can you enumerate why? And then Elizabeth, Richard, and Jeff, very briefly.
Well, I think the theme that runs through my problem with it is the role of the individual class member and client. First of all, on notice, I think notice is not simply to give people the opportunity to opt out. It's also to let them know that they can claim, and also to object. They may have a problem with it, and so. And I guess maybe I'm thinking about the cases we handle, which are fairly large. The mailing is not that significant. I will say, to follow up on something Ken said earlier, we use the web a lot. We, in our bigger cases, set up websites for that litigation. It has claim forms. We have updates on what's happening, and it's a resource for the class members. The two of them dealt with the named plaintiff and then auctions for counsel, which seemed to me to be feeding right into what was a major criticism of class actions, is that they're lawyer-driven vehicles, not client-driven. Certainly in the securities context, the role of the named plaintiff is paramount. You can look at the data that if you have an individual, not a real big stakeholder as the lead versus a state pension fund as a lead, there's a very different set of results. Why? This is more than a minute. It impresses the defendants. It impresses the judge. When you stand up in court and say, I represent, the Ohio pension funds, that means something to a judge. And also, if you have to, a jury. And, WorldCom, we told them we represent the New York State Common Retirement Fund. It has an effect. So it drives settlements up. Auctions, bad idea. If you believe that clients should run cases, not lawyers, then if a client is appointed, the client should be able to pick its lawyer. That's a fundamental. You can't, in Sendent, the judge had an auction. Our client was appointed lead, our clients, and what we were given was the right to match the lowest bid. But the client, we took that up to the Third Circuit, and the Third Circuit said not so fast. There is a right. A client has a right to the attorney of its choice. So if you believe that clients matter, then I think Jeff's got, ideas have some traction. My experience, clients matter a great deal, and lawyers, I don't want to, there are some securities lawyers who have said in the past that not having clients is a good thing, soon to be disbarred lawyers. Clients are important in the securities context, so that's where I come out of that.
I think I either agree with half of these or half agree with all of these. I'm not sure which it is. Notice, the best practicable notice is important. It's a due process matter. Making the other side spend the most money on notice is not important, and it can be dysfunctional. There's so many opportunities to give effective notice now at relatively low cost. The internet was mentioned. Hopefully more and more people will be connected to that. But there are other creative means to give notice. We have an excellent rule in California for class actions, and that is that the cost of notice has also got to be proportional to the amount involved and at stake. And that is due process at a very real, practical level, because you don't want to price litigants out of court by imposing, as a matter of due process, noticed costs that they simply can't meet. So form and cost follows function in class notice. I worry about named plaintiffs. Maybe I shouldn't have to, but an inordinate percentage of my class actions seem to go to trial. And I'll tell you, in the courtroom at trial, the jury wants to know where the plaintiffs are. They understand it's a class action, the judge tells them, but they want to know and they want to hear from the plaintiffs. Do real people care about this? Did real people care enough about this to put themselves forward, put their name on a suit, be deposed, stand up against a major corporation or an institution or the government, and be heard? Courtroom is where truth speaks to power. Somebody has to be there to tell the truth from the plaintiff's perspective. And people usually don't count primarily on lawyers to tell the truth. Don't ask me why. It's better to have a plaintiff. With respect to auctions and other ways of satisfying the obsessive and I think legitimate concern of courts with whether class counsel are going to be loyal to class interests in the aggregate, Rule 23G, relatively recent amendment, takes care of that. It gives courts a way to look at class counsel candidates early in the litigation. It parallels in many respects the PSLRA and does almost apply the lead plaintiff principles to all class actions. And so now at the outset of the suit, courts have to look at the level of investigation, the level of resources, the level of experience of class counsel, and courts can set class counsel fees in advance. They usually don't, but they can, and maybe they should. They don't have to use auctions to do it. They can use market rates and market forces to do it, to make sure that transaction costs are controlled.
Richard, briefly, or Jeff, a response there?
Well, my response to Sean is, first of all, he gave a quadruple negative, which actually I interpreted as a positive. I should have said at the outset that I was not talking about securities class actions. I should have excluded
Oh, then
that.
I take it all back.
And then I think Sean would be
They're
much happier. I'm talking about large-scale consumer class actions, not securities class actions. I should say, though, I do think, Sean, you overstate the benefits of the lead plaintiff provision in the PSLRA. There is a lot of evidence about the PSLRA and its performance, empirical evidence. There is some evidence that counsel fees are slightly lower when institutional investors are lead plaintiffs. However, that could be due to the fact that better cases are chosen that are easier to litigate. Overall, there is very little evidence that the PSLRA actually changed anything. Counsel fees are virtually identical after the PSLRA as before the PSLRA, and the PSLRA did not have the effect that was anticipated of opening up the plaintiff's bar to new entrants. In fact, it's increased, I think, the concentration of the plaintiff's bar by creating a barrier to entry into this kind of litigation. So while I think the jury's out on the PSLRA, I'm not really against it. I think that, Sean, in my opinion, you've exaggerated its
Well, if I could
value.
I couldn't disagree more.
You probably could.
No, I think.
Let me make a suggestion. Let's take some questions while you're thinking about how to. Let me start taking questions over here, and I'll move around. Try to keep them really short and address any particular person.
Mr. Miller, I also your article said something that just contradicted part of the article. The accuracy of one of those articles you said silly.
I take the last refuge of a deponent, which is I don't remember what I said in my Chicago article. So you'd have to show me where I said it was silly. Okay.
Yes.
Opt-outs largely have a lot of data. Basically, for liability, they're opting out opt-out means that that's transaction.
Right.
You see it red, transaction down in many cases. Lead players opt out fast, or relatively small fast action actually down
Yeah, I think there's a thread of that. I think we have clients that we give counsel to about thinking seriously about opting out. I mean, if you, I may be completely wrong, but if you believe that having a large institutional investor as lead plaintiff with capable counsel is a guarantee, is a virtual guarantee that the class will get the best result possible. In contrast to Mrs. Jones from Oklahoma City, whose lawyer somehow got appointed lead, where maybe you're not as confident, then maybe you stay in the class action. That depends also on damages, on unique defenses. A lot of clients, if you were going to opt out, you're going to be deposed, as opposed to being an absent class member who, at the end of the process, files a claim. But there are instances where it clearly makes sense to opt out, and you're going to see more and more of it. I'm not ready to ring the death knell for securities class actions, but also attorneys' fees might be different. There are a lot of different pieces of it. This opt-out phenomenon is a creation of the defendants making. When they decided to pay more, it's up to individual opt-outs in some of these cases. how could you, you really made it more likely for people to opt out. I mean, why wouldn't you? So, okay. Question?
Yeah, here.
Well, maybe it's because underwriting fees there are 4% as opposed to 7% here. There isn't a single allegation, sir, about any lawyer getting a case from that man because of, you're talking about vendors on Wall Street, just to be clear, because you're throwing out a lot of, I heard you before, be very careful on who you paint with that brush.
Okay,
Sarbanes-Oxley, the primary reaction I have to it is it's made the auditors rich, okay, which is ironic because Sarbanes-Oxley so increased the requirement for auditors to do work that they're making more money than they ever have. And it's ironic because Sarbanes-Oxley was passed in the wake of financial disasters that were caused, in my opinion, because the auditors weren't doing their jobs. But I do think Sarbanes-Oxley was one part of three main reasons why fraud went down for a while. It made people understand that they would be held accountable by having to sign these certifications, as well as the other things, internal controls and auditors having finally been cured of the consulting virus, or at least for a while, so they'd actually be auditing instead of cross-selling their consulting arms. A second piece was these mega settlements in some of these cases. They actually did get Wall Street's attention in Enron, WorldCom, Tyco, Adelphia, Nortel, goes on and on. And the third is some people went to jail. But unfortunately, in an era of deregulation, when only a year ago you had Bloomberg, Schumer, and the Paulson Committee and the Chamber of Commerce saying everyone's going to Europe because of too much litigation and too much regulation, we now see, what happens when people aren't paying attention. I mean, I thought Richard's comment about our society is less regulation up front and more trying to put it together, compensate at the end. I think that we're seeing that playing out right now. And I disagree with a lot of your factual premises about why people are going to London.
We have a few more minutes. How many questions are there? I just want to try to get a few out on the table. Let's put all three out and then get answers, and then I think we have to break for lunch. 1, 2, and then 3 here. Sir. Yeah.
I'm wondering whether a mechanism similar to that in Florida makes sense, whether class action will be very wary of class action weighted according to the and there are very serious tensions in class and how class I actually think that that's qualified are small entities or associational entities representing the group.
While you're thinking about that, let's get the second question out and then the third.
I wanted to ask about positive mechanisms.
And the last question, please.
Well, jump in on Stone Ridge, which is the Supreme Court decision in January that essentially read scheme liability out of securities cases. In other words, my bottom line answer is in Stone Ridge, the Supreme Court made the world safer for those who profit by helping other people cook the books as long as they keep their mouths shut. That's the bottom line of Stone Ridge. Ironically, that hurts the other folks who actually speak, including auditors, but that's my comment on it. But the quick answer to your question is that Congress has answered that by saying you can't do this in state court anymore. It's essentially a fraud case in connection with security, sale or purchase of security. They have, consistent with Republican ideals of federalism, have taken that away from the state courts. SLUSA, correct. You can still bring a Section 11 Securities Act claim in state court, but not a fraud claim. My take is that you can't do common law claims. It's a screening device. It was needed, in my view, having been on the defense side. It has overcorrected. Good cases are being kept away, are being dismissed. It's a cost to the system. I don't have a problem with that, except in the cases where I get thrown out. But if you get over that, it's almost by definition you have a non-frivolous case. And usually an institutional investor that, despite what Jeff thinks, is driving down the attorney's fees. And generally, one of my clients is laughing. You heard what he said, right?
Let me take quick closing comments on the questions from Elizabeth, Jeff, and then Richard.
Okay, the preemption problem. Okay, you can have ex ante regulation, or you can have ex post regulation, but you can't have neither. And that is the preemption problem. That preemption is coming up as the favorite issue of the Supreme Court, second probably only to punitive damages, at the precise time when the FDA, which is charged by law with protecting all of us from bad drugs, has never been weaker. They're heroic over there, but they don't have money, they don't have personnel, they don't have power, and they're being lied to by commission and omission by very powerful interests. Look, I love free enterprise. It's driven our prosperity. It's a wonderful thing. I'm probably a libertarian/populist. But there's a rule. If you live outside the law, you must be honest. And when you're not honest and you're very powerful, you have to have at least a little bit of ex post regulation. And that's why I think we're going to see a revival of formal, good old-fashioned, classic class actions as long as there's any little bit of substantive law left, because the public itself, the people themselves, are going to have to protect themselves when agencies can't or won't. So, a stronger FDA, I'd love to see it. Congress hopefully will help us on that after the next election, but Congress is also going to have to make it very clear to the Supreme Court, which always defers to Congress, that there is not preemption in this field, that you have to honor substantive tort law, substantive consumer law, which is primarily state law, and let people protect themselves if it turns out the agencies have been lied to or gamed.
Jeff? Well, I guess I'd like to say that I think we're at a point of, if not crisis, at least decision about class actions, that it's time maybe to revisit Rule 23 and think about how the elements work and how they work together, and maybe think about what kinds of reforms might be useful in a more fundamental way. I also think that the current trend in class action litigation is disturbing if you're concerned about protecting rights of consumers. The difficulties of getting cases certified, especially damages cases, are increasing over time, and effectively the jurisprudence in this area has created for judges the effect of a discretionary screen. In other words, the judge, if the judge doesn't like the case, feels that it's not worth bringing, has the ability to basically screen it out by refusing to certify on discretionary grounds that are reviewable on appeal only on an abuse of discretion standard. So I think we're at a time where it's very useful for us to reconsider the class action as a whole, and in line with what Richard said at the beginning, to really view it in the context of the overall menu of devices for social control and protecting consumers that exist in the society.
Just a couple quick thoughts on preemption, which is a huge topic and certainly does, as Deborah quite rightly pointed out, intersect with our questions of class action litigation. The first thought is that I think what we may be gravitating to, we're all awaiting, of course, these important Supreme Court decisions, but I think what we may be gravitating to is a more precise understanding. If you looked at the sort of questions someone like Justice Breyer is asking in these cases, to ask ourselves what sort of administrative action really ought to have preemptive effect. And so I think the more tailored and I think precise argument for preemption focuses on situations, and these are rare, but they do occur in the antidepressant litigation, for example, in which you do have meaningful post-marketing surveillance by the agency. The Clinton administration took a look at antidepressants and decided that at the relevant time, the science didn't support a connection between the product and an increased risk of suicide. It seems to me that when you do have meaningful administrative action at the post-marketing stage, that cannot have just no consequence at all for litigation. The second thing I'd say about preemption is that there's an underlying conceptual tension here, and it has to do with the way that we've thought about tort law for a long time. Ex-ante regulation and ex-post regulation come into conflict. That's what we're seeing in the preemption doctrine. But that is only so if we think of tort law as primarily a privatized means of regulation. And there's been a lot of theoretical discussion here that is driving this very practical debate. If we don't think of tort law chiefly as privatized regulation, as the private attorney general, but rather a more, I dare say, 19th century notion of private redress, of an opportunity for someone to seek to vindicate their claim for redress in a manner that's independent from the government, that is truly private. It seems to me that there would be less of a tension in terms of concern over private regulation by way of tort litigation somehow reaching different conclusions than public regulators have reached. So there's an underlying sort of problem here in the way that we've thought about tort law, really dating back to Holmes and the common law. And that's why we see it manifesting itself in this preemption debate today.
Please join me in thanking this fabulous panel. And eat your lunch a little faster.
Moments here to tell you something about public justice. Arthur Bryant, who's the Executive Director of Public Justice, as I mentioned this morning, had planned to be here. He was actually going to be on a panel. He had a personal matter he had to attend to in the West Coast and couldn't get here. I am pleased to tell you that our current president, Sandra Robinson, is here. Hello, Sandra. For those of you who don't know, Public Justice is about a 3,000 lawyer, member-strong public interest law firm. We consider ourselves America's public interest law firm, the largest of its kind. It has an extraordinary staff of lawyers. You're going to hear from Leslie and Paul this afternoon. Among other things, the project the Public Justice does, it has a class action preservation project as part of its Access to Justice program that deals with a lot of the issues we're talking about today, including arbitration issues, which Paul has become one of the nation's leading experts on. So I encourage you to read more about Public Justice and talk to Sandra at a break if you wish. About our organization or the staff lawyers. Thank you for being here. It's my pleasure to introduce to you our moderator for our next panel. Professor Seebach is a professor here at Cardozo Law School. He is one of the nationally recognized experts in tort law, has authored numerous articles about mass restitution litigation, including lawsuits involving tobacco, handguns, slavery reparations, many other things. His casebook, Tort Law Responsibilities and Redress, is one of the most widely used in leading law schools in the United States. As with all of our speakers, I could go on, but I think with that I will turn it over to Tony to lead this fantastic panel.
Thank you. Thank you very much. I just want to extend a special thank you to Professor Miriam Gillis for helping to bring this conference into fruition, and to Cardozo for supporting it. She and I share a conviction that this is one of the most, meaning the area of private law litigation as it relates to individuals who have been harmed or claim to have been harmed, is one of the most important political matters that this country has to deal with today, and the fact that the institution for which we work supports serious scholarship in this area is something for which we're very grateful. Now, I'm going to talk briefly about the topic of today's, or this afternoon's panel on contemporary challenges. And then I'll introduce our speakers. And then after they speak, I will try to be a kind of a traffic cop to help them talk among themselves and to talk to you. Now, really briefly, what I understand our mission for this panel to be is to talk a little bit about what has happened in the recent past and how have changes in both formal and informal approaches to class action litigation been received by the lawyers who work in this area. Perceived abuses of the class action, some of which you heard about earlier today, and many of which may or may not be spurious, especially in consumer non-personal injury context, has led to criticisms from at least two directions. First, there have been criticisms of the so-called lax enforcement of existing rules by state court judges, which have arguably enabled certification of class actions that should not have been certified. The second criticism has been that class settlements were not benefiting the class members themselves, for which the device was created. Now, responses to these criticisms have taken many forms. Some formal and some informal. One example of a formal reform, which many of you are familiar with, I'm sure, is the Class Action Fairness Act of 2006, which, among other things, makes it easier to remove a class action to federal court from state court. An example of informal reform, or reform coming from below, informally, is the increase in sellers, people who sell products, demanding that a consumer waives his or her right to participate in a class action at the point of purchase, a point at which I'm sure almost none of us ever think about what we want and don't want if we ever become members of a class. To discuss this and other aspects of these reactions to the class action as it's developed, we have a great panel. I'm going to introduce all of them at once. I'm going to go down in the order that I've been led to believe they are to speak. First, we have John Beisner, who heads O'Melveny & Myers' 120-member class action, mass torts, and aggregated litigation practice group. He specializes in defending class actions, mass torts, and other aggregated litigation. Over the past 29 years, John has been involved in defending over 600 class actions in federal and state courts in 40 states, covering a variety of subjects, including antitrust, employment, environmental, and securities. Following John will be Leslie Bailey, who's a staff attorney at Public Justice. Her specialty is in consumer rights issues. She mentioned to me that what perhaps distinguishes her from virtually anyone in this room is that she's actually tried a class action suit in federal court involving WTO protesters. She's also the co-author of a book entitled Consumer Arbitration Agreements, Enforceability, and Other Issues, and numerous articles. Now, following her shall be Professor Miriam Gillis of Cardozo Law School and my colleague. Her areas of interest include civil rights and structural reform litigation, tort and litigation reform, and class actions. Her articles have appeared in, and this pains me to say this, Columbia Law Review, California Law Review, Michigan Law Review, the Penn Law Review.
Oh, you mean not Cardozo Law Review?
Oh, yeah. Soon. And she has, in many of the scholarly journals, she has served as chair of the civil rights section of the Association of American Law Schools. And in 2004, she was a visiting professor at the University of Virginia, and in 2005-2006, she was a fellow in the program of Law and Public Affairs at Princeton University. Following her is Robert Eisler. Robert Eisler is a partner at Cohen Milstein Household & Toll, where he joined in 2007. He's a member of the Antitrust Practice Group and is the resident partner in New York. Prior to joining Cohen Milstein, Mr. Eisler was a partner at another firm we may have heard of, Leif Cabrizer. Mr. Eisler has extensive experience in complex litigation at the trial and appellate levels, particularly in the prosecution of antitrust class action. He has served as lead or co-lead counsel in many, many cases in state federal courts, including the In re, I'm going to get all these wrong, I think. Okay, in many cases involving complex chemicals whose names and components I couldn't recognize or pronounce. And finally, we have Sam Zakharoff, the Reese Professor of Constitutional Law at New York University. His research deals with issues in civil procedure, especially complex litigation and class actions, law and economics, constitutional law, particularly with regard to voting rights and electoral systems and employment law. He currently is the reporter for the Project on Aggregate Litigation of the ALI. Professor Zakharoff began his teaching career at University of Texas in 1989, where he held the Joseph G. Jamail Centennial Chair in Law. He moved in 1999 to Columbia, where he was the Harold Medina Professor of Procedural Jurisprudence before joining NYU recently in 2005. Each speaker will, I think, have about 10 minutes to speak, and then we'll hopefully have time to talk among ourselves. Thank you.
I will begin.
You want to stand or stay?
I can stand. Well, there were basically three observations that I wanted to put on the table today, which I suspect may engender some further debate, but three basic observations that I wanted to make. The first is about, as was referenced, the Class Action Fairness Act of 2005, which has been with us for a couple of years, and in terms of contemporary developments in the area of class actions, I think that's probably got to be viewed as one of the most significant. The main observation, though, I wanted to make about it is that I think that this was an area of extremely heated debate several years ago when it was enacted. I think that there were some critics of the bill who said this will be the end of class actions, and at the other end of the spectrum, I think there were some advocates who were favoring the bill who were saying, well, this will wipe out class actions. We won't have to worry about that anymore. I'm not sure that there weren't a lot of qualifications to that, but there was basically, I think, pretty aggressive advertising on both sides of the issue. And I think that at the end of the day, what we're seeing so far, although I'm not sure all of the ramifications have been seen as of yet, I think that the bill has done sort of basically what Congress was intending. It is opening the doors to federal courts to allow more class actions to be filed there. The Federal Judicial Center has issued a number of reports satisfying the provision, the very last provision in the bill that required the federal courts to look at what the impact of the bill was on the federal court system. And the fundamental result is that more class actions are being filed in federal court or are being removed to federal court, but not this daunting tidal wave that I think were predicted by some. Some of the statistics indicate that perhaps 2 or 3 additional class actions are being filed or being heard in each district as a result of the legislation. So I guess one of the patterns that I've been observing, and I can't figure out what the statistical analysis you'd have to do to find this out, but my sense is that a lot of counsel who are looking at filing class actions have simply decided to go ahead and file them in federal court. It's interesting that if you look at what the debates have been about CAFA, what the appellate courts have spent most of their time looking at, it hasn't been about what new class actions will be heard in federal court, It's the debate that has come up among a number of creative counsel who are trying to argue for applicability of the statute to actions that existed before the bill was enacted in mid-February 2005 and was supposed to be then effective as to class actions filed thereafter. And so I think that the actual implementation of the bill, if you leave aside these debates about existing class actions, has been relatively smooth. The second observation that I wanted to make, somewhat unrelated to CAFA itself, is on the subject of injunctive relief. And I guess what I would like to unburden myself with today is a comment that I have been tempted to make in litigating class actions for years, but have never been felt comfortable saying it in the context of a specific class action. It's as follows. I've often been in meetings with opposing counsel, myself normally being on the defense side of these things, indeed invariably being on the defense side of these things, when counsel have said, well, my primary purpose in filing this case is to stop your client from doing X. That's my job. That's why I'm here. And what I've often wondered is, if that's the case, why haven't you just filed an injunctive relief action? If that is your real purpose, what is all this business we have here about damages? And indeed, in a lot of those cases, I'm not sure a class action would be necessary. A lot of the cases I've been in, you wouldn't have to go through Rule 23. If you've got an affected party, you file for an injunction and probably would have broader relief on whatever class you'd file on behalf of. It's just one of those issues that has made me wonder what the real purpose of the class action is. I'm not saying that's true in every case. There are cases in many instances where there are potentially substantial damages. I don't mean to apply that comment to class actions generally, but there are some where you have an issue that is ongoing, where you do raise to yourself the question, if the purpose here is to stop this practice, stop the sale of the product, why is that not the primary focus of the litigation? Which brings me to my third observation, which may be in part an answer to my second observation, and that is that I think going forward, one of the great challenges to the class action device and the public perception of that device is currently and will continue to be the subject of attorney fees, which I think is in part the answer to my injunctive relief question, because if that was what you asked for, counsel bringing that case, I think, would perhaps have a more difficult time under our current system of securing the fees that he or she might have in mind in securing in that case. But the general fee question I want to raise is the following, and that is, I find there to be a substantial disparity in our contingency fee system between what goes on in individual cases and what goes on in class actions. I may be corrected by some of you as to the precision of my data, but I think that in most jurisdictions, what the states, and it varies some from locality to locality, but I see a range out there of contingency fees in individual cases being in the 25 to 40% range. Some cases it's lower, depends on what the agreement is up front. There may be cases that would take it to a different range, but that's fundamentally what's out there. Then you come to the class action world, where at the end of the day, admittedly, the fees that are awarded in cases where the fees are awarded on the basis of a percentage of the common fund are somewhat lower, but in a lot of cases not dramatically different. And the disconnect that I see is the following. That is that when you go into court and argue over class certification, the main argument that's being made by the proponent of class certification is we need a class because of the efficiencies that it provides, that the class device would provide in this instance. If you don't certify a class, each of the class members would have to go into court separately and seek redress for whatever wrongdoing has been asserted. And that would just be entirely too expensive. In some cases, it would be a negative value situation. But there will be a great efficiency in litigating this matter on a class basis. Then you get to the fee stage of the litigation if there's a settlement, or if in a rare case there is a trial of the matter. And that efficiency notion disappears. There ought to be, in my mind, a substantial discount of what that fee amount is if, in fact, this has been so efficient. The percentage of the overall fund that will be taken from the class members and given to the lawyers in that case ought to be significantly less. The class members ought to benefit from the benefit of that. Now, I've had this discussion with some of my friends who practice on the plaintiff side, and they said, well, why are you making that kind of argument? Because you know that if those fees percentages came down, we would simply argue that the settlement amount needs to be greater, which again indicates to me the concern I have that so much of what goes on in the class action world in terms of assessing fairness and determining results is really driven by the fee component. I think that was a major concern, a major catalyst in Congress moving towards adopting the Class Action Fairness Act, and I think that's a problem, a contemporary problem in class actions that will continue.
I'm here to talk about what I think is the single greatest challenge to contemporary class actions, and that is contractual class action bans. This came up earlier in this morning's presentation, and these are literally in virtually every contract that's out there. The 10 major credit card companies all require you to waive your right to bring a class action. It's impossible to get a bank loan, to buy a computer, to get a cell phone contract, to get long-distance service, and increasingly to work for a major corporate employer. And as a public interest lawyer, I cannot emphasize how strongly I feel that class actions are more important now than they have ever been, and not just because consumers are, drains are breaking and need redress for that, but because of the types of corporate abuses that we see happening that nothing can really address better than a class action. And, other panelists have already talked about some of the reasons why we need class actions, but just to throw out a couple numbers, a third of the profits of the credit card companies today is in late fees. We have payday lenders who are charging 1,300% interest and rolling over 19 out of 20 loans because the debtor can't afford to pay it back next week. We have employers who are miscategorizing employees as exempt and denying them overtime pay. And meanwhile, as Elizabeth Cabraser alluded to, and I think Sean Coffey as well, regulators are not seeming too keen to do anything about this. If you just look at the OCC, the federal agency that's supposed to regulate national banks, this is an agency that markets itself to the banks by claiming that if you are regulated by us, we will protect you from state consumer protection laws. And indeed, the OCC goes around filing amicus briefs in these cases arguing that the consumer state law claim is preempted by federal law. So especially in a lax regulatory environment, class actions are extremely important. So is it legal for a corporation to ban class actions? This is absolutely one of the hottest consumer law areas being litigated today. It's a question of state law. Generally, these terms are tucked into an arbitration clause, and under the Federal Arbitration Act, the enforceability of a term in an arbitration clause is a question of generally applicable state contract law. So these things are valid or invalid just on the grounds that any other contract term is valid or invalid. And most states have a common law rule that says that you can't impose an exculpatory clause on somebody. I can't go to contract with you and say, this is a take it or leave it contract, non-negotiable terms, and I can do anything, I can break the law, and you cannot hold me responsible. That's the traditional idea of an exculpatory clause, an express clause. Class action bans are less forthcoming, but they accomplish the same thing in certain circumstances. how is a class action ban exculpatory? Because people don't bring these types of claims on an individual basis. They simply don't do it. Why not? I think many of them may not realize that their legal rights have been violated absent a class action. Or if they do realize that something wrong has happened to them, they may not know how to articulate a legal claim. And so with many of these kinds of claims, a class action is the first that a consumer learns that she may have a claim. Second, even if you realize that you have a claim, many of these people cannot find lawyers to represent them. We had a payday lender case recently in which a legal aid lawyer testified that she has members of the military coming into her office all the time who have been victimized by abusive payday lenders. And she will try time and time again to refer them to a consumer advocate who will take them on an individual basis, and no one can. There just is not a bar of consumer lawyers who can make a living taking claims for $10 or even $500 and count on a court, or in many cases an arbitrator, who's not even required to follow the law, to award attorney's fees. Okay, well, why not sue without a lawyer? Well, I mean, these are often very complicated claims. They're not the kind of thing where you can just walk in and say, this happened, give me my money back. A lot of these corporations raise very complicated federal preemption defenses, and it's simply very daunting for the individual to think of taking on, Singular Wireless on her own. And those are just a few examples from the context of small consumer claims, but if you think about it, there are other factors in the employment context, for example, that could also make a class action ban exculpatory. Employees might be afraid of retaliation if they bring individual claims, for example. You may wonder, well, why can't the Attorney General, of the state bring these claims? Why do you need consumer class actions? We've had attorney generals in several states come in on our side and file amicus briefs saying, we do not have the resources, we depend on the private class action bar to help us ensure that consumers are protected in our state. And this is why corporations put class action bans in their contract. It's much easier for them to fight an individual consumer on a case-by-case basis while continuing whatever practice or policy was in place and never stopping them. In the meantime, $10 each from 1 million different people is a lot of money. So the good news is that more and more courts across the country are recognizing that these things can be, in certain circumstances, a get-out-of-jail-free card for the corporation. For a while, a lot of courts were upholding them, but recently the tide has definitely turned. Just within the last couple years, the First Circuit, Ninth Circuit, 11th Circuit Court of Appeals all came down, striking down exculpatory class action bans. Several state Supreme Courts, most recently Illinois, New Jersey, and Washington, with California, of course, having been the first in the Discover Bank case, which was actually litigated by my colleague Paul Bland. Several state appellate courts, Florida, Missouri, Ohio, Oregon, Pennsylvania, so there are a lot of good cases coming down. And the split that exists is mainly on state law grounds. But if you look at the trend, I really think this shows that courts are recognizing the value of class actions as essential and seeing that they're not merely something that a corporation should be permitted to unilaterally wipe away. I just want to make one quick point about CAFA. I don't see CAFA as simply, something that's just a mere transition that's not really affecting cases. There's a public citizen report that came out that demonstrated that 500 lobbyists worked on behalf of the bill and only 12 lobbyists on the consumer side against its passage. And if you look at what's happening, what we'll see in some of our cases is a state Supreme Court will find that a class action ban in a consumer contract is exculpatory under state law, and then the next court that looks at the same issue is a federal district court. This happened with the New Jersey Supreme Court case in Muhammad, which we won. But then American Express tried to invoke a Utah choice of law clause in its contract, and the district court bought it. This happened in California until very recently, when the Ninth Circuit dismissed this whole idea in the Schroyer case, and there are several cases currently pending in Washington where the same thing is playing out. So for big corporations, the ability to have cases in federal court seems to be a boon, and so I just don't think that CAFA is this sort of gentle thing that we might otherwise think it is. And I'll stop there.
Hi, thank you. I'm Miriam Gillis. I want to thank everyone for coming. I know there's been a lot of thank yous of me. Thank you for thanking me. I also just want to thank, I do deserve all that credit. I just want, this is my first conference ever, so I want to just thank all the people who helped me, Praveen Fernandez, Virginia Steve, all the students who are helping today, and of course all of you for coming. This is, so far I think this is great. Hopefully this will not be the low water mark you're about to experience right now. So I want to talk a little bit pick up where Leslie left off in her discussion on class action bans. Because it's just sort of it's fascinating to me that so much has changed. A couple of years ago, I wrote an article. It's actually in your materials on these bans, and things look much different just a couple of years ago. And as Leslie notes, much has changed in just the past 2 years. In 2005, class action bans were routinely being upheld. And the traditional state law unconscionability challenge that Leslie focused on and the public justice has had so much success in litigating and challenging was really being rejected by the majority of states. And so we've really seen a turnaround in that particular argument having some traction in the courts, particularly the state courts. Back in 2005, when I first looked at this, I wrote about a second wave challenge that I thought might have some traction in the federal courts. And really at that point it had only been made in one district court and had been unsuccessful in that district court. So this was sort of a classic sort of law professor musing about what could occur. So I just want to sort of update you that this second wave argument has had some traction, sort of fill you in on that. Just to step back from it, back in Mitsubishi Motors, a Supreme Court case from 1985, the Supreme Court told us that there's a critical limitation on the availability of arbitration as a forum for resolving federal statutory claims. These claims can only be arbitrated, the court told us, as long as the prospective litigant effectively can vindicate his or her statutory cause of action in the arbitral forum. If the arbitral forum is not adequate for vindicating these statutory rights, at that point it's not an effective forum, right? So it's not a legal forum in which to vindicate these rights. And so the second wave challenge is a challenge that essentially argues that the class action ban, by prohibiting a litigant from spreading costs across other litigants, by sharing the costs of litigating a claim, makes it impossible to vindicate statutory rights, right? So class claimants who can't share the costs of an expert, for example, won't ever bring a claim, right? Because if it costs too much to hire that expert on an individual basis, they'll never bring that claim, and so their federal statutory rights don't get vindicated and are just left to lie. And this argument, of course, is based on another Supreme Court case called Greentree versus Randolph, and a long line of cases actually holding that the arbitration clauses are unenforceable if claimants are forced to incur prohibitive costs in order to arbitrate their claims. So since that 2005 article, there has been some embracing of this idea. The First Circuit, in a case called Christian versus Comcast, and the 11th Circuit, and potentially any day now the Second Circuit, have indicated that that this second wave may actually be gaining force. In Christian, a group of Boston cable subscribers sued Comcast, the cable company there, for violations of state and federal antitrust law. and they ran headlong into a contractual class action ban. As Leslie says, many class claimants run into these bans when they try to sue. And the plaintiffs there argue that the ban prevented them from vindicating their federal antitrust rights by prohibiting the use of the class mechanism. And the First Circuit panel agreed, finding that in light of the complexity and the cost of litigating this antitrust case, without some form of class mechanism, a consumer antitrust plaintiff would not sue at all. Very realistic view from the First Circuit. The court also indicated that, and this is a quote, Comcast would essentially be shielded from private consumer enforcement liability, even in cases where it has violated the law. And plaintiffs would be unable to vindicate their statutory rights, so that the social goals of federal and state antitrust law would be frustrated because of the enforcement gap created by the de facto liability shield, which gets back to what Leslie was talking about. So for sort of uber realistic analysis from the First Circuit on this. Another case to talk about is the Southern District of New York case that started all this in Re American Express antitrust litigation, where the lower court rejected the vindication of rights argument, rejected this second wave argument. That argument, that case is currently sub judice before the Second Circuit. It was argued a couple months ago, so we await an opinion any day. I was at the argument. It looked good for plaintiffs, but you can never tell. There, the plaintiffs presented expert evidence that the out-of-pocket costs of trying to establish liability and develop a damages theory would likely exceed $1 million. Right, so the cost of litigating the antitrust claim would exceed $1 million, while the average plaintiff in that case only incurred about $1,700 in damages during the relevant time period, maybe $5,200 after trebling under the antitrust laws. So according to the argument there, again, the collective action ban flatly ensures that no plaintiff would ever challenge these tying arrangements. This is an American Express case, so challenge the American Express tying arrangements, because to do so, a small merchant would have to shoulder over $1 million in costs in order to recover $5,200 in damages, and no rational entity would do that. And finally, the 11th Circuit, in a 2000 case decided just last year called Dale versus Comcast, indicated, though it did not decide this issue, but it indicated that it agreed with this federal statutory rights argument. In Dale, the plaintiffs did not make the argument that the class action ban would have prevented them from vindicating their statutory rights, but the court nonetheless held that the cost of vindicating an individual subscriber's claim when compared to potential recovery was just too great, and so no rational subscriber would ever bring such a claim. So at this point, we may soon have 3 circuits who've endorsed this federal vindication of antitrust argument, potentially. So what will the world look like then? How do plaintiffs challenge the class action bans through this narrower and yet potentially quite effective argument that they keep them, prohibit them from vindicating their federal statutory rights? A few points to just put out there for discussion. First, what's clear from Christian and the cases that have come since Christian is that making the record is key. In Christian, the consumer made a record. The consumer class there made a record that they could not obtain review of antitrust allegations if they could not proceed as a class. The court noted that unopposed expert affidavits in that case indicated that the expert fees alone would reach the hundreds of thousands of dollars, and attorneys' fees could reach into the millions of dollars, while expected recovery, again, even assuming treble damages, would only be perhaps a few hundred, maybe a few $1,000s. So there was a record, and it was unopposed below, which made it easy for the First Circuit to find that record had been made. Subsequent cases have shown that making the record is key. So cases that have decided not to follow Christian, for example, the New Mexico Supreme Court in a case called Pfizer versus Dell refused to follow Christian because plaintiff really only made sort of allegations along these lines that the costs of bringing a claim would be very high, but made no real showing. So making a record is going to be very important for plaintiffs seeking to challenge these waivers on this second waive argument. A second point to note is that this is probably not about attorney's fees, but about costs of litigation, right? So in Christian, the court was, again, refreshingly realistic in rejecting the rationale that the opportunity to recover attorney's fees alone should provide sufficient incentive to bring non-class claims. Finding that these cases, antitrust cases in particular here, are difficult, uncertain, the outcome is uncertain, and the disproportion between the damages that are likely to be awarded and the attorney's fees make it likely that an individual consumer would never bring these claims. So clearly there's a difference here between attorney's fees and costs, and that relates to a third point I want to make, which is that expert fees are not compensable. Right, and so what we're really talking about are the costs of hiring an expert to make out your damages claims or to support you on a liability claim in these federal statutory claims. So if expert fees, for example, are not compensable under the Clayton Act and you're bringing an antitrust claim, that's really important because those are the costs that an individual would have to shoulder and therefore would not shoulder. Which makes it the argument you want to make there is that that's why the class action ban is unenforceable. And then finally, just one small point. There is the First Circuit and Christian made a big deal about the sheer complexity, that's their language, the sheer complexity of antitrust claims versus, for example, TILA claims, Truth in Lending Act claims. And noted that the prosecution of antitrust claims involves a great deal of expertise and labor and money, whereas TILA claims, sort of giving the back of their hand a bit to TILA claims they sort of characterize as elaborate factual cases, but fairly straightforward and simple. One of the concerns about this is that what we could see is a bit of a division in how consumer cases, quote-unquote simple consumer cases, are treated versus how more complex antitrust cases are treated when it comes to the enforcement of these bans or when it comes to arguing this vindication of federal statutory rights claim. And hopefully that won't happen. But it already is starting to. There's a case called Ornelius versus Sonic Denver, decided in 2007 by the Colorado District Court, where the court found that the plaintiff's claim involved only one transaction, which occurred over a brief period of time, involved at the most only 4 or 5 witnesses, didn't think that there would be an expert required, and therefore rejected plaintiff's effort to bring this second wave argument, this vindication of federal rights argument. So we can imagine that as courts sort of deal and really sort of roll up their sleeves and deal with these various attacks on the class action bans, there might be some distinctions made that we're not all comfortable with in terms of antitrust claims on the one side and, say, consumer claims on the other. So I put those out there. I just want to say one last thing, which is Professor Miller noted earlier that he had a number of proposals which are not necessarily agreed upon by the panel, by the first panel, in ways he'd like to reform Rule 23. One really simple way to reform Rule 23 in light of class action bans is just to prohibit them. And that would seem a pretty straightforward and simple way to deal with this problem of these bans. Thank you very much.
I'm here this afternoon as a substitute for my partner, Mike Hausfeld, and in my pinch-hitting capacity, I'm going to address a rather Sphinx-like topic that Michael came up with and then went to San Francisco. So I'll give the talk on that. And the subject of my discussion is the effect that the rise of collective procedures in other parts of the world, most notably within the EU, the effect that emergence has had on perceptions of class action process here in the United States. And from my perspective, doing antitrust competition cases on behalf of clients who are often international corporations, sort of the other end of the telescope from the consumer clients, there's been an emerging concern among these clients when there is a large recovery in an antitrust case involving what is essentially a global market. I've got a company that we represent. 30% of their purchases of this product were in the United States, but 70% weren't. okay, we recovered X dollars in the United States, but we still overpaid based on the same conspiracy wherever we bought the thing. What can we do in the European Union? And on the flip side of that coin, you've got defense counsel who've had a client that has been either adjudicated liable or has gone to the EU Competition Authority for leniency and gone to the Justice Department for leniency and said, yeah, we did it. We've got our individual employees going to jail in Britain, going to jail in the United States for price fixing. They realize that they've got some exposure, at least when you look at the text of the statutes in Britain and in the EU in general. The issue for them has been, for the defendants, has been no one can hold us accountable. No one is going to bother to try and blaze this litigation trail. It's going to be expensive. There are loser pays rules. There's all sorts of barriers. And that's definitely true with respect to small companies and with respect to individuals. It's just not worth it economically to pursue these claims. But when a Fortune 100 corporation says, look, I spent $300 billion on this widget, and I only got $25 million back, I want to go get my other $75 million, they've got to take that a little more seriously. Within the last 10 years, as part of settlements of antitrust class actions in the United States, there has often been some small component paid to claimants to cover, quote-unquote, foreign purchases. And during that same 10-year time span, there have been efforts within the federal courts to adjudicate claims on behalf of U.S. purchasers with respect to purchases outside the United States where commerce in the United States was affected, foreign purchasers for purchases where there is a global conspiracy, and generally speaking, those claims have not fared well in the U.S. courts. And what has driven recent events really in terms of pushing us towards resolutions, and Ken Feinberg mentioned one of those resolutions this morning in the VA and Virgin litigation, has been the presence of large claimants who are willing to litigate in another forum. And the recognition by sophisticated defense counsel that if they want peace for their client, they're going to have to find a way, either within the Rule 23 context in a U.S. court or as some sort of adjunct to that outside the United States, to get not just, well, obviously, I don't think that there's a lot of warm hearts out there in terms of wanting to get relief to the claimants. They want to get releases from the claimants, but it's the other end of the same question. So what we've seen in a case like Air Passenger, which is the VA Virgin case that Ken referred to, is a resolution that was crafted to encompass United States claimants with a specific settlement amount denominated in U.S. dollars and British claimants with a specific settlement amount denominated in pounds. It was not hotly litigated. Class certification wasn't litigated in the United States, so we're able to present a settlement class to Judge Breyer in the Northern District of California, and we are confident that Judge Breyer, reasonably confident, that Judge Breyer will preliminarily approve and ultimately finally approve the settlement, which will then redress the claims of U.S. and foreign claimants. With respect to some of the U.S. corporations that we are working with now in an effort to recover for overcharges internationally, there have been a variety of different proposals in negotiations with defendants, one of which, and probably the simplest of which, is a similar resolution in front of a U.S. court that will allow for claims and will allow the defendants to receive a release once the opt-out period has expired. But in some of these claims, we've got to be a little more creative, and we'll be a little more creative going forward in terms of structuring resolutions that will probably be something similar to what Elizabeth referred to with respect to the Vioxx settlement, was defendants putting a fund out there with the condition that it be principally claimed and that a portion of, and that a condition of claiming is presenting a release to the settling defendant. And so we're in my practice area, we're in a very interesting, at least from my perspective, point where an expansion of class device is being partially driven at least by the types of companies that usually end up on the other side of the V from the plaintiffs, and is being facilitated by, in large part, a sophisticated defense bar that wants to find a way to get peace for their clients in these cases. And another very recent aspect of this sort of entry onto the class action scene of large companies is In a number of large antitrust class action cases that have been filed this year, you're seeing multi-billion-dollar corporations filing as class plaintiffs, which in my experience has not really happened very often before. Sometimes they'll file as opt-outs late in a case. Parenthetically, their track record filing late in a case as opt-out in terms of getting a recovery has been lousy, so maybe this is why they're filing on the front end. Some of these companies are retaining their usual transactional and litigation counsel to handle these cases. Some of these companies are retaining more traditional plaintiffs' class counsel to handle these cases. But from talking to these clients, it's not a particularly, there's no real noble driver here of why they're participating more in these cases, other than they don't want to leave large sums of money on the table that they could otherwise claim. And their belief is that we better get into this, show the defendant that we're serious. We're not going to just settle our U.S. liability and then give away our foreign claims for pennies. And so I think that you'll see, and I don't want to tread on Deborah's toes. She's going to present this, I'm sure, much more articulately and more completely in the program later this afternoon in terms of the means by which relief can be achieved outside the United States in collective or class actions. But as more of these claims are raised in the U.S. courts, and as the U.S. courts tend to dismiss more of these quote-unquote foreign claims, whether they're claims for foreign purchases by U.S. Buyers or claims for purchases by non-U.S. buyers, you're going to start to see litigation in the not-too-distant future in the U.K. You're going to start to see competition litigation in the not-too-distant future in other EU countries. And once again, without treading on Deborah's toes, there are going to be evolutions in collective procedures outside the United States that are going to make it easier for these things to go forward. But one of the principal drivers early on is going to be the fact that the claimants in these European cases are going to be businesses that are large enough to pay the cost of litigation and to stay in that litigation without worrying about contingency fees, without worrying about the cost of experts and the other issues that, frankly, are becoming significant impediments to consumers litigating class cases here in the United States.
First, thank you for having me. Thank you for putting this together, especially Miriam and Tony. It's a pleasure to be here. I'd like to talk a little bit about developments in recent years in class action practice that portend changes for the future. And we should start by acknowledging what everybody knows, which is that class actions have taken quite a hit in recent years, and that there is a measure of disrepute to them. And I think that this comes from three sources. I think that, first of all, there is a politically motivated attack on class actions in areas in which the cheap aggregation device of the class action allows for litigation accountability for claims that would otherwise be non-remediable. This is the negative value case, the consumer class action. These are cases in which, as Leslie and Miriam described, there is no realistic prospect for individual redress, whether it be through arbitration or any other mechanism. Either it can be pressed collectively or it cannot, and the political tenor of the times allows for significant challenges to the greed and so forth of the class action, which basically covers for non-accountability. Second, as class actions have become more venturesome, to use the term the Supreme Court used, there have been efforts to use the settlement device of the class mechanism to close off individual claims in ways that are oftentimes antagonistic to the interests of the affected population, that offer cheap resolution, sometimes great benefit to lawyers, and that play off of some of the structural defects of a federalist system in which there are multiple potential fora for similar conduct to be litigated. Some of this may have been redressed, we will see, by the Class Action Fairness Act. Some of the coordination and the centralization that act promised may take care of some of the problem of collusive or competitive situations in which prices are pushed down because of the desire for a quick and expeditious deal. Third source is also draws upon one of the strengths but one of the vulnerabilities of the class action mechanism. The class action is a strong force for private attorneys general. It unleashes private interest in the name of a greater good. There is a wonderful metaphor that we know from Adam Smith about the invisible hand of self-interest. Well, let's get real, folks. Self-interest ain't pretty. And sometimes it yields behaviors that are unfortunate, reprehensible, potentially even criminal. And that is a vulnerability of the class action device in that it has to draw upon that sort of self-interest as the wellspring of its energy. So what has been the result? The result has been a lot of law being made that expresses skepticism about the class action. We have Amchem and Ortiz, which valorate the importance of individual actions, presumptively, against collective resolutions, and that in Ortiz even talk about the one-on-one day of an individual lawyer with an individual client, even in mass situations like asbestos where there are no individual lawyers with individual clients. We have, and I'm going to focus on the settlement area because that's where the action is. That's what class actions basically have always been about. That's what all civil litigation is about dispute resolution, getting it done. It's not just that there are no trials in class actions, there are no trials at all. So, you know, that I could care less about. So what does it mean for settlement in the class action context? Well, you got Amchem and Ortiz. That's a bad start. Conflict, subclasses, how do you know what the endless number of permutations might be? It's very difficult to get a bulletproof class action, and that's why objectors get paid off. Then you got Stevenson, excuse me, out of the Second Circuit. Stevenson's a great contribution. Says you don't have to just object now, you can object 10, 20 years from now. You can reopen everything if it didn't work out for you. You made a calculated bet that you would get sick within 10 years or you'd like the insurance policy. You don't get sick within 10 years, even though there's no causation evidence, doesn't matter. You can come back and reopen. Well, that's great. Who the hell's going to settle a class action if you can't get closure? And then you have cases that are narrow procedural cases like Devlin, which say you don't have to intervene. You don't have to show that you have a particularized interest that was not being represented. Come on in on appeal. What the hell? File later on. You know, why not participate at any point? So you get that and you say, well, is there anything left? Why would anybody go through this? Well, let me take the remainder of my brief time to tell you what I think are the three most important cases in this area of law, and you will see a pattern. The first is the single most important decision that's been written in this area of law since Amchem and Ortiz, and it's a decision that I venture that less than half the people in this room have read. And that decision is combustion engineering, Tony Sirica's opinion out of the Third Circuit. The reason you haven't read it is because you don't realize it's a class action case. It happens to be a bankruptcy case. Bankruptcy, that's mind death, right? That's for people who couldn't do tax law. So why read a bankruptcy case? Well, it turns out that you want to settle asbestos on a mass basis, find some weird little hook in the bankruptcy code, 524G, that Warren Buffett happened to have lobbied for so he could take out a leveraged position in Johns Manville, and use that to run basically the Amchem-Ortiz deal through the bankruptcy courts. Same issues, adequacy of representation, fair treatment of comparably situated people, non-arbitrary distributions, all the stuff that we thought was so terrible in Amchem and Ortiz, so difficult, so overwhelming, could never be handled on an aggregate basis. It's all right there. And Judge Sirica does a masterful job of figuring out what the hard issues are, what the wedge points are, and trying to address what really has to be done in order to ensure fairness for individuals who can't participate on their own behalf. Do I have a cite? No, I'm not. No, I've taught in the past with Charlie Wright and I teach now with Arthur Miller. Both of them could give you cites offhand. I'm no Charlie Wright. I'm no Arthur Miller. Come on. Third Circuit, combustion engineering, Judge Sirica. It's not hard. It's in our ALI. Actually, I do have a cite in the back. But anyway, second case. Ken Feinberg talked about this earlier. Zyprexa. Zyprexa is a great case. Weinstein gets hold of it. He doesn't have Rule 23. But even when he does have Rule 23 in Jack's hands, it doesn't look like Rule 23 anyway. So what difference does it make? So Zyprexa, he says, I got 7,000 cases. Some of them were filed originally before me. You know what I'm going to do? I'm going to hold all of them. I'm going to conduct discovery in them collectively. I'm going to take a few of them to trial on a bellwether basis. And then I'm going to run the settlement, if the parties choose to settle, which of course they do, through a settlement matrix that looks exactly like the types of settlement grids that you have in Amchem, Ortiz, and so on. And he's going to apply the same kind of fairness constraints that Judge Sirica applied. And he's going to realize the benefits of efficiency that John Beisner talked about a little bit ago, by saying, okay, the efficiencies don't just accrue to the plaintiff's lawyers, they accrue to the plaintiff's class, so I'm going to revisit all the fee agreements. And the third case, the most significant in this area of law, in my opinion, is Vioxx. And I'll confess I have some hand in that, but Vioxx is an attempt to create a transparent settlement matrix, grid, for the allocation of benefits across the class on objective factors, so it is clear to everyone what you can get and why, what everyone else is getting, and it's there on a take-it-or-leave-it basis. And fortunately, it has some good judges supervising it in New Orleans and in New Jersey who force not just transparency, but accountability of the lawyers in front of them to justify the distributions that are made, why, the fee arrangements that underlie the whole thing, and force individual settlements to be patterned upon this, subject to a lot of controversial stuff, including the fact that the plaintiff's lawyers can't play the field. So you can't put your best cases in, your worst cases in, and keep the best cases for trial. You're not going to get punitive damages down the road. You're going to pay a cost if you don't go along with this. Now, what's in common? What's the common feature of combustion engineering, Zyprexa, and Vioxx? They're all mass resolutions. They are all transparent. They are all being run through very capable federal courts, at least in combustion engineering at the appellate level. What is common about them is that they are all not class actions. Not a single one of them is a class action, because we have burdened the class action mechanism so thoroughly in the mass settlement context that where do we go? We go to Article 1. That's what bankruptcy courts are, right? Heaven forbid we should tarnish an Article 3 judge with something like weighing the relative merits of different claims and potential intra-class conflicts. That's not what Article 3 judges are there for. They're there to sentence crack cocaine and deport the innocent, right? We want this kind of dirty work done by our Article 1 judges. Come on. Then what do we have in Zyprexa? We have a judge saying, okay, I happen to have this through the MDL process, right? This bizarre federal statute doesn't even give them the power to try things. But I have it through the MDL process, so with the power conferred in me never to send it back anywhere, which is what the MDL statute is for, I will hold on to this until I squeeze you into a Rule 23-like proceeding, but heaven forbid we will never call it Rule 23. Why do we want that? And Vioxx, the saving grace of Vioxx for all the charges of ethical complications and the deal made with the plaintiff's bar, the saving grace is the transparency and the accountability in front of courts. And that's what Rule 23 was supposed to do. We learned a lesson after Hansberry. We learned a lesson through the 66 amendments that if this mechanism is to be legitimate, it must be transparent. The reasoning must be there. There must be accountability of the lawyers and accountability of the judges who signed off on it on appeal. And, CAFA was a mechanism to make sure that the right courts were accountable for this. And what we have done, unfortunately, in trying to deal with some of the class action problems, some in the litigation context, some in the bad settlement context, and some of it just in the desire for private gain context, is we have unfortunately burdened the mechanism excessively on the settlement side. So we are pushing private parties or Article I judges to be doing the work that we thought Article III judges should be doing in ensuring responsible mass settlements. And we cannot hide from the fact that in mass society there are mass harms, and when there are mass harms, they need a competent, fair, equitable mass resolution. Thank you.
Well, thank you very much to all the panelists. We have about, I think, Miriam, we're going to go till 20 after, 25 after, or 20 after? Yeah? Okay. With thanking you, you also get to actually have responsibility by telling me how long to go. So 2:30. Okay. So then we have lots of time, and I think that the panel itself wants to probably respond to each other's presentations, and you'll have some questions. I'm going to raise two questions that I just want to direct towards individual panelists, but anyone on the panel can chime in. The first is to Miriam, which is listening to your, and also to Leslie, listening to your presentation of the dilemma that is faced by the reduction of the power of aggregating claims. Certainly, other than a raw desire simply never to be sued, the defendants who ask consumers to give up their right to be part of a class action might say, we have lots of good reasons having to do with the flaws of the class action mechanism in the liability determining phase, which is we think that too many claims are lumped together. We can never discern which ones are actual, which ones aren't. We like the idea of forcing the plaintiff to bring the claims in a more refined fashion, even if that means one-on-one. And your response, interestingly, is, well, I have no problem with that. What I have a problem with is that no one will bring the claims. They're just not going to be funded. So it's not really a response directly to the defendant's main concern. It's another issue, which I'd be interested to know what people who think like defendants would say to that, because it's a good point. It's kind of not much of a solution to defund the mechanism which you claim to believe in. And one question I have is, what about alternate funding mechanisms? For example, why not add costs into an individual case, so that if a enterprising lawyer spends $100,000, they can get that back, maybe even as the British have, with a little bit of a success surcharge attached to it, a 6% or 9% little bonus. Or, and this goes even further afield, why not recognize that, in fact, there could be third parties who have an interest in bundling these claims? None of these claims are personal injury. They can all be assigned. Why not just bundle them and let somebody else, Warren Buffett, buy 1,000 of them, and then he can fund the experts and have a portfolio of claims? That's one question to throw out there. Another question is to Professor Zakharoff. So I was listening with fascination to your hit parade of successful non-class action class actions. And one thing I was thinking about, two of them, Zyprexa and Vioxx, and maybe I'm wrong about this, but this really struck me with Zyprexa, which I haven't thought about much. I thought more about Vioxx. I mean, Zyprexa, as you described Judge Weinstein's solution, my sense is that there's nothing other than the normal operation of statute of limitations to prevent another plaintiff coming down the pike who fits under discovery rule to bring a new Zyprexa claim. And in Vioxx, what we know about that, other than the working with the plaintiff's committee to make sure there's no lawyer available is that there won't be a claim made, because what we don't have in Vioxx, we do have in a lot of class actions, is we don't have latency. We know what the universe of cases are in these cases. And so my question to you and to the panel is, let's say you're right. What do we do with cases that have greater latency problems? Or do we just assume that we're not going to see cases much like those because most consumer fraud cases, most pharmaceutical cases don't have latency problems? So that's my question to the panel and to individuals in specific.
I'm glad to start. I'm going to take on the first part of Tony's question, which is this idea that defendants say, well, we like class actions, and I actually think defense counsel should like class actions. I mean, hourly fees being what they are, I would think actually that they generate a tremendous amount of money for defense counsel. But they say that they like class actions, but they don't want some of these cases to be brought as class actions. They want them to be brought in more sophisticated, more refined way. It was your language, and so they'd like to have them be brought individually. I mean, I think that's a slightly disingenuous argument to make, right? That you don't like class actions, and yet one spends much time trying to stamp them out of the civil justice system. But I also think that the idea is that I think Leslie and I agree with this, and probably many people in the room do too. It's one thing to say that the structure that this procedural device has done so much for this country, that many cases wouldn't have been brought but for the class action mechanism, and quite another to say that negative value claims of the type that Sam is talking about, the types of claims that worry us more, should be allowed to be brought in the class through the class device. And I think that it's right with the class action ban to focus on the fact that whatever you think about the substantive underlying claim, there's just no way that any of this will happen if it's too expensive for lawyers to invest in the cases. They don't have the $100,000 or more likely the $1 million to hire the experts, and so they're never going to happen ever, right? So we're never going to get the sort of peek under the hood to see if there's any substance there ever, because there's this massive deterrent to ever bringing the claim in the first place. But I don't know if Leslie wants to add to that.
Yeah, I would. There's actually an experiment currently underway on this exact issue, which is that companies are starting to revise their arbitration clauses. They're not taking out the class action ban, but what they're doing is they're tinkering with other terms. For example, AT&T Wireless now has a couple of premiums, which it says are designed to address this exact cost issue that you raised. Well, if individual lawyers can't bring these claims, let's make it really attractive for them to do so. Let's pay them an incentive. If we make them a settlement offer, they don't accept it, the case goes forward to arbitration, and then the arbitrator awards a higher amount than the settlement offer. But what we're seeing is, if you go to the AAA website, you can search all these cases. There's been no increase in the number of individual claims brought since the premiums were implemented. The numbers are still extremely low. Back when we first saw the data on Singular, it was 2005, I think, or 2006. This is a company with 50 million customers at that time. 30 people in the entire country had filed individual arbitrations. Now the company has 65 million customers, and I think we've seen something around 180 total. So you do have to look at the data to see if it actually works.
But what about a straight cost-shifting solution? I mean, there are firms that could afford to invest $1 million. I hear stories about plaintiffs' firms that can afford to invest $1 million into lawsuits. I hear these stories. And if they could actually recover them, if they were guaranteed a recovery, if it wasn't discretionary, why wouldn't that be a worthwhile investment for a firm that wants to maximize profit? No, of course not. But so let me ask you a question. If you developed an investment theory in which you investigate your case, the only thing standing between you and winning a $20 claim with $1 million expert fee attached is that you need to borrow the $1 million. Why wouldn't you bring it? Let's say that there was a premium and that you can just simply do a loss in the box. You can enfranchise that case.
Risk multiplier.
Yeah. And also, I mean, there's another. There are multiple predicates that I'm sure you're leaving out of this question intentionally, which is that even before the advent of these arbitration clauses, consumer cases were sort of the stepchild of class action practice. They were the toughest cases already, and then you add in the arbitration clauses and make them nearly impossible until you can adjudicate those away. But I mean, even judges who are generally very good trial judges for plaintiffs' cases that they believe are significant make similar comments. This is a $20 lawsuit, or it's a $5 lawsuit. It might be a $5 lawsuit for 100 million people, but it's still a $5. I mean, these were tough cases to begin with. So from an investment standpoint, whether you're Warren Buffett, whether you're a plaintiff's firm that may or may not be able to invest millions of dollars in litigation, this is not a great bet.
Okay. Let me just mention one point on the origins of these arbitration clauses, and I think we need to be careful about painting with too broad of a brush here, but my observation is that where a lot of these clauses arose is really found in the legislative history of CAFA, because there was a period where I think some of the class actions that you all are talking about, which from your description sound like they involve substantial abusive behavior, were there, but there was also a brand of class actions that were frequently being filed in magnet courts that were sort of gotcha claims, and they usually got settled with the payment of attorney's fees. These are documented in the Class Action Fairness Act legislative history, page after page, for the settlements where attorney's fees were paid. The class didn't get much of anything, and indeed in many of those cases there was no effort to get any sort of injunctive relief, and so no one bothered to say you can't continue doing this. And I think that for some defendants in these cases, certainly not all, these arbitration clauses were born out of the frustration of dealing with those sorts of cases. I can't get into the heads of the courts that have shifted on this, but I think part of the feeling that may be causing some of the courts to be more concerned about those clauses is that justification for those clauses has dissipated some, because those sorts of cases are not being filed as frequently anymore because those forums have disappeared to some extent. I'm not seeing nearly as many of those sorts of claims, and what we're seeing more of are the sorts of things that I think you all are talking about there being filed. I don't mean to suggest there's a cause and effect relationship, but I got a feeling that may be a little bit of what's going on there.
I think I have two questions, and I know Sam wants to sort of respond.
Well, I'll respond to the second. It's hard to prognosticate across the board, but I think we should, first instance, not generalize everything from the asbestos context. Not everything has 40-year latencies. Not everything was distributed to the extent that it exposed most of the American population. That's sort of a unique circumstance. I think that what's interesting about both Zyprexa and Vioxx is that a class-like mechanism was used outside the class action context, but also used in a more sophisticated way than traditional class action practice would have allowed for. Because traditional class action practice would have lumped everything together, would have packaged it all up, not as issue classes or things of that sort, but rather as sort of a lump sum, okay, now we're going to take the whole thing to trial, and does anybody have the guts to take the whole thing to trial? And the answer was always no. And so what you got was ad hoc settlements. Sometimes it was mature in the language that Ken Feinberg was using this morning, more often not. And what both Zyprexa and Vioxx did was it introduced bellwether trials. It introduced a number of other mechanisms into the mix so as to get an appropriate valuation. And I think that should inform class action practice as well, that it needs to adapt to the mass harm cases in a more realistic fashion. In the ALI approach, we're trying to create a mechanism for the trial of issues, for the real trial, with jury if it's needed or not jury, whatever it is, but to have partial trials with full appeals of those issues. So it's not just an extortionate or a threatening mechanism, but you can actually get an informed adjudication so you can set appropriate values, and that the courts have some basis for assessing the appropriateness of the settlement. I think that that's where the future's got to go if we're going to use these kinds of aggregate mechanisms to resolve the mass harms. But even on the asbestos point, at the end of the day, you can reject AmChem, you can reject Ortiz, you can say that the conflicts were too great, that the way it was structured didn't pay people fairly, that it had too much of a discount of the futures in favor of the presents, things of that sort. But that may be on the merits, but to say that an Article 3 is disabled, an Article 3 court is disabled from handling that, and then to say that an Article 1 court is going to do the exact same thing under this partial bankruptcy of 524G makes no sense to me. I just don't understand the logic of that. I don't understand what's the tremendous legitimating force of putting it in a tribunal that has less resources to handle this kind of a difficult issue.
I think we should open up to the audience. I see hands, and please wait for me to call on you and tell me your name at least, and if you have an affiliation, you might want to give that as well. Yes? Just speak louder. Yeah. Anyone want to say it?
I think I always see that as a function of settlement administration, which is another thing that Ken touched on as an important topic. And I can't speak to that particular piece of litigation, but I think we've done variable jobs, depending on the case and the resolution, on providing information for people beyond that notice that you got in the mail or a website that you might have gotten some direction to. And I think, some of the bigger cases, years ago there was a settlement involving Prudential, and there have been other cases where there are actually, the class counsel at the, with expenses granted by the court sets up a phone bank where you've got people who can answer your questions. Increasingly, for those with access to the internet, there are more and more comprehensive websites made available. So it's something that that the bar in general is working to improve. And I certainly agree that there are many better ways to handle it than the little slip that you received. And hopefully there is I don't know anything about that particular deal, but hopefully there's a website that you can go to that will give you a more comprehensive view of the deal, and that there will be maybe even a live person you can talk to answer any questions that you might have. I mean, that's a goal that we bear in mind when we try and put these settlements together.
Or not. Or just, we could forget about all that, right? Because you didn't know about the fact that Barbary overcharged you in the first place, right? So, I mean, I think I'm, more provocative perspective on this is, who cares if you get notice? Why does it matter, right? That the real goal of class actions, the real force they have is to deter future wrongdoing. And so the lawyers who represent you without your knowledge, without your okay, are going to do the best job they can to wrest the largest settlement they can out of Barbary or whoever else may have harmed you financially. And you'll get some small amount that, you might not even catch that check, right? It's going to be so small. You might not even open that envelope. This idea, I'm just one of those people who doesn't think that much about this whole idea that clients matter in these class actions. I think that deterrence, except of course for, I don't want Sean to kill me, the large institutional CalPERS count for securities class actions and the such, but you have this small consumer claim that you wouldn't have known about. You wouldn't have brought it had you known about it, right? So the idea here is that we want to make sure Barbary and other Bar Prep and other entities that have any ability to harm you in small and yet across the board, significant ways, don't do it because they're so concerned that there's some plaintiff's lawyer out there who's going to bring a class action suit. So, I mean, I don't want to totally diminish this idea of notice and individual autonomy, which has been written about a ton by law professors. I just personally want to put in a vote of who cares on that.
Okay, we have a question in the back. I'll get you next. Gentleman in the blue shirt. Speak a little louder. Yeah.
Court. That's as a result of the portal Act of 1947, which was designed to cut off class action agreement power. What has happened is that there has been a compounding of the state wage and hour claims, so that you have compound three cases with the FLSA cases, and the courts are now struggling with that case in states where the laws are such that you have a state wage and hour like California, especially in addition to the FLSA case. Now, comparisons to the labor area, I haven't heard a lot of those, but the things we talk about cut differently. For example, under the wage and hour act, the private plaintiff can't get an injunction. It's only the Secretary of Labor who can have a difference. But the question for the President, as a labor practitioner, what I've heard about that this is a consumer's yellow dog contract. And when you think about it that way, in effect, the yellow dog contract, for those who haven't heard of it, is a contract or an agreement where the worker has to sign before he goes to work an agreement that he won't join a union. That's the yellow dog contract. And so we have this consumer's yellow dog contract. And so my question is there any legislation in the contract banning yellow dog contract? Have there been hearings? Senator Congressman Baxter or anything else?
Yes. Yeah, it's unfortunate that Paul just left the room because he's been actually instrumental in helping educate legislators behind the scenes about what's needed on the arbitration forefront. The Arbitration Fairness Act is currently pending, and if you're here for the second panel, you should ask Paul to tell you exactly what the status is of it. But that would ban arbitration clauses, pre-dispute binding mandatory arbitration clauses in both consumer cases and these employment cases that you're talking about. And I hadn't heard the term yellow dog contract before, I apologize, but you're probably familiar with the Gentry case in the California Supreme Court, which just held a couple months ago that even if an employee is given a window of time within which to opt out of agreeing to an arbitration clause with a class action ban, the pressure is such and the sort of deception about what you're actually agreeing to is such that that does not mean that the contract is enforceable. So in states that require procedural unconscionability in addition to substantive, which is what I talked about, this is a really important case for workers.
Well, it looks like we're going to have to end right now. I'm sorry for those of you who couldn't answer questions. Thank you very much, all the panelists. We have an announcement coming up.
Talk about moving forward. To lead that discussion is Robert Peck, Bob Peck. We're very happy to have with us. Bob is the president of the Center for Constitutional Litigation, law firm dedicated to challenging laws that impede access to justice and otherwise take on some of the most significant constitutional challenges that can be taken on. Bob is a well-regarded lecturer and professor. He's taught at such schools as American University and George Washington University, where he teaches constitutional law, advanced constitutional law. He is a member of the Board of Overseers of the RAND Corporation's Institute for Civil Justice, the Board of Directors of the National Center for State Courts, the American Law Institute, and the American Bar Foundation. On top of all that, he is makes frequent appearances before the U.S. Supreme Court, and is truly one of our country's real great consumer lawyers and constitutional lawyers. With that, I give you Bob Peck.
Well, thank you. This has been a wonderful day. And kudos to those who organized it, and for all of you for sticking through it on a Friday, especially now that we're at a Friday afternoon. when we're facing this very serious topic and going through much of the weeds of it. Now, we've been asked to basically be the crystal ball panel. This is the one that looks into the future a bit. Now, I'm going to set the bar fairly low for us because the fact of the matter is whenever I think about these panels that look into the future, I think of the director of the U.S. Patent Office in 1900 who advocated to Congress that his office ought to be done away with. No need to appropriate more money because everything that could be invented has been invented. So if we do better than that, we're okay. But you have, once again, a wonderful panel of experts, people, most of whom I've known for quite some time, who will talk to us about different aspects of class action. And as the National Archives itself says on it, the past is prologue. We're going to talk a little bit about the past and the present, and it may be only after we get into questions that we really get into the future much. But I would like you to listen very closely because we have a very interesting group of people. And I'm not going to go through their biographies as you have them in your materials, but I'm going to introduce them very quickly right now. First to speak this afternoon will be Victor Schwartz. Victor is head of the public policy department at Shook Hardy. He is general counsel of the American Tort Reform Association. He is the energizer bunny of lobbyists in Washington because he keeps on going and going and going. And also, since every late Friday afternoon panel needs a sex symbol, he is ours. Second, Paul Bland. Paul Bland is one of the leading litigators in the country challenging arbitration agreements. He's argued these cases before the U.S. Supreme Court. He is a staff attorney with Public Justice, and if there is anything about arbitration that needs to be known, he is always a source for that information. So we're very glad to have him, and he will talk about that intersection that we keep running into between arbitration and class actions. Catherine Lemon is an attorney with the ACLU of Southern California, which is one of the premier affiliates of the ACLU, having done an incredible amount of cutting-edge litigation. And she, in her own right, is one of the leading civil rights lawyers of our generation. And so we're very happy to have her here. And then finally, Deborah Hensler, who teaches at Stanford now, but also was the longtime director of the Rand Institute for Civil Justice, is probably the leading empiricist in the study of the legal system in the country, and who will bring us facts, not anecdotes, facts about the legal system and the way that class actions are viewed globally. So, with no further ado, Victor, why don't you start us out?
I want to thank Bob so much. I have great respect for him. They left out that Bob really is very important to my earning a living because I passed tort reform and then he goes around and nullifies it all over the United States, which is very good. So then we pass it again and then he nullifies it. And it keeps us both busy, trim. It's also fun to be in law school. I used to teach. There's a case book, Prosser, Wade, and Schwartz. I don't know if anybody's ever used it, but we're going to have it on sale for $69.95 outside if you want. I can't get Prosser to sign it, but I'm thinking of a class action against these polls. I don't know how many of you. I try to watch everybody, and I couldn't. I would always hit one of those polls, and whoever designed that must have had a, I don't know, a peculiar sense of humor. But President Clinton is thinking of, I'm bringing a class action against the Democratic National Committee to see that there's a revote everywhere Hillary lost. I mean it. Testified, actually, Bob wasn't on the panel, in front of Alan Specter about a year ago. And if you want to get nervous in a hearing, Imagine this. The guy says to me, Mr. Schwartz, I thought you do a pretty good imitation of me. I'd like to know whether that's true. Thinking, what the am I going to do now? So I said, it would be disrespectful of me to speculate as to an answer to that question, Senator. Something that you, as chairman of the committee, should decide. Now, class action, sorry. Now, you've all heard all day, all these geniuses talk, thank you, about class actions. And I just do 101. You've heard it 1,000 times, but it helps me get into the subject if I go through the portal of where Charles Clark began with all this. And he was really looking at things, efficiency. So you didn't try the same thing over and over again. And also providing justice where the individual claim just didn't have enough money behind it or lawyers behind it to be able to get justice. In the beginning, those were the two polarities. Those were the two goals. And that was the vision of Charles Clark. When he wrote the rule that became 23, there was very little consideration for years, really, dealing with the subject that I love, and that's tort law. They weren't thinking about tort law. And when they did think about it, basically, it was things that are unusual, where something happens at the same time. There's a plane crash or a hotel fire. My friend John Cole is a great plaintiff's lawyer, always got to those fires before the firemen. He's just a fantastic plaintiff's lawyer, and would get the class rounded up. So there were examples where it would work, where it would help. It was only later that it started to get stretched out into other areas. Tobacco, that was tried. And then that was Castano, and they said, well, everybody smokes differently. So it's like that. So we can't lump all those people together. I always like to see them outside buildings. It's just some fascinating thing about the smokers. What are they talking about? I want to know what they are saying. Oh, I think I'll die next year. But they had this predominant, I guess I got the right word, is that what it is in 23? Predominant factor, and that the questions that are in common are supposed to predominate over questions that are not in common. And defense lawyers started to really hit that away, and sometimes the class actions faded. This is the past, because whether it's tobacco or drugs, legitimate ones, or automobile, cases are different. There's different factual patterns, and there are often very serious questions, as you've heard, about cause and fact, and whether this particular Vioxx patient died or didn't die because they took Vioxx or because they had previously existing heart disease. And the defense bar did pretty well with predominance. Then there was a little shift. Around the country, not many places, most judges are real good, they're the best. My first job was with Judge Metzner. He was real good, and he's still alive, and he's smart, he taught me a lot of stuff. But there were a few judges around the country, and I've committed many sins, Bob knows that. But I came up with this term, judicial hellholes. I feel very bad about it. It bothers me at night. But I trademarked it. And we focused on some judges who would just certify classes. I mean, the way sometimes they hit a passport, with those, we go through, boom, 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 boom. And so plaintiffs' lawyers kind of drove there, and they got their classes certified. That was okay. And then they would find other escapes, more sophisticated, and I think you're going to see more of this as we get to the future, of getting around that predominance requirement. My friend, my mentor, Judge Weinstein, he was really a person who I worked for in law school and look up to, and he's so creative, and God bless him. He's in his 80s, goes to work every day. He's fantastic. But he thought there's ways to use statistical proof to get around the predominance requirement. And maybe some of the earlier speakers talked about that. And that is likely to be a technique that is going to be used and developed to try to get around the idea that each fact is different. And there was another escape route. And there's this project that's so learned, done by one of the professors who spoke earlier, in ALI's aggregation of litigation. And there's a lot of work in there about ways to escape the predominance requirement by using subclasses. And we'll let subclass break it down to some tiny little thing. And from a defense point of view, if you have enough of subclasses certified, it's just going to force you to the settlement table. So it's a very strong weapon that plaintiffs' lawyers can use, and I think you will see it used more as ways around predominance requirement. The choice of law rules, that's been a problem because, in fact, I argued, I was in front of the Fifth Circuit. I argued a case where I was representing a gun manufacturer, but not what you think, not because they killed people, because it didn't work. And a whole bunch of people wanted their money back, and they tried to take the Georgia where this Glock, I think it was Glock, where they made the thing or distributed it. I think it was German. I was always a little frightened with that client. But they certified, see, she got the joke. Client, good morning. Good morning, client. So I argued in the Fifth Circuit, and they tried to say that there was no real choice of law. We're going to take the place where it was all distributed. But that's not a good escape route. They'll try it. There's a law review article on it. It's pretty good. But I think when somebody buys something, they anticipate the law of that state is the law to apply. And in fact, the law of Georgia that they were going to try to apply to all the class members actually crushed rights of some consumers because it was less liberal than others. Those are some of the escape routes we're going to see, and we're going to see more. I don't think class actions are as dead as some people think. I think people are going to try to find ways around that predominance requirement. I mentioned 3 of them. There's a lot of, it was thought that to some extent CAFA, which John Beisner really created, it's very rare is there a big law that one person can really say, and he would never say it, created it, and he did. The Class Action Fairness Act, that was supposed to bring an end to class actions because it stopped the judicial hellholes and they couldn't be certifying them anymore, but it really hasn't. Some federal courts are certifying classes, and in fact, the part of CAFA that really has been the most important public policy part may be stopping the coupon settlements. Because judges, federal judges, are looking at these things very, very carefully. And there's some defendants that wanted to settle their cases, give coupons or whatever to the plaintiffs and give the attorneys big fees and get to go home. And federal courts are not looking well at those things at all. And at the time CAFA was going forward, that was not focused upon. And I just don't see that CAFA has ended class actions. It did shut the hellholes down. That is true. All these escapes, some may say they are needed, some may say that class actions need to be resurrected, that you want to get around the issue of predominance. But I would just suggest to you that sometimes efficiency, as good a goal as it is that Charlie Clark had in mind, just suggest to you that efficiency can go too far and somebody is denied individual justice. It's not going to be a popular defendant. It's not going to be somebody that ACS wakes up every morning and is worrying about. But it's still, our system is based on unpopular defendants. It says equal justice under law on the top of the Supreme Court. There's no footnote for unpopular defendants. So efficiency can trump justice, and I'm concerned about escapes that put efficiency too high. About the small claims, and this won't help many, but I just closed with this. In January, I went to the auto show in Washington, and I checked my coat, and it was a gift for Christmas. I finally had, after all these years, an overcoat that fit me. Mo the Midget sold it to me. It's a store. It's closed now. It was run by a couple of people at Mo, and it fit. It was wonderful, and I checked it, gone. And they lost hundreds of coats that night. It was just, I could see it. It was chaos. But going to sue this august thing in class actions, that was impossible. So there are something called small claims courts, and people have forgotten them. But putting more money in them, giving them a higher limit, is one way. I'm not saying it's everything, but it is one way to provide justice to that small case. I'm not suggesting it's all of them. And by just suggesting to these people that I might do that, I gave them the sales slip, and they were kind enough to reimburse me. I still haven't found a coat like that. It's impossible to find since Moe's closed. Thank you very much.
What will happen with class actions? We may know a lot more sooner than a lot of you would guess. My colleague Leslie Bailey said that the issue of whether or not a ban on class actions is unconscionable or illegal can't be enforced as an issue of state law. And that is, in fact, the theory that we've won a whole bunch of cases on around the country, and a lot of other lawyers have won that theory on. And in 3 of the different cases that we'd won in our firm, we drew cert petitions to the U.S. Supreme Court, where defendants said, oh, you know, federal law wipes away the state law. Under the Federal Arbitration Act back in 1924, when Congress passed the Federal Arbitration Act, what they really meant was the federal companies can do whatever they want act, and it wipes away any state law. A contract would be illegal in any other setting. Once you put it under a paragraph called arbitration, now it's preempted, and Congress lays hand on it, and it's good to go, and it means that federal law wipes away state law. And in the past, we've beaten all 3 cert petitions, laughed them off, and said, no court's ever agreed with that. There's no serious court that's ever found the Federal Arbitration Act preempts state law, and there's no issue of federal law. Now, states disagree. There are states we've won. There are states people have lost on this issue about whether or not a class action ban is enforceable, but there's no difference on federal law. Okay, December 19th of last year, my birthday, I turned 46, and the Third Circuit gave me this following present. In a case called Gay versus Credit Inform, they held that even if Pennsylvania law would say that a ban on class actions was unconscionable because it was exculpatory, would give the defendant a get-out-of-jail-free card, that it was preempted by the Federal Arbitration Act. So now, there are 3 cert petitions at the U.S. Supreme Court authored by Carter Phillips, single most successful Supreme Court advocate of the modern era. I think you have to go back to Thurgood Marshall to find someone who's won more cases other than someone in the Solicitor General's office, which is sort of cheating, doesn't count, than Carter Phillips. The first cert petition has been fully briefed, and there were 3 amicus briefs, including one by the Chamber of Commerce. And they say, oh, there's this huge circuit split between the Gay case and these other cases, and it's pandemonium. We in the corporate world don't know what to do. We can't tell whether arbitration clause is enforceable, because it's not, you know, we can ban class actions in the Third Circuit, but we can't ban them in California. How can we plan our business, right? So we need the Supreme Court to come in and step in and decide this. Okay, of the 3 cert petitions, the first one, Gentry versus Circuit City, was conferenced today. So on Monday, we may find out that the Supreme Court decided whether or not federal law wipes away all state laws that would in any way limit the ability of a corporation to stick a ban on class actions into a contract. So for any case that involves parties with a contract, any consumer case, nearly any employment case today, and a lot of other types of cases, a lot of antitrust cases where there are contracts. As of Monday, we may find out whether Chief Justice Roberts and the other 8 are going to decide whether federal law says that there's a federal right for them to do that. Okay? After reading the Chamber of Commerce's amicus brief in the the Gentry case, where they talked about basically that there's a need to have a federal right to get rid of all class actions. Sitting here at this conference, listening to people talk about the fine points of notice of class actions, you can set up and notice this way, or listening to Vic talking about, well, you know, the predominance inquiry, how it's dealing. I feel like I'm at a conference on dinosaurs where you can see the asteroid in the atmosphere. You know, these things may be completely gone by a year from June. So what will happen if the court takes the Gentry case, or if it takes one of the other 3 cases? Bob talked about setting the bar low for prognosticators. I watched one of the games in the March Madness the other day in which, not making this up, a one of the announcers says to the other one, so who's going to win? Who do you think is going to win this game? And the guy thinks about it and says, well, one of the teams. And I was like, gosh, this guy should be like nominated for an Emmy or something. But there's actually three possibilities, I think, of what could come out of this. There's not two. A, the consumers, the employees win. Gentry case or the Laster case, one of the other three cases where there's a cert petition. We win. The Supreme Court does the right thing and says there was the Federal Arbitration Act, not the Federal Exculpation Act, and that this is a matter of state law, that in 1924 the Congress wasn't meaning to field preempt all state contract law and say that this is entirely an issue of federal law. So suppose we win. What does that leave you? That leaves you with a balkanized system. Right now, we won a case in the California Supreme Court, the Discover Bank case. We have the New Jersey Supreme Court in the Muhammad case. There are the other states that Leslie listed. Then there's about another dozen states that have banned class actions. And so what you'll see is, because of the problems of choice of law clauses, you're going to see in consumer and employment cases, you'll see class actions in maybe 15 states, and there's still like another 20 states which we're litigating. I argued a case in the New Mexico Supreme Court a month ago. There's a bunch of other states that are still up in the air. But there are going to be class actions some places and not class actions others. In Maryland, there just aren't class actions anymore. They're just gone. The Maryland Court of Appeals says that the class action ban is enforceable. Fourth Circuit said class action bans are enforceable. People come to me with just unbelievably outrageous stories in Maryland. It's like, boy, you should see the way I was cheated. They'll describe it. They'll set out the documents. They've kept exquisite documents. It's a really articulate plaintiff, really attractive plaintiff. And I say, God, that's really too bad. Sorry. So if we win, there will be parts of the country you can bring class actions and parts of the country where you can't. Okay, B, the chamber gets everything they want. You just have complete corporate immunity from all class actions. Okay, that's B, all right? And that's what Carter Phillips is up there going for, and he's the man and so forth. Say they get what they want, and they ban 99% of class actions. There are going to be a ton of areas where corporate America is just going to be unbridled. Are people out there right now getting a kick out of the subprime crisis? Because that's corporate America unbridled. Because first of all, you had federal agencies that did nothing. You have agencies that get all of their money from user fees, as Leslie Bailey described to you. So the OCC, they get 10% of their budget from Bank of America. If Bank of America decides to call itself a thrift instead of a bank, or decides to call itself a state-chartered bank, the OCC has to fire 10% of its employees tomorrow because they get all their money from Bank of America. So the OCC acts like Bank of America's buddy. They're like the lawyers for Bank of America. I've been at cases where there's me and the other co-counsel next to me. On the other side, there's somebody from a firm like Victor's, and then there's someone from the United States of America representing the OCC on the side of the bank. Okay? That's the OCC. That's federal banking regulation right now in America. Okay? Is it funny? I mean, we were laughing about federal banking regulation. Well, they've also gotten rid of lawsuits because as the federal banking agencies have said everything's preempted and they all have the class action bans, it's next to impossible we're in a case. So what is a subprime crisis? 2 million people are going to have their homes foreclosed this year. This year, in 2008, most people predict 2 million foreclosures of homes. That's corporate America when it can run wild. That's corporate America when there's no limitations at all. Elizabeth Cabraser sat here this morning and talking about federal preemption involving drug manufacturers. And she said, if you don't regulate them at the beginning and you don't regulate them at the end, that's unacceptable. Well, to me, the subprime crisis is unacceptable. And it's not the only place that could happen. You don't just say, oh, well, it's just the banking, these mortgage lenders got out of control, but the rest of corporate America can be trusted to have no laws apply to them whatsoever. But that's plan B would be to have the chamber wins and gets everything they want. Okay, I personally, I'm not laughing. C, there is a C. It's really weird with the Supreme Court. There have been several cases in front of them in which someone has said, one side should win or another side should win. And what the Supreme Court has said is, well, let the arbitrator decide. Because that's really not something a court would decide. We'll let the arbitrator decide. So, this is where the race to the bottom really starts. If the arbitrator decides whether or not the ban on class actions is enforceable, what are they going to do? Well, if you're an arbitrator, there's 3 major arbitration firms. JAMS, former judges, the American Arbitration Association, the AAA, and the National Arbitration Forum. Okay? That's in order of how uncorrupt they are. JAMS is now gone from virtually all consumer contracts. Because in the fall of 2004, they said, we believe that a ban on class actions is inappropriate. The 20 largest law firms in America got together, according to people inside JAMS, and contacted JAMS and said, we're going to boycott your mediation business. Now, you don't make any money doing consumer arbitrations because no consumers bring arbitrations. But we're going to boycott your mediation business unless you back down from the ban on class actions. By February of 2005, they did. But because they, for 3 months, had been apostates, they're gone from consumer contracts. Anyone here got a credit card? Look and see if JAMS is currently available to you as an option to your credit card. They aren't. They're gone. The American Arbitration Association, they saw what happened to JAMS, so they got the idea. They will do an arbitration in a class action basis if either the clause is silent, doesn't say anything about it, so that means if the clause was written before 2003 in the Basel case, because every arbitration clause written since 2003 bans the class actions. Or they'll do an arbitration if a court orders them to do it. But under option C, the court's not going to order them to do it. The court's going to say, oh, you decide. And then C is a national arbitration forum which advertises, runs around the country telling people we would never allow a class action before us. The National Arbitration Forum, which is headed by a guy who used to work in-house counsel at ITT Financial. They were hit with a bunch of class action. They had a dirty credit card operation. And then he left ITT and went and formed this organization. It's a tort reform organization. They walk around. They have advertisements in banking magazines saying that, bring your case every company should write their contracts and name the National Arbitration Forum. So we have a loser pays rule. If a consumer brings a case against us, we'll make sure that if they lose, that they have to pay all of your fees. There are studies from Public Citizens showing over 95% of the cases that go in front of them get won by the company. So what is the race to the bottom belief? I'd like to end with a prop. Big believer in props. Now, speaking of setting the bar low, there's a blog the other day, the 5 worst Supreme Court arguments ever, and the guy who won was this guy from Mississippi. Had showed up and he decided to have a prop in front of the Supreme Court, and he brought an apple in the Supreme Court cafeteria, and they stood up and he said, y'all, the other side wants 2 bites at this. And now we got the worst Supreme Court argument ever. So anyhow, I myself will have a prop. The ACS hands out this little booklet outside, the Declaration of Independence, the Constitution, the Gettysburg Address, which seems like a weird mix. Like, which of these 3 doesn't fit? But anyhow, on page 3, on the Declaration of Independence, in the early part of the Declaration, the part where the colonists, this is what they are bitching about, why they are going to go to war and declare independence. Because I don't actually watch John Adams, although, I'm just going to buy it eventually. But anyhow, on page 3, he being the king, right, the bad guy who we're going to war against, he has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. Well, that's the 3 arbitration companies, right? The only way that they get to be the judges is if the company writes them into the contract. If American Express writes them into the contract. None of you wrote your credit card agreement. The company did, right? And they're dependent on the companies for how they get paid. So if you're either going to have we win in which there's some class actions, or we lose completely in which there's no class actions, or the arbitrator decides, which means there's no class actions. Those are the futures if the Supreme Court grants cert in any of these 3 cases. And by the way, if we beat cert in these 3 cases, there will be another 20. There's going to be one every month until my daughter is, in grad school.
Hi, I'm Catherine Lehman. I'm the Racial Justice Director at the ACLU of Southern California, and I really appreciate your staying through a long day to listen for me and for the rest of this panel. The organizers of this conference asked me to talk about the uses of the class action device in the civil rights context and to project into the future about the continuing utility of the device. And I'll give you the short version first, which is that I think it's enormously useful. I'd like to talk today about some of the practical uses of the device in some contrast to the rule compliance uses of the device, using some of my cases. And my principal example will be from a case on behalf of some 2 million California public school students who lacked basic tools for learning that I and many others litigated for a number of years. The case was a class action on behalf of roughly a third of California's public school students who didn't have textbooks to use in school or to take home for homework, who didn't have trained teachers in the front of their room, sometimes didn't have any teachers at all, and didn't have decent school facilities to learn in, didn't have toilets that were open and unlocked, didn't have desks to sit at in their classes, didn't have classrooms that were free of vermin. The case was sort of a classic case for use of the class action device. It involved 2 million kids. It would have been impractical to bring all of those kids into court for purposes of litigation. That we had a common issue of law, which was about the state's responsibility for making sure that all kids have the basic tools for learning in their classes, and we had common issues of fact in the sense that all of the kids suffered the deprivations that the suit was about. The lawyers for the state argued, in some contrast to us, that actually the case was not susceptible of the class action device because the reasons that the kids didn't have the textbooks or didn't have an open and unlocked bathroom or didn't have a teacher would have differed in the specific schools and the specific districts around the state. We have 1,054 districts in California. There were a lot of different reasons why the delivery of those basic tools wasn't present in the classrooms and at the desktops, or where there wasn't a desktop at the seat for each of the students. We argued and the judge agreed that ultimately the case was about the liability of the state for failing to have a system to prevent or detect and correct those kinds of educational absences for the students. So we got to litigate as a class action. We ultimately settled. It's a terrific victory. I'm very happy with what we achieved for the kids. But that retelling of the story is a fairly cold retelling when contrasted to the facts for the kids and for the families when we were preparing to bring the litigation. When we went around the state to interview families about what was absent in their schools and what it was that the suit should be about and what we should be trying to present to the court to do some justice for kids in California's public schools, I talked to families who said to me, for example, look, 86% of the teachers at my kids' school are uncredentialed. The school is not a school that anybody should be sending their kids to. It's nothing that's educational that's happening there, but I can't come forward and talk about it to a court. I can't come forward and be public about my concerns because the superintendent in my district is my landlord. The superintendent in my district owns the building that I live in. The superintendent is enormously vindictive, and if I come forward and I say what's going wrong in my kids' school, I will be homeless. And there wasn't anything that I could say to those families as a lawyer. I couldn't say, well, the lawsuit will go quickly enough that you will still be at home. I couldn't say that there's, I had some way to guarantee that these people would not be evicted from their homes. So that set of families, and that's just one example among many that I had in the suit, that set of families really couldn't come forward and lend their name to the kinds of issues that we needed to talk about in the suit. I needed to find other families who could speak on their behalf and who could talk about what was wrong in the schools, who could help us to establish state liability without having to take the kinds of serious risks that would have been present for the families who would have likely been homeless if they had come forward. Likewise, the state tried to make the litigation so unpleasant for the families that we wouldn't be able to show liability because we wouldn't have any class representatives. The case was, as I said, on behalf of some 2 million kids. We ended up prosecuting with 15 class representatives, and it was very difficult to find 15 kids who could withstand 4 days of deposition, who could withstand the kinds of onerous, difficult litigation process that the state put them through to be able to establish that, in fact, they didn't have textbooks and the textbooks were important for their learning, which is what we were wanting to show with the kids. We had, as another example, we had 2 kids who were 9 and 11 years old who were class representatives. And weeks before their deposition, they were orphaned. Their father had been killed the year before, and a few weeks before the deposition, for class certification purposes, their mother was killed in a drive-by shooting on their doorstep. It was an enormously difficult time in that family for those children who were 9 and 11 years old. And we tried to delay their deposition because it was such a difficult time for them. We tried even to have the state stipulate to their ability to be class representatives and to go forward with the other kids. The state would not stipulate because of the importance of deposing these children for purposes of their adequacy of representation as class representatives, and refused to delay or to stipulate. So I found myself in the unpleasant position of having to speak to 9 and 11-year-old boys about whether they wanted to go forward on behalf of other children with the state. And they told me that it was important to their mother, so they wanted to do it. And I've never met such lovely people as these kids. I mean, it was a nadir for me as a lawyer to have to go forward with litigation with children in that context. And I suspected at that point that the lawyers for the state wanted to make the litigation so difficult that we would not be able to prosecute and that we would not be able to establish liability for the state. And I thought, perhaps I was being a little bit cynical, Perhaps I'm too wed to, I drink my own Kool-Aid. And so, I should put that thought aside. And then I started the deposition with another one of our class representatives who was at that time 16. And the deposition was enormously unpleasant for him. It was humiliating for him to say, with a court reporter present, with a very expensive lawyer for the state, a bunch of people in the room, why he was concerned about the conditions in his school and that he thought that they should be better, and to be met with the wall of total absence of caring. And he was humiliated. I mean, he really didn't think that if he had ever said to an adult that the conditions that were true in his school were true and that he thought that they should not exist, that adult would tell him that it wasn't important. When that happened, he told me he couldn't go forward with the next day of deposition and he couldn't continue because it was so unpleasant for him. So I was out of class representative again, and I had to find somebody to substitute in for him because I needed to be able to establish the conditions at his school. Did you suddenly stop being able to hear me? Okay. I needed to be able to establish the conditions at his school. When I passed the chief lawyer for the state, after that had happened, I had found another kid who was substituted and I could continue with our 15 class representatives. The lawyer for the state said, well, we're doing what we wanted. They're dropping like flies. It's becoming too difficult for them. So I decided I wasn't too cynical, and in fact it was the goal for the state to make it too difficult to prosecute the case as a class action. And if I hadn't been able to go forward with 15 kids on behalf of 2 million, we never would have brought that case. We never would have been able to establish that the state of California, in fact, did not care if the kids had textbooks, did not have a system to make sure that the school facilities were safe for the children to be learning in, did not care and did not have a system to make sure that there were teachers in the front of every classroom. And that would have been a travesty. So it was enormously important to be able to bring that case in the lives of the kids that I represented, the lives of the families that we represented, and in terms of the kinds of change that we were able to make in California that we are able to continue implementing today. One last example from that case, and then I'll turn to the police brutality context, which is no less painful, is that those kids would have graduated if we had had to go forward with the pendency of litigation. They would have stopped being in elementary school, they would have stopped being in middle school, they would have stopped being in high school, so they wouldn't have been suffering the conditions, and the issues would have been moot. If we hadn't been able to litigate the case as a class and show that it was live at the time that the class was certified, and then we could go forward and establish the conditions as they existed at the time of class certification. So the device is, in the kinds of injunctive relief, traditional civil rights litigation context, which is the world I live in and litigate in, it's enormously important because we can bring and prove cases that make tremendous difference, but also because it allows us to cherry pick, if you will, the families and the litigants who are safest, to be able to represent other people who are less safe, but who suffer the same kinds of conditions. And in a similar context, but differently harrowing, I guess, is the police brutality context. As the racial justice director in Los Angeles, I suffer no shortage of civil rights violations that I might litigate, and police brutality is sadly high among them in Los Angeles. I have gone at I have 2 minutes left, so I'm going to be very brief with my police brutality. I have tried to stem the tide of police brutality a few times in my 8 years at the ACLU, and I will say that I am not wildly successful in that. But the first time that I tried to stop the LAPD from routinely beating people of color, I was unable to find anyone who could come forward and say, I was hogtied, I was beaten in police custody, they threatened me with killing me. The stories that they were telling me, I couldn't get people to come forward and put their names in court on because the police would come after them again, and I couldn't protect them during the pendency of that litigation. So the best that I could do would be to represent organizations on behalf of the community in an existing consent decree with the United States Department of Justice to monitor the reforms that have been promised for now 8 years and have yet to materialize for people in the LAPD. I continue to meet with clients, potential clients in my office all too regularly, who tell me the kinds of stories that I described, who tell me that they are beaten, who tell me that they will be beaten again, who tell me that they are threatened, that the police know them and come after them, that they up their charges. They're disgusting and horrible stories. But I have a very difficult time finding someone who can stand up, who doesn't have the risk of the police coming after them and doing something worse to them because they have stood up for justice. So the class action device gives me an opportunity to do that when I can find somebody who, for whatever reason, will be able to be less fearful. I was able to do that in the education context. I look forward to the day when I'm able to do that in the police context also. But I think the time is not dead for the use of the class action device in the civil rights context. Thank you.
like others, I want to thank Steve and Miriam for inviting me to this conference. I want to thank you for making me the last speaker on the last panel on a Friday afternoon, and particularly a panel with Victor Schwartz and Paul Bland and Catherine Lehman, all of whom have been wonderfully passionate and, in Victor's case, wonderfully amusing speakers. I don't think I can live up to that, but I'll try and live up to Bob's requirement of a very low bar for prognostication, and I am going to try and prognosticate. Discerning the future of class actions in the U.S. at this moment, I think, as is demonstrated by this really rich day, is very difficult. One problem that permeates all general conversations about class actions is that everybody is talking about different kinds of class actions. We saw this on this panel. We've heard this through the days. And in fact, both the past, present, and I would argue the future of mass personal injury cases, dubbed mass torts today, small value consumer claims cases, securities cases, antitrust cases, institutional reforms, so-called social impact cases, and the labor cases that we were reminded about earlier this afternoon, all present different kinds of challenges and different kinds of potential. So I'm going to try to give you a rapid view from, I guess, 30,000 miles up, touching on all these different kinds of cases. On the one hand, I think if we look to formal law, statutes, rules, case law, many of us would say, many people have said today, that class actions are an endangered species. The Private Securities Litigation Reform Act put large institutional investors in charge of class actions, ending what was at least perceived to be a frequent practice of racing to the courthouse with one's favorite class representative whenever there was a fall in stock value, and was, of course, intended by its backers to decrease the number of securities class actions, and for a while seemed to have done so. AmChem, which has also been much cited today, required heightened scrutiny of mass tort class actions, which some commentators argued made it impossible to bring certain types of mass litigations as class actions. The Class Action Fairness Act facilitated the removal of state law-based class actions to the federal courts, where it's clear that the legislation's supporters hoped the federal judges would refuse to certify them. Increasingly, class certification hearings, in federal courts at least, have been transformed into Daubert hearings with requirements for extensive evidence to demonstrate that the complaint meets the requirements for class certification, thereby raising the costs of the process for class counsel. A business-friendly Supreme Court has shielded key financial institutions from liability. Surprisingly to me, I guess I shouldn't be surprised by this court, but in a political and economic environment that has even some Bush appointees murmuring about a possible need for regulation. And the court has responded supportively, as we've also heard, to preemptive arguments, decisions that, while not limited to class actions, clearly have profound implications for them. And we've heard both on the last panel and this panel about arbitration provisions in consumer contracts that create or attempt to create a bar to class actions, although some states have disallowed these provisions, as we've also heard. I think a U.S. Supreme Court that has been enamored with arbitration in the last couple of decades and increasingly hostile to damage class actions may yet endorse those bars. And finally, in my litany at least, the recent spate of indictments against the former principals of Milberg Weiss, the powerhouse securities class action firm, and Richard Scruggs, the swashbuckling mass tort lawyer from Mississippi, the uncovering of fraudulent activities associated with silica litigation, with some, although hardly all, asbestos litigation, and the Fen-Phen class action settlement claiming process, what Ken Feinberg called the post-class administration phase. All of those allegations, and in some cases clear establishment of illegal or unethical behaviors, cast a pall over mass litigation generally and class actions in particular. Not a pretty picture. But if one looks at practice, I would argue one sees a different picture. The number of securities class actions actually increased last year. Through 2006, the last year for which I've seen data, the values of the settlements of securities class actions have actually also increased. Large institutional investors, apparently having been awakened to their interest by the PSLRA, seem to be increasingly opting out of class actions and pursuing individual litigation. This issue came up with Sean's talk. The effects on the remaining class actions are not clear, but logically this might mean that they are becoming again the domain of smaller parties, for better or for ill. AmChem did not end mass tort class actions. Post-AmChem, there have indeed been some mass tort class actions, and in any event, AmChem did not end mass tort litigation, because mass tort litigation, despite everything you've heard today, has never relied primarily on class actions for resolution. Asbestos litigation, which never depended on class actions, has decreased dramatically, but it's still chugging along, albeit increasingly in the bankruptcy courts. Class-like mass litigation continues with us, and we've heard about those cases today. According to careful analyses by the Federal Judicial Center, CAFA has dramatically shifted state-based consumer class actions to the federal courts, both in the form of removals and by encouraging original jurisdiction filings. But recent data from California show that at least in that state, the number of class actions, including those both removed and filed in federal courts and those that remain in state courts, is growing. Whether other states share California's experience is not known, but it seems unlikely to me that it's unique. CAFA, by the way, seems to have had no effect on mass tort class actions, which remain few and stable in number. The premise that federal judges will reject certification more often than state judges has yet to be investigated systematically, but it never rested on solid data. A RAND study published last year found that 15% of consumer class actions filed against insurance companies were certified. But we don't know how this number compares to the past because we don't have systematic data on the past, and indeed we have very little systematic data about class actions generally. The arbitration story, it seems to me, has yet to reach a conclusion. Pro-business U.S. Supreme Court interpretations of statutory law could, of course, be overturned by a Democratic Congress with the support of a Democratic president. And the pall over litigation created by the unethical behavior of some class action and mass tort lawyers remains, but outside of the Wall Street Journal's pages, the subprime mess and questionable practices of investment bankers and accountants are attracting more attention and growing litigation. So the death of class actions in the U.S., like the death of mass torts, may not be nigh. If a Democratic Congress can bestir itself to restore a sensible amount of regulation to the marketplace, we might see less of a need for litigation going forward. If judges can exert the authority they have to scrutinize proposed class action settlements and reject those that reward class counsel for deals that benefit themselves and defendants at the cost of class members, we might see more defensible class action outcomes. But barring a return to Republican control of both houses of Congress and the White House, an outcome that I'm not allowed by ACS policy to state a position on, I think class actions will be with us for a while in the U.S. Ironically, while efforts to restrain or eliminate class actions gained steam in the U.S. over the past decade, the opposite has been occurring in virtually every other part of the world. The resurgence of market capitalism and the erosion of public enforcement that has gone on around the world, in part under American leadership, have stimulated consumer advocates in Europe, Latin America, and Asia to argue for the adoption of some sort of representative litigation. Individually represented class actions, what folks outside the U.S. describe as American-style class actions, are now authorized in all but the smallest Canadian provinces, in the Federal Court of Australia and the Court of the State of Victoria in Australia, in Israel, Indonesia, Malaysia, Taiwan, Singapore, Norway, Sweden, and Chile, among others. In France, the election of President Sarkozy shelved proposals for la classe action, but approved groups and bring something called a conjoint action. In Germany, there is something called a model case proceeding. It looks to me like an MDL, but German colleagues tell me that it is in fact more like a class action. In Japan, there are mass joinder actions that similarly resemble class actions. In the Netherlands, class actions are authorized for settlement purposes only. Representative litigation by government-approved NGOs is authorized in Poland. In Portugal, individuals can seek court approval to represent a group of individuals with so-called homogeneous interest commonality. Denmark adopted an individually represented opt-in class action and then empowered a public ombudsman to bring opt-out class actions on behalf of consumers. Class action statutes are currently being debated in Austria and may become part of an ongoing civil justice reform debate in Belgium. Because we began this morning and much of the discussion today has focused on mass tort class actions, I want to underline that the driving force for class actions outside the U.S. is enforcement of consumer protection law, securities regulation, and antitrust regulation. Historically, representative litigation has been infrequent in jurisdictions that authorized it, that is, that had it on the books, in part because standing was limited to social associations and the remedies were limited to injunctive relief. So many of the countries I've mentioned had some kind of representative litigation on their books, but this mechanism was not being used, both if people in those countries argue, because of the limited remedies and limited standing. The new U.S.-style class actions provide for damages, which is expected to increase their attraction both to individuals and to consumer NGOs who also have the power to come forward and sue on behalf of consumers. With the exception of Canada and Australia, the new class action regimes are opt-in rather than opt-out. I would expect that this will make vast classes of the sort that we have sometimes seen in the U.S. unlikely. However, the availability of the Internet and the advent of social networking may moderate the effect of an opt-in rule. Imagine a YouTube video depicting an injurious product or a sleazy sales technique ricocheting around the net, played over and over by millions. How much harder can it be to opt into a class action than to friend someone you've never heard of before? Is there a class action island on Second Life yet? I keep meaning to check. I know there are lawyers now operating in Second Life. Today, class actions in many parts of the world remain hobbled by fee regimes that make it riskier for class representatives to come forward and less attractive for plaintiff counsel to represent them. Fee-shifting rules, requirements to post surety bonds against adverse costs, an absence of a fee doctrine that provides for cost-sharing among common fund beneficiaries, as has long been a feature of mass litigation in the states, prohibitions against contingent fees, and limits on risk premiums in fee contracts. But these barriers are beginning to fall. There's increased pressure in many jurisdictions, and already some jurisdictions have adopted so-called no-win, no-pay fees with risk premiums for prevailing plaintiff attorneys. Plaintiff class counsel have discovered in jurisdictions like Australia that have opt-out regimes that opt-in class actions can address the free rider program problem that exists where you don't have the kind of equitable fee doctrine that we have for common fund cases. And most importantly, third-party payers have emerged to invest in promising litigation for a share of damages. These are private and sometimes publicly traded for-profit companies. And their charging essentially contingent fees is a practice that is not only allowed in some jurisdictions, but to date virtually unregulated. Interestingly, if fee regimes are modified in many jurisdictions to facilitate class actions under pressure from consumer advocates, this could also, it seems to me, have significant effects on old-fashioned individual litigation. What's driving the new enthusiasm for class actions remains a matter of debate. My own view is that economically advanced democratic societies turn to private litigation when they come to believe they can no longer depend on public agencies to regulate the marketplace and protect them against shoddy products and shabby services. But it's also true that American class action lawyers are actively seeking partnerships with lawyers and clients outside the U.S. to represent in U.S. and foreign courts. Not surprisingly, the arrival of the Americans has lawyers elsewhere thinking, why can't we do this? And we heard, I guess, before the break about the dynamics in litigation involving large multinational companies as defendants and plaintiffs seeking themselves to see whether there isn't some way to create a kind of coordinated class action regime. So in sum, class actions remain alive, if not well, in the U.S., and they are morphing into new life forms around the world as we meet today. I think this film has many sequels to come. Thank you.
Thank you, Deborah, and I think you now know why I was so enthusiastic about the folks who would serve on this panel. Now, I'm going to start out our discussion with a very safe prediction that everything that could be said about class actions still has not been said. And I'm going to start by suggesting that Deborah ended with the note that class actions, despite all the impediments and the very sobering information that we heard today, particularly on this panel, remain alive, that they will continue into the future despite everything else. And I also read Victor's remarks as basically saying that there is no end to the inventiveness in keeping these alive by the subclass approach and things like that. So the first question I have, because there are clearly very substantial impediments to plaintiffs standing up and becoming class representatives, whether it's in civil rights cases or in tort cases, my first question is, despite Paul's pessimistic beliefs about the Supreme Court and maybe arbitration basically being the future of class action by eliminating it, do you see Deborah's comments essentially as accurate, that there will be class actions as long as there's litigation? And why don't we start with you, Victor, since it's been the longest since you've spoken. And you can also use this time to comment on anything else that you've heard.
Well, each person had his own or her own perspectives here, and I think...
And I would ask you to speak closer to the microphone because it is sometimes hard to hear.
Testing. All right. Earth 2. Okay. Each person had a different angle on this, and I thought that was educational to me because personal injury lawyer things are what I know about, and arbitration clauses would rarely affect that because it would be deemed unconscionable and it wouldn't be permitted. So in the area that I work in, which is PI and torts, I think it will survive, and I think Deborah is right. She is also, I thought, was helpful to us to know about things around the world because I hear about them constantly, and sometimes the remedies are more advanced than ours if you're looking from a plaintiff perspective. If you're looking from a plaintiff's perspective. In this regard, that in some countries you don't really need an injured plaintiff. In other words, the cases can be brought before somebody has actually been hurt. And we don't really have that in PI work in the United States. So I do think the escape valves will be pushed, even under CAFA. In Alabama, one of my clients was sued, and each class action had 99 plaintiffs because 100 is the limit on CAFA, so they boxed them that way. And I could give you other examples, but I don't want to educate some people here as to ways that they can escape various rules.
And I likewise think that the class action device will survive. And I think that the challenge to civil rights class actions has not been so much through erosion of the rule itself, but the erosion of the category of lawyers who can bring the cases and the ability to get attorney's fees, and so to make it viable to bring the cases. But even though that has happened, people who have as little remunerative savvy as I do still bring the cases, and so I think it'll still survive.
I think you already have my answer, so I'll pass on that question.
I think it's going to depend on the area. Well, first of all, I don't want to be heard to say that I feel sure the Supreme Court is going to rule that the Federal Arbitration Act preempts state law. I think that we have so clearly the better of the law in terms of better argument in terms of the language of the statute and its history. I think it would take an extremely cynical and results-oriented Supreme Court, and I would hope that that's not what we would see. But this is recorded, right? I think that it's absolutely true that tort cases where people don't have a contract will continue. Securities cases will continue because FINRA, the successor to the NASD, has a rule that says that they can't ban class actions in the arbitration clause. So they have all these arbitration clauses, but they have no bans on class actions and securities, which is very interesting because when the business community comes in the lending area and so forth, and they say, if we're not allowed to ban class actions, it will be the end of banking as we know it. Because prior to 1999, banking was a disaster. It was only after 1999 when we all adopted the bans on class actions that we started to finally make some money. The securities industry has no ban on class actions. They're just not allowed to. So there will be securities class actions. I think you will see them in the civil rights cases with governmental agencies or people like that where you don't have a contract. No one has a contract with a police officer who beats them kind of thing. The economic justice class actions are the ones that are at risk. In the employment setting and in the consumer setting, the things that are most likely to determine economic justice issues that go to a whole range of sort of corporate cheating that affects people in their homes and their livelihood. Those class actions, I think, are very much at risk. I think that just whether or not they exist at all is completely in play. I think that the idea that they could disappear is real. And I think that there are tons of people who just say, oh, they would never do something that crazy. Well, there are all these lawyers out there who did drug products liability cases who 3 years ago would have said the same thing, who are now, really trying to figure out Plan B on their lives. And I think that the same thing could happen in the economic justice area.
All right. One other question for the panel before I open it up to the audience. And this morning, during his keynote address, Ken Feinberg suggested that this panel ought to address the effect of technology. So assuming the survival of class actions, what does technology mean for how class actions are going to be handled in the future? And why don't we go in reverse order? So Paul, why don't you start?
The biggest, I am not a very technologically savvy person, as is endlessly pointed out by my teenage son, but the biggest thing that's happening right now is the battle about electronic data, emails and so forth. The federal rules were recently changed to make it easier, essentially, for companies to destroy electronic data. The experience I've had among consumer lawyers, which are not necessarily the most sophisticated bar of lawyers, frankly. I mean, I think that I think that you will find that securities lawyers, employment lawyers, frequently have an edge. But in the consumer area, it has been shocking to me how many consumer lawyers do not understand the changes in the electronic discovery rules and are involved in class actions where they need to be filing, like almost immediately after the case is filed, they need to file something that says, Judge, don't let them destroy any databases or documents. And all these consumer lawyers out there you meet at the conferences of NAC and consumer lawyers who aren't doing that. They don't even know about the rules. They sort of say, well, that wouldn't be allowed, and they don't even know. I mean, so I think that one of the things that's happening is that there are changes in technology and discovery that have led to rule changes that are extremely important that tons of lawyers have not picked up on in my specialty at all.
Excuse me. So I think the effects of technology are profound. I think that the research, which is mainly qualitative on the development of mass litigation, shows the importance of social networking. And when I used to talk about social networking and asbestos litigation, I talked about the fact that asbestos workers are unionized, they talk to each other, they learned what they had to do to both what they might have in terms of disease as a result of their exposure and how they could pursue claims. The spate of product defect litigation in the 80s and early 90s involving products that mainly affected women and women's health. Most of the people who've studied that litigation think that a contributing factor was the women's magazines and the efforts in the broadcast media to reach out to women. Well, now we've created an entirely new world, and we should not forget that that's a world that is a global world. There's a very interesting, to me, human rights abuse case brought ultimately in state courts in California against one of the big oil companies on behalf of people who were tortured and abused. I think the case I'm thinking of is an Indonesian case. The Indonesian villagers connected with their lawyers by going on the net and finding a lawyer in a public interest center to represent them. So the ability of people to connect with each other, people to connect with lawyers, lawyers to connect with potential clients, and lawyers to connect with lawyers is, I think, a major part of the story of civil litigation in the U.S. and around the world today. And to me, most of those factors seem to cut in the direction of more and more different kinds of litigation rather than less.
So I'm revealing myself as a Luddite in addition to a windmill tilter, but I don't see technology particularly affecting my practice. I am already ridiculously scrupulous about turning over everything that I have and requesting the same from opposing counsel and fighting to get that. So I don't think that I will get a new tool. I don't think I'll be hampered by the discovery rules, and I tend to meet with my clients in person, so it's not going to change my practice much.
Victor?
I think I'd ask Mr. Feinberg what he would think.
All right. Well, let's ask you what you want to ask about. So questions. Yes.
Hi. I appreciate the different perspectives that and I actually have a question about public perception of living. You guys talked a little bit about how, well, I think in all panels, talk about religious access perception. That's one concern. And then you talk about the perception of lawyers, of trial of plaintiff lawyers, in terms of the fees that they collect, in terms of indictment. Talk about that kind of category. And we also talked about class actions as a means for full corporation counsel. And so, I guess my question is, in light of all of those three sort of sets of concerns, what is the role of public opinion, public perception for the system? We talk about legislation like CAFA and the Arbitration Fairness Act. They're passed by Congress who are elected officials. So what's the role of the people? And do you think that there's an element of engagement that's been here that's playing a part in obstruction of that success? And that's kind of a big question. Maybe you can summarize.
Okay. Let's go first. Paul.
I think that there are many very grim perceptions that a lot of people in the public have of the plaintiff's bar. I think that a huge amount of it turns on labels. It is really interesting if whenever I am in a position to talk to a real person and get past the label of, oh, you're a trial lawyer, by which they mean, like a greedy, baby killer kind of thing. I mean, where they have these preconceptions. And I say, well, this is the kind of case that I bring. And I talk about a specific case. It's like AT&T collects a tax of $2.50 from everyone who lives in the state. But it turns out that only 15% of the people in the state live in the municipalities where they owe the tax. So for the other 85% of the people, they just keep the $2.50 every month. And so we think that's bad, and we think they should give it back. So yeah, I don't say I'm a trial lawyer. I say this is the kind of stuff I do. And if you can get past a label to the substance of it, I think that there is an enormous readiness in this country for people to see companies held accountable. I think that the reaction that people have to the subprime, what's happening in the subprime area, is similar to what happened with Enron. I think that there are a ton of people out there saying, no one is minding the store. And I think that if lawyers are able to set out the substance of what they do and keep away from labels, that will have a huge impact on how they're viewed.
If I could add, this is the sort of multidimensional issue that's very difficult to do good public opinion research on. So you can see surveys, and you probably have seen reports of polls where if the issue that you're asking people about is framed in a particular fashion, you will get very negative views. Trial lawyers, which has become a bad term, I think, as a result of lobbying to make it a bad term, and other descriptions of the litigation system that are framed in a way that point to self-interest and particularly focus on issues of attorney's fees do get, I think, you see, this is a bad thing. In the few instances that I'm aware of where there have actually been studies that try to probe deeper into public opinion in this country, what you see, in my opinion, is that people have a dual, and I think a nuanced and quite sophisticated picture of the system. On the one hand, they do think that there are people who bring frivolous lawsuits. They do think that there are lawyers who are just in litigation to make money, and somehow that's worse than being in any other area of the economy just to make money. But they also have these stories about, what they think was the bad product or the injured ant or the auto accident or the doctor malpractice. And they know people who had difficulty finding lawyers, and so when they start talking about contingent fee lawyers in that context, they tend to present it in a different way, and people are capable of connecting class actions to trying to level the playing field between consumers and large corporations. But, as people who have been writing about politics in recent years have said, framing is everything. And the community that has largely been opposed to class actions has, in my view, done a much better job of framing that debate than public interest lawyers, consumer lawyers, or other kinds of individual advocates.
Anyone else? That's a good question. Lawyers like Catherine or Paul are heroes, but the ordinary person doesn't see them that much. What they see is advertisements such as the advertisements that I see where I live. There is a casino in Charlestown that tells you you can win and come down there and you can get a car. And right after that, often there's an ad for some of the personal injury lawyers in the state. You may have $1 million lungs. That's an interesting ad. That's a real one. These type of advertisements, which are done by a portion of the personal injury bar, do more to assist those who may want to put some restraint on the system than anything that those who are trying to put some restraint on the system are doing. It hurts them a lot, and they're not. It hurts those who believe in good things. And those ads are really hit people's mind that this is not justice, but it's something like a lottery. That's not anything that the tort reformers are doing. It's done by the lawyers themselves. I think the stuff they get in the mail on class actions makes people think that the legal system is some kind of mumbo-jumbo that they don't understand. They get that thing in the mail, they can't read it, they don't understand it, and it diminishes their respect for the system. To the extent that true messages get out, that most personal injury lawyers do a good job, that all defendants are not horrible, that the legal system can serve people, that's a good message. But it's hard to get that message out in the current atmosphere.
Let me just add one more thing. I think your premise is correct, that popular sovereignty is not a part of this debate, that the general public is not part of the debate. They do not know what CAFA is. They couldn't care less about what it does. For the most part, they are unaware of the battle that's going on over tort cases between business and the trial bar. They are unaffected by it. They know that there are appeals to them occasionally, building on age-old antipathy towards lawyers that has nothing to do with anything modern any more than it does the fact that this has been a constant throughout history. And at the same time, there are incidents, whether it's anecdotes that are blown out of proportion or fractured in their presentation, that are used to try and shape enough of a public consciousness, not a real public consciousness, but enough to fuel the kind of political activity that we see that goes on. And I do think it is largely a disservice to the system that people do not grasp what is being discussed.
Talk about how these bad ads might actually be more benefit for what your rates are than you do. At the same time, in Ohio, we have elected judiciary, have elected Supreme Court, and the only time that the chamber went directly after and did try to raise the issues, did in a series of advertisements showing a lady justice picking up, I don't know naturally the blind justice ads where the lady justice picked up her blind.
Talking about the ad against Justice Resnick?
And backfired, and she overwhelmingly and so that was a time that the court tried to get the message out, and once people saw the message, it backfired. But then the corporate forum side did was merely quietly got those people elected for campaigns that didn't talk about the and got them elected through other means, talking about their patriotism or whatever. And now they're on the court, there's a 7-0 court in the same cases for 3 years later, and we're fighting over it, and we won this time. And so I guess the question is, do you feel that setting up an easy answer, but then explain it a little bit, that your argument actually does win over people? And on the reverse side, do you feel that a full narrative of the issue would move people from your side?
Well, I have the whole issue of the election of judges is probably for a separate day. For a long time, the plaintiffs' bar dominated that field. Now, businesses in it, and sometimes they've done things that I might not personally agree with. I think if the issues were aired in a good way with actual discussions and things that people watched, it would improve things. Right now, we have ad and counter ad and millions of dollars spent in these judicial elections, and that's got to be troublesome on either side. There's a judge who's on the Supreme Court of Ohio who's a very brilliant person. He's been there for a while, and he said something that chilled me. He was in one of the emerging countries, and he helped design their judicial system, emerging countries after the fall of the Soviet Union. And they asked him this question, Chief Judge Moyer, I'll say his name, what army enforces your judgments in America? And he said none. And the point he was making, I think, is when we believe that we know how a judge is going to decide a case before it's heard, we may need an army someday. And that's where some of the advertising troubles me in terms of electing a judge on either side, where you would know what his or her opinion is rendered before a decision.
I just want to say that first, I mean, that this issue is incredibly troubling, the way that money is coming into play in election of state court judges. The plaintiffs' bar is being outspent by a factor of, I don't know, 10 to 20 to 1 in most states. I want to give 3 very, very quick anecdotes. First is, Leif Cabraser, among a bunch of other firms, wins a jury verdict after a trial of 6-7 weeks, in which the jury finds liability and they win a verdict of over $1 billion. And the state Supreme Court takes the case. The Supreme Court's right on the knife's edge, and State Farm spends something like $500,000 on one of the candidates. And that candidate wins and casts a deciding vote and overturns the jury verdict. Okay, that bothers me. In West Virginia, a coal company with several cases in the West Virginia State Supreme Court, through a series of shells, undisclosed, through never using their name, spent several $1 million calling what was considered a liberal state Supreme Court justice essentially soft on child molestation, because there was a decision in which he had not even written the opinion, which was a 5-0 decision in which he had taken part. The guy was not soft on child molestation, but he got blown off the West Virginia Supreme Court and replaced. That really bothers me. We were actually approached on a case intake by somebody who wanted us a number of years ago in a state on election eve. Someone just elected to the state Supreme Court looked in the TV cameras and said, I want to thank the state's medical community for their support for me. They will see their investment pay off. And they wanted me to do a state bar attack to try and get the newly elected justice in the state Supreme Court disbarred. And we thought it over and decided, since we would lose, that we would sort of pass on that, because we really didn't think that the state bar committee was going to, disbar the state Supreme Court justice. But that really bothered me. And the way that it's not just advertising, but the way money is going to state judicial elections in this country it's an unbelievable shame and travesty, and it's an outrage calling for attention.
Last question.
As we think it is, folks, decided not to wait and publicize some titles. You don't have to win every case. You don't have to get the decision to go your way every time. When we're talking about the courts or a baseball game, but to stand mute in the face of this outrage, I think it's terrible. Another thing, I don't know why the Lake law has allowed the other side to talk about what reform is a nice word. Why don't you tell the world what they mean by reform? They mean to take the nice word. I think that $1,000.
Okay, I agree that we've done a lousy job of framing the issues, and we could be a lot stronger in that, and I like to refer to it as attacks on the civil justice system rather than tort reform. I just want to say in my defense on the state Supreme Court justice, it was reported widely in the newspapers in the state, so it's not like it was a secret. And besides, if we'd brought an attack on this person in the state ethics committee, those proceedings are all secret. Ethics proceedings are all done in camera and so forth. So, we have a very small staff of people, although we'd be welcome, people who want to donate money to us to let us grow our staff. But we have a very small staff, and we get, I get probably 30 calls a week from people who want me to take a case, and I really do look at whether or not I think there's any chance of winning a case. I don't take a case that I feel like, boy, this is really outrageous, I'm going to try and publicize this by taking a case that I know is going to lose. Now, people disagree about this. Ralph Nader is endlessly saying, it doesn't matter if you win or lose, go ahead and take these cases you lose, just get out there and get in the newspapers, and that'll change the world. And it's like, Ralph created another organization that does that, but that's not what we do. We take cases where we think that there's a chance. And we take cases that are really long shots. We lose a lot of cases that are difficult. It's not like we sit there and say, oh, wait, we're only going to wait for the slam dunk to roll in, but yeah, a case that's a 0% chance, I don't feel bad about not taking it.
I want to defend the plaintiffs' bar. I think they're doing a great job. They spend more money than I will ever see, and in fact, their new thing, which nobody publicizes, but most of the time when they had political power, the plaintiffs' bar basically tried to stop tort reform. But now, sir, and I won't have the time to show them all, but if you go to the actual website, you can see it. moving legislation to expand rights to sue. And it's amazing. It's going on in Congress. I love it because it's giving me full-time employment. I have to run around and find these things. They hide them like a piece of matzah on Passover to find them. And then when I find them, I have to expose them. They're doing a terrific job. And I think the plaintiffs' bar deserves a round of applause for the type of job that they are doing. Never understate them.
All right. Before I invite Steve Feynman up to give us our final instructions here, please, this panel did a terrific job, and if you join me in thanking them.
Just want to thank you all for coming. I think it was a great conference. Appreciate your participation. If you want CLE credit, you need to sign before you leave. Is that right? And there's a reception outside right now, so please join us outside. Thank you very much for all your work.